that email. But do you receive emails from the superintendent questioning some payments that are made ever?
No, generally we have conversations.
So you don't email?
Not
Well, let's talk about your conversations then. If you get a conversation from Dr. Eisen now about a payment, you say yes or no. Do you, and he questions the payment and you get either a thumbs up or a go ahead or I have no questions, do you still write the check?
Yes.
Okay. So if Patrick Dubbs, the superintendent at the time that Ron James was involved, in Exhibit K there, you have that in front of you?
Yes.
Ask a question and you as the treasurer provide that response and you were to get a thumbs up sign from your boss, you'd be okay to write that check, correct?
But,
Yes?
Yeah. Well, the superintendent's not my boss, but
I'm
yes.
sorry, I could not
Then
hear
here you
that.
go.
This-
Hang on. I only have one person talking at a time because Ms. Sue here is trying to take everything down, okay? All right, you can answer the question.
Yes.
You would write that check.
Yes.
Exhibit L, if you got a similar question from your boss, and then you ask the question, if you have objections, please immediately let me know. And you got response none, you would feel comfortable writing that check, agreed?
Yes.
Mr. Hardman handed you Exhibit 1, that we went through all those checks. And Exhibit 1C specifically, which is the actual purchase order. Yes, you have that in front of you?
I do.
Okay. Now, there are two signatures, and they are electronic signatures, right?
Correct.
You have no knowledge that Patrick Dubbs did not hit enter and put his signature on this purchase order, do you?
This not on the document history from the software that he clicked anything to approve it.
You don't have this approval?
No.
Okay.
Did he have to do something specific to approve each check?
The purchaser, the superintendent would approve the purchase order, not the check.
So the superintendent does have to go on and put his stamp on, meaning Ron James can't put Patrick Dubbs' stamp on that purchase order.
No, the software prints it directly.
Ron James can't hit Patrick Dubbs' signature, can he?
That's not how it works.
Ron James can hit Ron James' signature, right?
And he can click to have this signed and approved, and both signatures are printed.
And Patrick Dubbs has to hit click, enter, and his signature gets approved, correct?
No,
Why not?
Mr. Dubbs doesn't have to click. In this workflow, he did not click anything to have his signature applied. That was applied through the approval process of the software, which was only the treasurer's approval.
Was that process followed in this?
The previous, the interim treasurer changed the process with SCView when he learned that the superintendent was not actually logging in and approving the purchase orders when he came on board.
Okay.
Did you speak with anyone at the auditor's office in your process?
Yes,
Did you provide emails from anyone at the school to the auditor's office?
yes.
Did you provide the emails that I just provided you to the auditor's office?
It likely was in the batch. I didn't read through all of them myself.
Okay. No further questions.
Thank you. Mr. Smith?
State's Attorney. Earlier, you pleaded guilty to the third-degree felony of unlawful possession of a firearm by a previous convicted felon. And hold on. And the agreement was whatever sentence shall not exceed a cap of 8 years in prison. So we are looking here, if the court decides to sentence you to prison, you are looking at no less than 2 nor more than 8 years confinement in prison. You could be sentenced to no less than 2 nor more than 8 years confinement in prison And then that could be suspended and you could be placed on regular probation for up to 10 years. You can also be placed on deferred or unadjudicated probation. I think those are the three options available.
Yes, Your Honor.
And have the parties had an opportunity to review the pre-sentence report? And are there any corrections or changes to it? State.
We reviewed it and we have none, Judge.
And defense.
No, I don't have any, Your Honor.
All right, then.
I have two brief witnesses, his mom and his dad, Judge. If you don't mind, can you please come?
Hold on. And then we had a report earlier prepared by Dr. Edgar Pond of the court's insistence that the defendant be analyzed for competency and insanity. And that report had been received on September 11th, 2024, which states the defendant is competent, stand trial, and is not suffering from a mental illness that would make him ruled insane and unable to stand trial. Any objections to us calling this court's exhibit number 1 on this date and putting it into admission in this court for all purposes for sentencing?
None, Your Honor.
No, Your Honor.
All right, then it will be made a part of the record for all purposes. Okay, we're calling it court's exhibit number 1. It is made a part of the record for all purposes without objection.
No objection.
All right. State, would you like to go first? Or do you want to defer till later?
Let's defer, Judge. I
Okay.
understand he's got some live witnesses.
All right, defense may go forward. Thank you.
All right.
One at a time.
That's fine.
Yeah, we don't do it as a group.
No problem. I can.
That's why we only have one chair in the witness stand over there.
All right. Would you state your full name for the records?
My name is Terry Eugene Burks.
That's who you're calling, Terry Eugene Burks.
Terry
Okay,
Burks.
the witness has introduced himself as Terry Eugene Burks. And raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Okay, you may lower your hand. Go ahead.
And to my right and your right, that's your son, right?
That's correct.
And he
Who is?
Chadston Wayne Bryson.
We have to do it for the record. So the court reporter's notes show exactly who you were referring to.
And just briefly, tell us about yourself and how you employ.
My name is Terry Eugene Burks. I'm 51 years of age. I reside in the city of Beaumont, Texas. I've been here for a little bit better than 19 years. My wife and I have been married 19 and a half years. And I presently work at a company called Henneth Transportation LLC as a hazmat chemical driver.
All right. And you understand that your son, Chadston Bryson, is charged with unlawful possession of a firearm by a felon. We got a chance to look at the pre-sentence investigative report, right?
Yes.
And you understand that the court has a cap of 8 years, meaning that judge just said you can go as low as deferred probation, straight probation, or as high as 8 years in jail, right?
I understand.
So with that being said, and you're also familiar with Dr. Rapon's report, this was when we had him evaluated for psychological conditions, right?
Yes.
So what I want you to do is I don't want to feed you with what to say or not to say, put words in your mouth. Directly talk to the judge and ask him why do you want him to have probation, deferred probation in this case?
Thank you. Again, thank you, Judge Stevens, for allowing me to address the court.
Yes, sir. Go ahead. Thank you.
Again, I'm Chad's stepfather. I've been in this life ever since he was 6 years of age. And so for approximately 20 plus years. And the first part of our relationship was a beautiful relationship, teaching him how to tie a tie, even ride a bike and so many other things, our fishing trips and stuff. But as time progressed, the neighborhood that we lived in, he got hooked up with the wrong crowd and ended up gravitating to a lifestyle that wasn't conducive of the household that we tried to project. We come out of a Christian home. And so things began to spiral down for Chad and for our family. He began to get in trouble and we had problems with him at school. But one thing that I promised myself, and I married his mother, I also married him. I said that even though I grew up in a home without a father, I said that I would never, ever forsake my family. I would never, ever give up on the family that the Lord blessed me with. And so I've always been there for him. I've always tried to love him as a father. I've never looked at him as my stepson. And whenever I would meet people out in the public and they would say, "Is that your son?" I would say, "Yes, that's my son." And I've always loved him. And I'm not going to sit up here and say that Chad is not without fault. We've always tried to hold his foot to the fire. We've always tried to hold him accountable for his actions. I never made excuses for the things that he has done or the activity that has led us here today. I've always been one, as the saying goes, that drove with tough love. And we have rules in our house, and Chad knows that if you can't abide by these rules, then you can't stay at this house. Home is what home has always been, and Chad is always welcome to come home. And as long as he's home with us, he does right. You know, we tell him what to do. We take him to the places that he needs to go. I've even started trying to teach him how to drive when he was with us, you know, so that he could get out and become a civilized individual, be productive in society. And I believe that that's still in him. I believe that there's some good that's still left in him. He just needs to have that robust supervision, that oversight that will keep him grounded. His mother and I have already pledged our love for him and our support for him. We have a structured home. We have reliable transportation. We have a big family, and all of our family have pledged their support to help us and help Chad in any way possible to become successful in life and to turn the direct trajectory of his life around and begin to be the father for his son that he needs to be, to have that respect given back to him that he has to earn. And I believe that if he's afforded that opportunity this time around, I believe that what's been the norm for his life up to this point will begin to take a 180 turn, and he'll be able to become that person that he needs to be in life. And we're going to help him become that person if Your Honor in this court sees a possibility for him to be placed on supervision.
Okay. Any questions from the state?
A few, if I may, Judge.
Go ahead.
So, Mr. Burke, you and I visited before the plea last time, didn't we?
Yes,
Shortly.
Yes, sir.
So I want to be frank with you and ask you a couple of questions.
Yes.
When I read through your stepson's report here, his problems have been existing all the way from when he was a juvenile. He was running away from home. He even got his extensive trouble is being in possession of some drugs within a drug-free zone. So, I mean, we're already having problems when he was a juvenile.
That's correct.
And right when he turned 17, he ends up with a felony offense that gets him a 5-year sentence.
That's correct.
Right. So you were in his life. When did he get out of TDC? From that 5-year sentence that he got on the burglary habitation?
I want to say that he got out in 2020.
So anywhere between 2020 and 2022, right?
Yes, sir.
And you don't remember that yourself today, right? But the same The same thing that you're telling the judge, the family and the structure, you and your wife have been there for him through that time frame, haven't you?
Correct.
Right, so I'm going to tell you, I'm concerned with that. And the other thing I'm concerned with is that after he gets out of prison, he ends up committing multiple offenses in 2022 that I was a stepfather too. It's just shameful to even see this on a piece of paper. He was convicted twice of family violence. That's not something you taught us.
What was that?
Yes, it is.
What was it?
His mother of his child. They were trying to live together, and I'm assuming they got into an altercation, an argument of some kind, and which resulted the authorities coming. And I'm not sure all that played into that, but he wasn't living with us in our home at this particular time.
When was the last time he lived with you and your wife?
With us? I know that he came right after he got out of prison the first time. He paroled to our home. And
We know he was convicted in 2016.
and that's in
5 years
2020.
in prison, so he gets out in about 20.
Yes, sir. We picked him up from the Clemens unit there in Brazoria County.
You know, he was given probation for those misdemeanor offenses, but he didn't complete that. He got revoked.
Right.
Is there anything you can tell the judge that can exist differently about this probation that you're asking for to try to turn this young man around?
And just before you answer that, what concerns me is, all of us make mistakes. All of us make mistakes. Welcome to humanity. We're all in it. But it's how you deal with your mistakes is the real test of character.
Right.
And
Yes, I'm
the
sorry.
defendant goes to prison after some problems as a juvenile that apparently in 2014 did not work out for the extended period of time, because he gets arrested, a date of offense for these two burglaries in 2016. He gets imprisoned, and in 2016 he is 17 years of age.
Right at 17, yes, sir.
And he just turned 17, which so right into being responsible as an adult in 17.
Yes, sir.
Stuff. He goes and commits burglaries of homes, which if he was shot by the homeowner would, of course, that's an absolute defense. And that's why those laws are so strict. And it's dangerous to be burglarizing somebody's home.
Absolutely.
Anyway, but he gets 2 convictions, so he serves a 5-year sentence and he's released. And then thereafter, he goes to live with y'all.
Yes, sir. He paroles to our home.
But he's in March of 22, he picks up family assault and also a violation of a bond or protective order. So that's a law. Family assault, that's another criminal law. And then a violation of a bond or protective order, which is a court's order that you're asking for probation here, and he would be on court orders. But he's proven that he can't follow court orders in the past. And so he was revoked and sentenced to confinement on those 2 matters. Thereafter, in fact, before that, he commits escape, and I'm not really clear about what happened on that, but he was convicted of that and sentenced to confinement, looks like jail confinement for that misdemeanor. So he's picked up 1, 2, 3, 4, 5. On 5 crimes, 5 misdemeanors, he was convicted, including assault, family violence, assault, 2 assaults of family violence, among other things. Then 2 felony convictions of burglaries of a habitation. But it was after he got out and was living with y'all that he picks up those 22 assaults and violates his bond, escape, while he's kind of under y'all's more supervision. So we know that the previous supervision with you, as well intended as you are describing it, you can't live his life. It's his choices and your choices. You seem to be articulating that you're a good choice maker. And why your stepson has not, is that right? It's your stepson, not your, his mother, you're married. But nonetheless, you came into the family, so you're a role model. I presume his actual father is not much in his life.
Right.
Okay, so you sound to be a good role model, and the question is, what's your problem? Who can you blame but you? But you have you may have had a role model in your family before that failed. Your natural father, I don't know, but it sounds like that he didn't make good choices as a parent. But you knew better. You know that's not right, so you rebel on that. But you've got a good father figure now. You hadn't had one for 2004, since 2004. So why would you make poor choices when you've got a good example? And you also know that when you make bad choices, you get your hands spanked like we all do. We get punished. Why would you want to get punished again? You know it has consequences. And so we're talking about violations of law here. Just as an adult, 1, 2, 3, 4, 5, 6, 7. 2 of those are felonies. The others are misdemeanors. And I'm not even counting the juvenile problems that you have, which amount to now adding over 10 criminal matters that you were held responsible for and punished for separately. So why is it that you should get a 12th second chance?
Commissioner Street.
Go ahead.
The time I sat in there, I had time to really reflect on my life. And it's not the life I want to live anymore. It's getting old to me. And parents I got that love me, they love me, And I shouldn't hurt them. In order to love them the way I should love them or the way they love me, I should love myself enough not to hurt them by coming to jail, doing drugs, hanging around the wrong crowd. I also got a son now that loves me. And, in order to love him back, I have to love myself. And I'm going to start by having some self-love and walking down the
How old
right
is
path.
as your child?
3. He's going to be 3. It's going to be 3 in August. And
What is his date of birth?
August 18th, 2022.
Okay. So the lady was pregnant with your child 9 months before that, I guess, the first of 2022. And yet you knew that, right? You knew she was pregnant. So you're charged, you then, after learning that news, being a responsible person now, as a father figure, a role model, you committed 5 crimes there within a few months after learning that. So how is it that a child in your life made a difference, is going to make a good difference when you went out and went on a crime spree, knowing that you had another life that you were responsible for other than yourself?
I was still kind of young-minded. I was still finding myself young. But now that I feel like I have found myself. I feel like I truly have found myself now. I'm not getting any younger. My son isn't getting any younger.
How long have you been in jail now?
I've been in jail for a year now.
How's that working out? Families together, unit? No, it's not when you are in jail. Unless they're in jail with you. Okay,
Right.
okay, I understand.
And then, Judge, I had this whatever.
All right. Thank you, sir.
All right.
Raise your right hand, ma'am. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Okay, go ahead with introducing this lady. Thank you.
All right, would you state your full name for the record and tell us briefly about yourself?
My name is Sandra Nicole Burks. I'm 49 years old. I have 3 children, 2 girls, and Chad, and then I have grandson, Charlie.
And are you employed?
I am, we'll be working at Baptist Hospital on the 27th. I was working for Dr. Albert for Albert. But I'm on my 2-week notice thing, so I'll get back.
So basically what you have here is husband, wife, middle class family, pretty much middle class jobs. And you heard one of the major questions of the judge is that, hey, your son has all of these situations where he's becoming involved in law enforcement, whether it is the family violence. The judge mentioned about going to the prison in his adult history. Let's get straight to the point, all right? He's hit the wall several times, right?
Yes.
And judge is asking a good question. Okay, well, hey, he hit so many times. Why should I give him a chance today, looking at what has happened in the past? Do you follow his argument, right? Line of thinking.
Yes.
All right. So what I want you to do is to answer him directly on that question, which is considering all that has happened in the past. Why should we give him that deferred adjudication shot today? And you can answer him however you want to answer him. You can look at him and tell him what you think. Go ahead.
Okay, yes, all of these things happened with Chad when he was real young. He was very young-minded. He actually started doing drugs in the 6th grade. It's when they, he said he was having a bad time, a bad day, and one of the kids told him, hey, I got something to help you. And ever since then, we've been trying to help him, ever since he was in the 6th grade. Now, I do believe that he has learned his lesson. I do believe that he was very young when all these things was happening to him, having had time to really think about his life.
Why do you think he's learned his lesson?
Well, I guess.
Because really the only thing different is he's been in jail. He's been in custody. Nobody likes that. So they're going to say anything to get out. Oh, okay. I don't like this. This is punishment. I don't like this. Only sociopathic people enjoy being punished. So he's not mentally ill that way. So it's just natural for him to say, I'm tired of here. This is punishment. I don't want to be here anymore. Let me out. That's just normal. But what is it that we can say that's specific that is different in his life that would reflect success?
Yes.
Because he's got an environment that has success as a potential. He just didn't care to choose that, and then committed all these offenses and mistakes. What did we say, 11 times? Well, yeah. 12. My goodness.
Well, I believe that, we have more of us, like back then, just me and my husband mostly, we have more family involved, that they expect they would help us and help with him, and getting himself together. And I just chose to believe that he's going to change this time.
What's different about the role modeling in the family than before? By the role modelers, what's different? I don't see anything different. It's just him that's different. He just does not accept or decide to take part in the family unit as a responsible person. And he had role modeling in the household. So it's your fault and your choice. Everybody else is rowing the boat. You want to ski. Roll fast so I can ski. I just want to avoid committing crimes. Y'all do all the heavy lifting. That's not fair. Would you agree? Go on.
Well, we do have our pastor involved with it. And
I'm sorry.
We have our pastor involved as well.
What's he doing? Or she?
He.
Who's your pastor?
Pastor Gary P. too.
Okay. Well, what would that man do?
Well, excuse me. Yeah, he would come to the house, talk with him, and will help us with him trying to get jobs together Just really consoling with him and spending time with him and trying to get him on the right path like we are.
At the end of the day, all of these things sound great, but at the end of the day, it boils down to one thing. It's your choices that are legal,
Right.
not the pastor, not your mom, not your stepfather, not the attorney, not all of these other people who are trying to help you, that you're rebelling against yourself on, working
Right.
against yourself. It's all boils to you. And you've made a series of bad choices up to now. Series. And then now there's nothing that's been changed. You've had more than your fair opportunity to make the right choices. But you do. And you stick your hand on the hot stove, it's going to burn you. But you're now embracing the stove. You're just not touching it. You're grabbing and hugging it. Because it's like, I enjoy being burned. No, who does that? Nobody likes that. But that's the way it looks in this thick document. Okay. All right, I think I know where we stand. Anybody else has anything else to say?
No questions of her, Your Honor.
Anything else you would like to say, sir? Thank you, ma'am.
My name is Second Small. I feel like I really have. I know it may seem like just because I'm in a bind that.
Yeah, everybody's going to say you're going to try to tell me something that I want to hear because you're in a bind. The thing that bothers me is you've had far more chances than the average person in this, as a defendant in this court, to make the right choice, and you have failed miserably up to now. So there's nothing that's really changed except you're getting tired of being in jail. That doesn't help me in making a decision that takes you out of confinement, because the community is a lot safer with you in jail. It's been proven now. When you get out, you go and commit crimes.
I like to be around.
What's different about it other than, are you saying you're finally maturing?
I am,
Okay.
I'm finally maturing, and it took a while, but I'm finally maturing. And I promise this is the last time. This is the last time I can ever go through this. Last time.
Well, the last time should have been several,
I understand.
11 times ago.
I understand this.
Anything else?
Just
Yeah.
one of the biggest things is the probation department, at least from one of the things I read in the report, where they said defendant's positive attributes suggest potential for
Successful probation if adequately supported.
And I think the adequate part, which is the condition of the statement, is I think we've demonstrated the adequate support side in the sense of he got middle class parents.
I know, but he's had that adequate support available for him several bad mistakes ago. They've been available in the household, and yet he still rebelled in his decision making. Right? Wouldn't you say? I mean, the man's been in the house since 2004 as a role model.
I think one thing that Dad brought out was like the girlfriend incident. He had moved out of the house, but I think if you give him probation, they're going to keep him in the house. And with him in the house, that adequate support will be there. He won't be out of the house. Yeah, actually live with him, right? Because he's going to live with y'all, right? Correct. And I think under their roof versus being outside of their roof, it'll be a tremendous difference in his behavior and adaptation to
All right.
society.
If nothing further, the court has taken all that into account, and in reviewing the pre-sentence report that's been made a part of the record, does any of the attorneys wish to add anything else? I think I know your thoughts on it.
Yes, sir. Go ahead.
If nothing further, I'm going to find that earlier in this case, the defendant had pleaded guilty to the third-degree felony of unlawful possession of a firearm by a previously been convicted as a felon. And he did that voluntarily, knowingly, intelligently. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. That's another felony conviction. I am following this agreement, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. You will be given credit for all time you have served in accordance with this charge. Do you understand what has happened here today, sir?
Yes, Your Honor.
Oh, all right. You will be given credit for all time you served. Anything else you want to say?
No, Your Honor.
And nothing else? How'd that sink in with you? Like something fell on you?
It's all right.
Like a car falls on you?
Hurts a little bit. It does hurt.
All right. The court is going to further suspend the sentence. You will be placed on 10 years probation.
Thank you, Your Honor.
There will be terms and conditions of probation. Number one, you will be required to undergo a comprehensive mental health evaluation by a licensed psychiatrist. And maybe Dr. Rapon has fulfilled that in his September 11th report in determination of competency. But we want to make sure that you don't have an excuse for any failures. You will be subject to a substance abuse evaluation, and you will enroll in and complete any substance abuse treatment program that the probation office deems is appropriate.
Yes, Your Honor.
You will complete some cognitive intervention programs that are available for such offenders, including the moral reclamation therapy program, which helps you make better choices than you've been making. You will be required to complete your education, your high school equivalency, and any further vocational training that helps you become a responsible person to yourself and to your family. You will be ordered to refrain from possessing or accessing firearms, other weapons, any illegal drugs that have not been properly dispensed and diagnosed as something you should take for your assistance by a licensed medical physician.
Yes, Your Honor.
You will perform 600 hours of community service, and you will be on high intensive reporting plans that the probation office will monitor and control. Here's the other thing. One failure away, one mistake. And everybody makes mistakes, but I'm talking about from these any knowing or intentional failures to follow these conditions, which are strict, will result in you coming back here real quickly. And I don't know what else you could say. It's not going to be anybody else's fault but yours.
Right.
Unless it's somebody else's fault that made you do it, which seldom happens. But if it is, we'll take that into account. Otherwise, if it's your decision, you've been on notice that you are on thin ice, and 8 years in prison is where it will end up if you fail to follow these terms and conditions of probation. But I know what Judge went over all of these one time before, and you failed. But you understand what the court has tried to convey to you today, that failure is not an option for you
Yes, Your Honor.
anymore. I don't see a problem.
I didn't hear one.
Now, the probation office, which has a 90+% success rate for probationers, is going to review all of this with you here in a little bit, make sure You understand everything. Because if you're back here, you're going to have a hard time explaining your way out of failures at this point in what we have done in addressing your actions. Also, one other thing you need to be concerned about. This is your second successive felony conviction. You know what happens on your third one? 25 for life. You can't get probation. You have to be able to serve less than 10 years or less to be even suspended and probated. So you can't get regular probation next time. Here, I've signed those probation orders, and I think we've done all we could to get you to a point of it's in your hands. The responsibility is yours. Follow through 100%. Okay, and the probation office will keep me updated on your progress, which I hope it is. All right. Anything else? That is all, Langston. Thank you.
Thank you, Honor.
Yes.
Thank you. Something next is a free office on recent application.
Are you ready on that?
Yes. Stephen Lane. And that is, I'm gonna resend. It's all.
And also for the record, the court is going to note that Mr. Bryson's mother and stepfather submitted written documents on called character letters on his behalf that are made a part of the record for this sentencing hearing. Okay, tell me when Stephen Thompson is ready. Thank you. Omar Gooden. Ready?
Yes, I think they're signing the paperwork, the prosecutor.
Do what?
I think the prosecutor's signing the paperwork.
Okay, so we ready otherwise?
Yes.
And we'll bring Omar Gooden, please. Thanks.
I'll need to swear him in once he finds out.
Yeah, very good. Some. Very long, actually.
Do we need him over, Omar Gooden, for any reason?
Oh, Marvin, yes.
Here's Omar Gooden.
Yes, just go
Is
Marvin.
that you, Mr. Gooden? Okay, you need to come in front of that lady to swear in. Thank you.
Wait, wait. Swear or first, tell the truth, all the truth, and then the more stuff you got. Get your right thumb. Place it flat right down. Okay, one more time. This one.
Is the date on this one today?
Yeah, I'm signing it, Judge.
Okay. All right, so
This is a plea on the lesser included misdemeanor A evading, Judge.
is that you?
That's
That's what happens when somebody, my prosecutor says they're reducing something to a misdemeanor.
It was a musical theme. It sounded like, uh-oh.
Yeah, it's an uh-oh, it's an uh-oh.
Mr. Laird doesn't know how to turn the volume off on his computer.
Oh, it's going to be a lesser to what charge?
Class A evading. Yeah, it doesn't have my
There it
name.
is. Um, Okay, so section 38.04 of the Texas Penal Code, evading arrest or detention, subpart A. A person commits an offense if he intentionally flees from a person he knows is a peace officer attempting lawfully to arrest or detain him. This is a class A misdemeanor, except it is a felony if previously convicted or if the defendant uses a vehicle. So there's. Does the defendant who's here with, and you are Omar Rashard Gooden?
Yes, sir.
Present with Ms. Holmes, Brittany Holmes, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment can be proceeded cited?
Yes, Your Honor.
In summary, this indictment alleges, sir, that on or about September 21st, 2024 in Jefferson County, Texas, it is alleged you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with in that case?
Yes, sir.
Right. It was filed as a third-degree felony because it goes on to allege that you intentionally fled from a person you knew was a peace officer trying to lawfully arrest you. There is an agreement that's been reached by the parties where you would be pleading to the lesser included Class A misdemeanor of evading arrest or detention, dropping off the use of a motor vehicle part, which means you face up to 1 year in the county jail and or a fine not to exceed $4,000. Do you understand?
Yes, sir.
That is right. It's and or, correct?
Yes, sir.
And that's not in here. It's just- and and or.
Ms. Holmes wrote that part, Judge.
An agreement has been reached.
That's only enough to get
There are worse things. Far worse. The agreement's been reached that
Yeah.
you would be placed on deferred or unadjudicated probation. And the non-binding recommendation is for probation of a period of 1 year. You can be placed on probation for up to 2 years. Do you understand?
Yes, sir.
And I'm going to jump to I'm going to follow this, but you're going to be on probation for 2 years. You are charged with a third-degree felony originally here. You have a prior first-degree aggravated robbery, which is nonsensical. That's a violent crime out of Gregg County, and you have been put on notice that mistakes have consequences. So if you're going to be placed on probation on this court watch, you're going to be on the full term of probation so that we can be convinced that you've learned your lesson, even though you should have learned it back after you got out of custody on this ag robbery. Okay, do you understand the plan? And is that your understanding?
Yes, sir.
If I followed this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this lesser included Class A misdemeanor of evading arrest, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes,
Do you
sir.
understand it? Discuss it with your attorney. Were the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you're charged with. You've reviewed this thoroughly with your defense attorney. You are guilty of this crime and any lesser included offenses, such as the one the court has proceeded on, and you've entered a plea on, the lesser included Class A misdemeanor of evading arrest. You were given up your rights to a jury trial and the rights to the right to the confrontation and cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God, in States Exhibit 1. It is made a part of the record for all purposes. Pre-sentence reports, right?
Yes, sir.
So much.
All right, if nothing further, I'm going to find, sir, you pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to follow this plea agreement, place you on deferred or unadjudicated probation for 2 years. You must follow these terms and conditions of probation, which are normally customary for this type of offense, which will include a defensive driving or some type of responsible driving class that we all used to take when we were in high school and driver's ed. But the important thing is you've been through this. You know it has consequences. This is nothing more than a 4,000-pound missile. We have too many cases here in this court where people are irresponsible and people have died.
Yes, sir.
And everybody weeps and cries, but you can't take the life back.
Yes, sir.
You can't undo the harm and place to not only yourself, but to the others and the law enforcement officer who is doing his sworn duty to try to ensure safety. Because we got to use the motor vehicles and the roads responsibly for each other. You sound as though you quit caring about everybody else, and you certainly don't seem to care about yourself with your criminal history. You've got to fix that, or have you?
Yes, sir. I have.
Well, talk is cheap. You got to act it out responsibly in decision making. Are you going to do that?
Yes, sir.
Okay. You know what happens if you don't? Your
Yes, sir.
probation can be revoked. And Miss Holmes did all she could for you.
Yes, sir.
She's run out of fastballs to throw. It's going to be a soft, slow pitch that I'm going to hit out of the park next time.
Yes, sir.
If you're in this court and you do something that is proven irresponsibly, illegally while on probation, don't flirt with that. Okay. All right. You know. See the probation officer. Next, who do I have now?
He's ready on.
Stephen Thompson?
Yes, sir.
He's in front of me.
He needs to come in front of us.
And we sent it to you.
And right, Kashawn Washington?
Yes, sir, probation.
Yeah. Well, and then I have David Tovar.
Yes.
Your right thumb print?
Are you representing Mr. Tovar?
Place it flat.
It said pro se, but
You can have one more time?
you're always invited.
I'm why
Place it flat.
how that ended up like that.
Okay,
He
that's
mentioned
okay.
it in court one time, Judge, and we switched it and so
Okay.
we'll get it all worked out.
All right, again, please tell us your full name, sir.
Stephen Wayne Thompson.
And you were here. With Mr. Adams, your attorney and the state's attorney. In 23-4-1304, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about November 11th, 2022 in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face no less than 180 days, up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be, let me get to that page. Pleading guilty and found guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for up to 5 years. There would be terms and conditions of probation, normal and customary for this type of crime. And restitution is going to be owed in the amount of $1,500 to the complainant in this case as listed in this indictment. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
That Langston was writing real fast. He missed the boxes. That's what he does when he's trying to do a lot of things at one time and he's working as hard as he can. But we'll fix it. Look, this restitution is always important. Victims, there's a victim here. So what are you going to do about paying this back?
I'm going to pay it.
Okay, fine. When, how, and where?
I'm going to start working the day I get out.
Do you have something lined up?
Yes, sir.
What?
Dragon.
Say that again.
Dragon. That's a fab shop. Dragon. We saw dragons.
Okay. Dragon Industries?
Yes, sir.
Like the non-existent animal, the dragon. Yeah. Who owns that?
That's a big company. A friend of mine works there. He said he can get me a job. He's a foreman. He said he
Yeah,
can get a
I know
job.
who owns it. I was just curious if you know. But they're very nice people. They're a great asset to this area.
Okay.
And they take care of their workers as long as you act responsibly on their behalf as an employee.
Yes, sir.
Because they have a good reputation. All right. How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily
Yes, sir.
and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection.
No objection.
It's admitted. Among other things, the state you are mentally competent to enter this plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. If you were guilty of this crime and any lesser included offenses, you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation by your attorney. All of this is true. It states so help you God.
Yes, sir.
States Exhibit 1.
No objection.
Made a part of the record for all purposes. Pre-sentence report is waived in this case.
Yes, sir.
If nothing further, I'm going to find as follows then, that you are pleading guilty to this state jail felony of burglary of a building voluntarily, as alleged in this indictment in 23-41304. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here in this hearing to find you guilty beyond a reasonable doubt, which supports your guilty plea. I now find you guilty beyond a reasonable doubt of this state jail felony. I am following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. Now, that confinement shall be suspended. You were placed on regular probation for 5 years. You do well, it's shortened to 1/3 of that time. There will be terms and conditions of probation which are normal and customary to this type of offense. It is irresponsible to burglarize buildings owned by other people, and especially homes, but this is a building and it had a loss of $1,500 that the parties have agreed or is restitution to be owed to the complainant, John Neves, Neves or Neves. And that I want that paid back, sir, within 180 days.
Yes, sir.
If you don't, I want a hearing on what the problem is, because you've made a promise to me that you've secured some employment with a responsible entity, and they will pay you for your work, and they pay fairly. And I want this victim paid back as soon as that period of time before that elapses. If not, we're gonna have a hearing and we're gonna find out why.
Yes, sir.
What the holdup is and how much you have done. If I find out that you're not doing all you can reasonably to pay this restitution and follow the other term, the probation can be revoked. And you can be sentenced up to 2 years. And that's 2 sentences that stands between you and the state jail.
Yes, sir.
But it's all in your hands. It's your choice. How you're gonna, which direction you're gonna head, And this is the same direction that all responsible people do. They pay their debts, they follow the rules. We all do it. So it's not something that's Mount Everest, something we are all capable of. So show it. Do you have any felony convictions?
Yes, sir.
What do
I have
you,
a burglary habitation in 2003.
you about finished with the burglaries?
Yes, sir, I'm done.
Because, somebody shoots you, the owner shoots you, they can be awarded.
Yes, sir.
Because that's what our civilization thinks about people who come in and invade people's property unwarranted. And they work hard for it. You can't take that time and effort and expense back when somebody comes in and invades. So it's like somebody coming into America to have a war with us. We're going to defend ourselves, and homeowners and people who own buildings have a right to do that as well. All right, well, follow the rules so we can all live together. Thank you. That is all.
Thank you, honey.
Yeah, Roddy, come on up, please. On Keyshawn Washington. Do we need him out? Or is he here? Oh, is he supposed to be here?
Yeah.
Okay, Keyshawn Washington. Keyshawn Washington, 16-26375, no answer in the courtroom. No answer in the courtroom. I asked the bailiff to call into the hall for Keyshawn Washington, please.
You should be in jail.
Oh, he's in jail?
Yes.
Did you know that?
I think we requested a bond.
I'm showing he's in the jail. Let me see this. Here you go.
Okay.
He's in custody.
Let your file say it's fine.
Please.
Okay, you are Mr. Washington
Sir.
here in cause number 16-26375. You were here with your attorney, Mr. Kimler. You recognize him? Vaguely, huh? When was the last time you saw him?
I don't know.
Years ago or
We're trying
a decade?
We're trying to get a bond. So,
Okay, there's for what? This first amended motion to revoke probation?
yes, sir.
It was filed 4 years ago.
I know we'd like to get a bond.
He just got arrested on it?
We're arrested.
Yeah, I'm asking this stuff. Well, who's the prosecutor on this?
When we arrested.
It's
April 7th is when we get custody.
Mike Laird.
Yes, sir.
Okay, you were placed on probation in 2018 for 5 years, deferred or unadjudicated probation, which is now 7 years, going on 7 years ago. This first amended motion to revoke unadjudicated probation was filed September 17th, 2021, which is going on 4 years. We're almost 4 years. Have you been an absconder?
Objection, Your Honor.
Has he?
Yes, yes.
Your objection to what?
It's-
My
well,
question?
That might require. incredible
I'm asking the probation officer.
That's a legal conclusion.
When was the last time he reported?
The last, his last court date was June 2nd.
Yes, I think.
June 2nd of 2021. Okay, okay,
But he was arrested April 7th of 2025.
okay.
And last note I had on my file was October 14th to 21. There was a warrant because it was a no-show for court. So I don't know what happened since then.
It's deferred adjudication.
Yeah. Okay. Anybody want to say anything?
Well, I think he's entitled to, given the length of the delay and him returning to custody, there may be a due diligence issue as well. So, but we are requesting a bond.
Okay. Anything else? Anything we'll state?
Since he's not been able to be found probably until this time, and he hasn't reported, hasn't turned himself in, we request the bond be extremely high, and if he gets a bond, that he get a GPS monitor as part of it.
Anything else?
There you are.
Okay.
And then
Anything?
we just
Okay.
going to request a speedy.
Nothing else?
Request a speedy hearing.
Okay, we'll have it here. Your bond is $250,000. If you post that bond, you must be in home confinement. You must have a GPS device. You cannot leave home for any reason except for medical or food and any other necessary needs that have to be approved by the court first through your bondsman
He'd have to,
and the probation
he'd
officer.
have to report obviously the probation.
That goes without saying.
Right.
You're under probation rules that here. See your signature right there? That you signed 4 years ago. I agree to follow all the conditions imposed upon me, and I know that this community supervision can be revoked for any violation. I will remain in the legal custody of this court and hereby waive extradition if I am charged with a violation and arrested in another state. And there's your signature. You made that promise. And we hadn't seen you in 4 years. If you don't report, you're not really on probation. It's just a joke. And we don't find it anything but serious. We find it serious because that's the only way we can supervise folks. The ironic thing is you were placed on deferred or unadjudicated probation, which gave you a chance. And that was on 2018. And you were really toward like you had done 3 years. But you got to run through the tape, you know?
Yes, sir.
You run track in school? Okay. You let's say you're running a 100-yard dash, you go 50 yards and stop and walk off. You get a participation prize even? No, you're not. And certainly you don't get first place. All right. You got to run through the tape. We all do. So even when we don't win, you still got to put the effort and complete the task. All right. I want this. Look, there's not a substantive crime here, is there?
No, sure.
But it's all something that I'm sure the probation office is probably can be ready to testify to. I want this in a few weeks, please.
Yeah, they destroyed a lot of stuff.
When can you be ready, right, on this, on a hearing?
All right.
You've been working on it for 4 years.
Speak your life. You want to put it like
No, it'll probably be a couple of weeks, but not long. Okay.
I can do 2 weeks.
2 weeks. All right, let's do it then. Thank you. All right. Anything else? I see David Tovar, I believe, correct? Is that it?
Yes, sure.
Mr. Tovar, thank you. We'll need David Tovar, please. Thank you.
Administrator needs to diligence was conducted, it's like it says required. That reports. Yes, maybe.
It says defendant motions. Is that right? So this is a case that's pending, right? Okay.
Yes.
22-41144 is now called the State of Texas versus David Allen Tovar. Is that you, sir?
Sir.
Present. Mr. Wilkerson is here representing you. You're not representing yourself, correct? He's representing. So, okay, good. And the state's attorney is present. You, as you know, are charged with this first degree felony offense of continuous sexual abuse of a child, which carries with it a significant punishment of a first degree felony. This was indicted on November 30th of 2022. Has the defendant been an absconder?
No, it's been on the trial docket for quite a while, Your Honor.
Well, we do the best we can. We're trying as many as anybody I know. So It's not like we're letting anybody down. We just have far too many cases to try and
So there are a couple of issues.
go ahead.
First of all, my client has completed an affidavit of indigence. We're going to need, at a minimum, the complaining witness in this case, her pediatrician to testify, which is going to have some costs as far as an expert witness is considered. We also probably could use in conjunction or in lieu of that, a separate expert witness. But his family is here today and they just have no more income that they can spare with this. His wife's been
With
working.
what? The preparation for trial?
Yes,
Is
sure.
what you're saying?
Yes.
What is it you're going to do with the victims or the complainant's physician? I mean, do we have some kind of situation of privacy here under law that may infringe upon any freedoms y'all might have under constitutional law and rights in defense of a case?
What we have, Your Honor, is a complaining witness who in part had I guess you could call it birth defect. She had external hymenal tissue, Judge. And so she also journaled her, I guess however you want to term it, she chronicled all of the people that she was sexually active with. Now the state's moved to try and keep that journal and those entries out of the case at bar. But one of the important points is the loss of that hymenal tissue corresponds to the entry in that journal when she first discusses having penile vaginal sex. Moreover, Judge, there's also an issue. The state is trying to prevent an allegation that the complaining witness has made against a childhood friend for, excuse me, I can't breathe, some number of years that involve allegations of sexual assault. But this is when they were 6 years old. And so they're also trying to keep that out. But in any event, and by the way, we mentioned before that we need to have a hearing on that motion in limine. And I don't know if you want to do that with the trial or potentially before the trial, given the complex number of factors that have to be considered in making a determination as to whether some of these matters will be allowed in or not.
Whatever we do, we got to fast track this.
Absolutely.
Because of the nature of the crime, and we're moving on 3 years, which is far too long for this case, this type of case, which the legislature has placed as a primary importance on trial docketing.
Judge, if at all possible, I'd ask that this case be specially set because we have subpoenaed people so many times to show up, repeated subpoenas, and also
But you're ready.
Yes, we're ready.
State's been ready, Your Honor.
Well, then let's preferably set preference it as a number one case. When can we do it? From my coordinator?
Judge, we have special studies up to the summer. We could possibly do it at the very end of August or beginning of September.
How about beginning of September?
That'll work.
All right. And like a week before that, we'll set it for pre-trial motion hearings if necessary, or we may take it up during the course of the trial, depending upon what the circumstances are and what the parties wish to do.
So the only issue with regard to at least
you want money now for
yes
for prep.
Yes, Your Honor. We have this, I believe it's been filed, but it's an affidavit of indigence.
What are you asking?
So we
I have a motion in limine. That's not it. What are you asking for? Do you have something in a motion, written motion for monetary need?
No, for monetary requests, we do not
All
yet,
right,
Your
well,
Honor.
let's put that in a written motion and then we'll let you add anything to it in a hearing, but let's get, we have this now set. So we're talking about, we're in May, June, July, August. Okay, you got about 3.5 months.
Yes. The only issue with regard to the, I guess it'd be a 412 hearing, for some of these alleged prior incidents that the complaining witness has journaled about is again, some of these journal entries correspond to a physical change associated with the complaining witness, specifically the loss of that hymenal tissue, that external hymenal tissue.
So
And
tell me what the statute says about sexual act with a child younger than 14, about whether the hymenal tissue is a necessary element of the offense.
no, Judge, the allegation isn't that it changed with regard to
What do you call it?
the,
Just make it clear on the record.
okay, so we allege obviously that it would have been impossible for the defendant to have engaged in the alleged activities prior to a date certain established within her journal, where she indicates that she engaged in sexual activity because her mother was caring for her birth defect up until the time that she engaged in sexual activity as reported by herself in her journal.
I know you've read the indictment. It's alleging 3 different types of felony acts within the statute, causing his sexual organ to contact or penetrate the mouth of the complainant. Where is that a part of?
As far as the mouth, Judge, it's not.
Okay, then that has nothing to do with your argument. Number 2, causing his sexual organ to contact or penetrate the sexual organ of complaint. What does contact have to do with it?
Or penetrate.
What does contact have to do with it? Absolutely nothing, right, with your argument. Okay, but I see the penetration point. I'm just saying there are variances and they are pled in the disjunctive, which means either way is you're on notice that they're going to attempt to, they're alleging both ways, and you just be one way may be the only way that is sought.
That the
third way.
The complaining witness articulated these allegations up to and including the penetrative issue, Judge, is obviously relevant to the other allegations in the indictment.
Okay. The arguments, forget it. What we're talking about is what's been alleged, what you are on notice that the state may be proving. That's what's only issue right now for me. Finally, the other way is intentionally or knowingly causing his finger to penetrate the sexual organ. How would that apply in your argument as well?
That would also result in the loss of hymenal tissue, the external nature of which is not, we're not saying that.
You know the definition of penetration of the vaginal area under law?
Yes.
It doesn't
require.
It doesn't require that.
It does.
All right, thank you. All right, anything else? I think we noticed not what the potential aspects could be, but what's necessary. And necessary can be met without having to deal with any of your issues, and unless the state is going to try something different, then we'll deal with it then. But you're on notice there. You have been placed on fair notice for years on what they are alleging, which are methods that can be proven as alleged in this case, which do not intercept or interact with your argument at all. So let's just move on with what is provable realistically under law. If something comes up, we'll take it at the hearing.
The statements of the complaining witness, Judge, are what are in issue.
Well, that goes to something that's always in a trial: credibility, how much weight and credibility to be given by a jury, and let the jury deal with that. Okay. I'm not going to prove that point up for them. We'll see how that plays out. I'm just worried about the issues that the state has been placing you on notice in the disjunctive. You've been placed on notice, those areas. If they have to come up, we will take them up at the time. It's not necessary right now. They can prove their case as alleged without having to deal with your argument. And all indictments tend to be alleged disjunctively and also in a general fashion. And if we had hearings on what could happen specifically, if this is every case, we'd never be able to get to trial. So we'll deal with it in those rare cases that it becomes an actual issue. But I don't see it at this time. So we're going to move forward. Let's get to trial. Everybody sounds like we're ready, willing, and able, and let's move forward. This is a case that the legislature says needs to be fast tracked. So it shall be. What's the date?
September 15th.
Got it, everybody? September 15th. And special set first. Thank you. All right. Anything else? Marcus, anything else on this?
No, Your Honor.
Thank you. All right.
A hard copy of this affidavit.
I don't think we need a hard copy. You want to just make a copy?
Sure.
Yeah,
That's good.
email me a copy.
Anything else on this? Anything else? Anybody? Yes, no? All right, we are in recess till 1:30. Thank you. Very good.
Always.
Possessing any firearms or any weapons. While you're on bond, you will also be prohibited from drinking any alcohol or any controlled substance that you do not have a prescription for. And you're also going to be ordered to undergo random urine test. Okay. I do see that you were also charged with the offense of possession of a controlled substance. And I see that the bond conditions on that one requires you to do urine tests. So Ms. Garcia, UAs, but he's going to pay the UAs because of the court upstairs. So it'll be defendant paid. All right, Mr. Leja, these conditions of bond are going to remain until this case is over with. I am going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Now, you are going to need an attorney to represent you on this case. I see that your other case was rescheduled to 6/25 for you to get a lawyer. So we're going to reschedule your case for the same day, June 25th. Now, Mr. Leja, if you do get a lawyer, just have that attorney contact this court before the next court date. You, sir, do not have to come back to court. You let your attorney take care of your case. However, if you do not have an attorney by the next court date, you will have to return to court. All right, sir, do you have any questions on anything that I mentioned to you? No. All right, right behind you, the table, my preacher also go with her. Sounds conditions, have a seat, we'll reset your case. Millie, page 10, Leja, THA. All right, come on up, Ms. Capillo. Come on up. We got our interpreter here. And let's see here. Yes, Mr. Martinez Delgado. And Ms. Anthony, this is Martinez Delgado, but it's not for PC. But there was a 2B one.
You need cause number?
Yeah, please. Yes, sir. You're Argenis Martinez Delgado? Hi, Mr. You're here with your attorney. I just wanted to inform you, sir, of what you are being charged with. You are being charged with the offense of assault of a family member. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. I see that this was an offense that was alleged to have occurred on June 28th of 2023. That's almost 2 years ago. There's an individual by the name of Gamboa Francis that's accusing you of this offense. I see that there was an investigation that was being done by the Harris County Precinct 5 Constable's Office. I see that they were, sent over to a residence in Katy. They met with Gamboa Francis, and Gamboa Francis told the officers that you were her husband and that she's accusing you of assaulting her. Okay. So the officers went ahead and did an investigation, and they contacted the district attorney's office, and charges were filed against you. Now, those charges happen to be out there all of this time until it looks like you posted a bond in Fort Bend County. Was he arrested on Fort Bend? Did he get detained in Fort Bend and they found this warrant?
Yes, sir.
Okay.
Got pulled over for speeding ticket.
Okay, they found the warrant? Yeah, okay. All right, sir. So I do see that you posted a bond out of Fort Bend County and were released on bond. So what we're going to do this morning, sir, is the court's going to order some conditions regarding your bond. Now, Ms. Anthony, do you see this case, Martinez Delgado?
Yes, Judge.
Do you know if anyone from the state has had any contact with the complaining witness?
Yes, Judge, they have.
Okay. Is she requesting any conditions?
Let me check, Judge. Yes, it looks like residency restriction and no contact.
Now, did they contact the complaining witness recently?
This morning, Judge.
Oh, this morning. Okay. Were you aware of that?
I was, yes.
Okay. And do you know, I'm assuming, I see that in the to-be warrant, they were husband and wife. Are they still together?
No, sir. They were actually meeting up that day to sign divorce papers.
Oh, I see.
So they had been separated. They don't have any children.
Okay.
The only reason he has to communicate with her is to finalize the divorce, which to my understanding still has not been done.
All right. So she requested no contact?
Yes, Judge. But if they have to, state would be amenable to no threatening.
2 years, almost, since this happened. So I had to believe there's been some type of contact since then. Okay, I'll order no threatening. So, Ms. Garcia, it's on page 11, Martinez Delgado.
Yes, sir.
So, Mr. Delgado, the court's going to order while you're on bond, you're not to threaten, harass, or assault Gamboa Francis. You may speak to her, you may contact her, email, text, whatever. Just don't threaten her, harass her, or assault her. You will be prohibited from going over to her residence, wherever she may live. Don't go to any residence, okay? And you will also be ordered, sir, not to possess any firearms or any weapons. These conditions of bond are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Now, we are going to reschedule your case to allow you your attorney time to gather all the evidence that he needs. On your next court date, sir, you do not have to come to court. You, your attorney will let you know if and when it's necessary for you to return to court. All right, sir. Do you have any questions on anything that I mentioned to you? Okay. Okay. Do you have any questions?
Yes, sir.
All right, sir. Right behind you, the table, my pre-trial officer, go with her. Sounds conditions, have a seat. We're going to reschedule your case. And just get a court date from my coordinator.
Yes, sir. Thank you, Judge.
Thank you. You're welcome.
Yeah, it was run in 2020.
Millie, on page 2, Barrera Ernesto, court appoint.
Yeah.
Yes, ma'am. Hey, you're welcome. Yes, ma'am. How are you?
Good, how are you?
I'm good, thanks.
I have a Spanish arraignment on Ms. Ventura Davila.
Nope, got it right here. All right, let's call her Francia Ventura Davila. Now, I haven't heard PC on this. Would you like the court to hear it?
Yes.
Okay. And Ms. Anthony, this is on Ventura Davila.
Yes.
CFSGI. On page, yeah, it's on page 19.
Okay.
Page 19, if you need the cause number. You are Francia Ventura Davila. You're here with your attorney. I just wanted to inform you that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the assistant district attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you are being charged with. We're going to talk about any conditions of bond that the court may impose, and then we're going to reschedule your case. All right, Ms. Anthony, whenever you're ready, you may proceed.
Yes, Judge. On 5/5/2025, officer is dispatched to a failure to stop and give information in Harris County, Texas. Complainant told the officer that someone had hit his vehicle while parked. Complainant did not see who, but got video footage from a neighbor. Video shows the vehicle and license plate of defendant's vehicle. Officers went to address listed and spoke to defendant. Defendant admitted to being involved in the accident and stated she was distracted. She told officers she got scared and left the scene. Damage was $2,000.
Any response to procedure? Okay. All right, Ms. Davila, the court's going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of failure to stop and give information. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. So what we're going to do this morning is the court's going to order some conditions regarding your bond. Ms. Garcia,
Yes, sir.
this on page 19, Ventura Davila.
Yes, sir.
All right, Ms. Ventura Davila, there is a person by the name of Eddie Gonzalez that's accusing you of this offense. I have to believe you do not know who that is. Okay, so the court is going to order that you do not have any contact with Eddie Gonzalez. Do not call, text, email, no contact whatsoever. Secondly, the court's going to order that you are prohibited from possessing any firearms or any weapons. These conditions of bond are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. We are going to reschedule your case to allow time for your attorney to gather all the evidence that she needs. On your next court date, you do not have to come to court. You let your attorney take care of your case. She will let you know if and when it's necessary for you to return to court. All right. Do you have any questions on anything that I mentioned to you? Any questions?
No.
All right behind you is my pretrial officer. Go with her. Sounds conditions. Have a seat. We'll reset your case and just get a date. You're welcome. Yes, ma'am. Thank you. Thank you. You too. Yes, sir. Good morning.
Good morning.
What you got this morning?
I'm calling Cesar Rivera.
What's the last name?
Last name Brown.
Brown. Let's see here.
Yeah.
In custody?
Yes.
All right. Let me see here. Oh, Tisha Brown. Let me see. DWI.
Yeah, you do. Thank you.
I think they're kind of back there. What are we doing? Get a personal bond.
I don't understand. She's only got $100 bond, and it looks like.
This is eligible one.
Yeah, no. It's kind of funny.
I don't see the usual bond.
I wonder. Let me look at something. Looks like she got arrested yesterday.
Yeah.
I wonder if she's in processing.
She got here.
Miss Anthony.
Yes,
Do you
Judge.
see this case,
Yes.
Tisha Brown?
Yes, Judge.
Do you see that if she has anything else pending county besides Harris?
Yes, I'm looking right now. It looks like she was on a DUI probation, but she should have been off of that in 2022. That's the only criminal history I'm seeing. Yes.
So you see a DWI case?
Yes, I see there was a DUI out of, I believe this is Georgia, that she was on a probation for.
State of Georgia, right?
Yes, yes, Your Honor, out of, in 2021, it was a 12-month probation, so it looks like that should be over by now.
Okay.
But that's the only thing I see.
All right. Well, if she does have that probation, this makes it a DWI second. And if that's the case, I'm going to issue bond conditions. I will release her. I want to give her a PR bond. Let me check something. Nancy, real quick. On page 23, Brown, she's in custody. Do you see anywhere on there where she might be released on a GOB? She's got $100 bond, but that's
It just says she's eligible, Judge.
really, that's all?
That's all. I don't know if she's actually been
It
getting.
looks like she got booked in yesterday, right? Yeah, I see 3 a.m., 5:11. So I bet you that she's eligible. Maybe the paperwork hadn't gone through, but not, she's physically here, right? Let me just do a PR bond. Ms. Garcia,
Yes, Your Honor.
on page 23, Brown, I'm going to go ahead and do a personal bond on her. She's in custody, but I'm going to raise the bond to 2,000, although it'll still be a PR bond. And Millie, page 23, Tisha Brown, I'm granting a PR bond on her. I just need to get a future date for discovery. July 20. Is that a good day for you? Okay, well, to July 23rd. So let me do that on a bond paperwork. All right, so July 23rd. But I am going to issue bond conditions. So looks like since she does have a prior DWI, I'm I'm gonna have to order an interlock. Do you have any idea if she has plans of driving a motor vehicle? I'm not prohibiting her from driving, but if she's gonna drive, which is fine, as long as she has a valid Texas driver's license.
So I won't throw that, but there was a refusal, so I assume the ALR suspension would be there.
Yeah, but she is, the ALR is not gonna take effect for another 45 days. But I just need to know if she plans on driving, because she just got arrested.
Yeah.
And there's a 15-day period that you can request for an ALR hearing. Not that you're going to do it, because you're just appointed on this case. And I just need to know if she's going to be driving. If not, I'm going to order a portable and no driving.
Yeah, so I believe she will be driving. Just gonna see how we handle that, address it later if we need to.
Okay, so then we'll order portable, no driving. She will be driving?
Yeah.
Okay, all right, so then Ms. Garcia, let's order an interlock,
Yes, sir.
waive the monitoring fees and agency pay,
Yes, sir.
and let's do random urine test too and waive those fees.
Yes, sir.
And no weapons, no alcohol, controlled substance. So just let her know, no alcohol, no controlled substances without a prescription, no alcohol, interlock, we'll pay for the interlock, and then a random UAs, and we're gonna also pay for those.
Yeah.
So she's gonna have to come out here in a couple of minutes. Ms. Garcia, how is she, when she is released, she has to go to 49?
Yes, be up to her, Your Honor, once she gets released.
Okay.
To go over to
Okay, just let her know that once she's released from custody, she has to go to 49 San Jacinto. Now, it's in the morning. If we do this, she might be released today, but I don't know how late.
Yeah.
I think pretrial's only there till 4 next door. So she might have to come back tomorrow. But just let her know to come pretrial, get her bond conditions, and then we'll reset her case for 7/23, and she's good to go. Okay?
Sounds good.
All right.
So I do have one more.
Yes, sir.
Last name Harvey.
Harley?
Harvey.
In custody also?
Yes, Judge.
Let me see, Harvey. Got it.
Basically, it's kind of weird. I think you should back up to make bond like yesterday.
Oh.
It was bond made. They told him it should be being
It's
released.
probably in processing then. Let me look at it.
Still, I think we should do.
Let me look at it. All right. Nancy, page 27, Harvey. I do see bond made on 2 cases.
Yes.
Oh.
The other also.
Which one? The theft or the trespass? Because I see a trespass and but I see bonds on both.
Yeah.
Yeah, I see the PR bond on the trespass. Oh, God, I wish they wouldn't do this. Are you going to represent on both?
I've been appointed both.
Yeah, let me look at the theft. I don't see bonds on the theft, Nancy, but I do see that,
It's in the system, Judge.
it is supposed to, so it is being processed. Okay, so he's gonna be released on bond, but I need to issue bond conditions now that he's here. Is he physically here?
Yes.
Okay. Let's do this. Let me look at the theft real quick. Let me, come on. And trespass. All right, he's got bond conditions on the trespass. But I need to issue bond conditions on the theft. I haven't heard PC on it. Let me hear PC. Miss Anthony.
Yes, Judge.
This is on Harvey Duntae, Duntae. It's a theft.
Yes, Judge.
Let me hear PC on that theft case.
Yes, Judge. On 5/9/2025, officer was dispatched to a robbery in progress call at CVS in Harris County, Texas. Officer met with complainant, who was a store manager of the CVS. Complainant stated defendant was outside of the location causing a disturbance, threatening customers and digging through the trash. Complainant stated that he told defendant he did not mind him going through the trash, but not to make a mess. Approximately 20 minutes later, complainant observed defendant enter the CVS, and which he knew he shouldn't be on the premises because complainant told him earlier in the day to not come back because he took merchandise earlier by concealing them on his person and passing past all points of sale and walking out of the store. And the total was $44.84.
All right, so I'm gonna do bond conditions on Mr. Harvey also, so Ms. Garcia.
Yes, Your Honor.
This on page 27, Harvey, no contact or going over to the CVS. Do you have a particular location?
Yes, I have a location, Judge.
So do you mind giving that to Ms. Garcia? Just to, okay, and no weapons.
Yes, Your Honor.
So he's here too, right? We're gonna bring him out too also so he can sign those bond conditions and just tell him, don't go over that CVS and no weapons. Now, his other case that you're appointed, that's it for the till 16, but let's off docket that. And I want to set both cases together. So just let Millie know to put those two cases together and we'll set them off probably sometime in June or July. Okay? And then we'll bring him out in a minute to sign those things. Okay, you got it. Thank you. Yes, you're welcome. Morning, how are you?
How are you today, Judge?
I'm good. How are you doing?
I'm good, Judge.
Oh, it's good.
Provost, he's in custody. Judge, I don't know if, I was trying to see if probable cause had been found.
See, I'm looking at the trespass to see why he's in custody on a trespass.
Judge, I think he's in custody because the bond is set at 2,500, and I wanted to address,
You know why?
he's in the deferred, but they haven't filed a motion to revoke.
It's coming. I can assure you it's coming.
Well, in this one, Judge, the underlying case was a burglary at U of H. He goes there at 2:32. He was under the impression that he could not go back to that building, but he could go to the library and read books. So at 2:32, they saw him at the library and they filed a criminal trespass charge against him.
Unless he received notice not to come at all.
Well, Judge, when I looked at the probation conditions, it does not say anything about he is not to go. It says no threatening or harassing.
Yeah, but that's the probation. I'm talking about this case. So let's do this.
And I don't see where he received any notice.
Well, let's see. Miss Anthony,
Yes, Judge.
Provost, Provost, Eric.
Yes.
Let me hear the PC on this one.
Yes, Judge. On 5/9/2025, officer responded to the U of H Anderson Library in Harris County, Texas, after receiving information from a U of H security officer working at the library. While conducting a patrol check of the area, security officer recognized the defendant by sight from a previous burglary of a building report. Officer met with the defendant and was provided his name and date of birth. Officer provided the information to UHPD Police Dispatch and confirmed the defendant had one previous criminal trespass that was issued by Officer Ritchie, reference case number 23-1626. Defendant was again found on U of H property without legitimate business or authorization.
So he was asked not to come back.
And this is the part that I'm not clear on. He was arrested for I keep saying B&B, but the burglary. And I don't see where he was provided any notice. I think what he was he was arrested. He was charged with burglary. And then I don't see where he was giving a criminal trespass. When I looked at and I thought maybe it was a part of his probation, but I don't see anything in there other than no threatening or harassing communication with the alleged complaining witness. He was at the library. He wasn't at the building. And I get it. He was given a criminal trespass for the entire university. I understand that.
Yeah.
But he was under the impression that he couldn't go back to that particular building. He was at the library at 2:32 p.m. reading a book.
Well, but
And I get it, Judge. If there is a criminal trespass, I just don't see it.
well, I don't see it in the probation conditions. You're correct. I don't see anything prohibiting him on his probation conditions.
Right, Judge.
But if the UHPD told him not to come back.
And that's the part I don't have to. And I was going to ask you, could you consider giving him a PR bond on that, Judge? Because that is a missing. I mean, he was there at 2:30, and I get it if he was not supposed to be there, but there was nothing nefarious about him being at the library reading a book. Granted, if he was told not to be there, and I've explained to him that I don't see it, but if they're saying that he can't be at any part of the university, whether he's at a library reading a book as a part of, because his conditions of probation said he had to get some type of GED or whatever, but I'm asking the court to consider giving him a PR bond on this case because outside of this, I don't see any other criminal history. I see that he's on a deferred. And outside of this, there is no other criminal history, and the deferred is for a state jail felony.
Yeah, I do see it. But I'm gonna be honest with you. It's a 228.
And if they do judge, then, that's an argument for,
That's
but
good.
based on these things, I would ask the court to give him a PR bond.
I'm hesitant. I'll be honest with you. I'm very hesitant. You know, especially, and not necessarily that I am targeting your client or anything like that, but there's been a big issue with people going to that university that don't belong there. Okay.
And Judge, I do agree, but he was in the library.
I understand.
And I get it, Judge, I do. Even if, I would think a PR bond would be appropriate in this circumstances due to the limited criminal history. He is on a deferred, and the trespass was at 2:32 p.m. at the library.
Do you see, all right, Miss Anthony, can you pull that again? What do you see anywhere on there what the date or time of offense?
Let me check, Judge. Yes, 2:32 p.m.
Okay. And it's at the library?
Yes, at the library.
And Judge, if it was 9:45 or 12 a.m. at the library, then I would.
No, I understand.
As far as I can see it, what do you want to
Okay, from what I can tell on his burglary case, he never bonded out.
Right, there's no amount of bond.
So it looks like he got charged with burglary. And
He sat there for,
I don't know how long. I mean, I see that
5 months.
maybe, I do see that he was charged.
But not the other one.
Well, it was a 2B warrant. This was January 2024, but it looks like he didn't get detained till December of 2024.
And it looks like he pled out
And
the,
then he pled up in January, the
Right.
next month. So he spent at least a month in jail.
and the bond was only $1,000 on that case.
Let's see how much the bond was.
That's 1,000.
Yep, you're right. It was 1,000.
This is on May 3rd. Should go out. And then,
That particular case, the allegation, he entered University of Houston Stadium offices and allegedly took some items that he pawned later on. All right, he was given $1,000 bond, but they did not give him a PR bond for that case in state jail, the state jail felony. I'm very hesitant at giving him a PR bond. I really am. I'm sorry. I'm just super hesitant doing that.
And Judge, would you consider lowering that? I mean, even, I can tell you any amount of bond, but at 2,500 on these circumstances.
Yeah, I know that was the magistrate who did that. The magistrate gave him, excuse me, a $2,500 bond. All right, let's do this. I'm not giving him a PR bond. I'll split it in half, $1,250. And the 2,500.
Show whether, Trespass, where he was advised. Cause they said.
Yeah, we don't have it yet, but we'll have to request.
Okay, can you request?
I'll
Yeah,
put it in there.
Thank you.
I mean, I'm sorry. I'm just very hesitant of, and, giving you a request. I understand exactly what you're saying. He was at the library, allegedly he was reading, et cetera. He just got out of jail in January. And for burglary of the same location, University of Houston, you know, and then he was given a trespass warning.
And that's the thing that's in question, Judge, but she's gonna request it to be.
So, I mean, if he was given trespass, he had to know, you can't come back here, period. I know. All right, I lowered the bond to $1,250. Let him know that if he bonds out, he is not to go to anywhere near the University of Houston. Because I do see bond conditions that specifically say, don't go over to the University of Houston, anywhere on campus. It's a huge campus. So anywhere on campus. And then let's just get a date from Millie, or whatever date you want, okay?
Okay. All right, thank you, Judge.
You're welcome. Yes, ma'am. Come on up. How are you?
Hi, Judge.
Good morning. You haven't heard from Ms. Pybus, have you?
Judge, she let me know she's still in her bail review here.
Really? Is that in
Yes.
felony court?
She's in court 11. She's covering 5 courts today.
Can somebody else talk to the complaining witness? He's here.
Sounds like a fun hearing. She did let me know she can give him a call, but I told her you wanted an in-person.
Well, because he's here.
He's here.
Yeah. I mean, now that he's here, let's take advantage of it. I mean, if you or somebody else can do it, that's fine with me.
Yes, Judge, let me ask Chief.
Okay. Okay. This is on an assault case. It's just a rip call, okay? And it's going to be in reference to Martinez, Damaris Martinez. And the complaining witness is a Jonathan Martinez who's here in the courtroom. And it's just a rip call. So if you can handle that, Ms. Siegler, I appreciate it. Thank you. Yeah, I'm sorry. Yes, ma'am.
Mark Solis, Your Honor.
Solis?
This is kind of a weird one. I was just looking at the complaint on this one, Your Honor. I believe you've already found PC, but I was eyeballing.
It's a harassment. Let me see
It's a
here.
couple phone calls. Apparently, his sister got into a beef with a complainant, and so he made some kind of foreboding phone calls, and they interpreted it as, to me, a little outlandishly, that meant he was going to show up at their house and shoot them up, even though he said, I believe the quote from the complaint is, you have something coming, and I have a surprise for you.
I think the 2B warrant that was alleged to have occurred January 16th. I'm looking at the 2B warrant. Baytown PD, dispatched to location on Main Street in Baytown. Spoke to Charlotte Reyes, complainant. Do you know the relationship, if any, between?
This is, my understanding is, Your Honor, the defendant was backing up his sister who had a tiff with the complainant.
Oh,
And so he's the brother, the big brother, who apparently is, yeah, that's where these phone calls came about, at least from my reading of the complaint. But this is kind of a weird, you get from, I have a surprise for you, you've got something coming, to he's going to show up at their house and shoot them. I mean, that feels a little.
Let me see. It says complainant, they received a call from a Charlotte Reyes. Stated that her daughter, Jasmine Reyes, got into a verbal fight with her friend Mia. Words were exchanged, but the girls decided to squash the dispute. Then she said that Mia's brother, who is your client, Mr. Solis, started making phone calls to Jasmine's phone while Jasmine and complainant were at home in Baytown, stating things like, I have a surprise for you and you have something coming. Well, I mean, you know, that's.
But this is after the issue has been squashed, as I said, which is kind of.
I understand that. You know, when someone calls you and says, you have something coming, and you just gotten into an altercation, and then you come to find out that the person that's contacting you is the brother of the person that you had an altercation, I can see where this individual would feel.
Just seems kind of vague is all I was trying to say.
Well, I know. Okay, let me read some more.
I'm sorry, I'm gonna say other times 11 days.
Yeah, that's 36.
All right, did you read the part where it says that the complainant called and spoke to her mom, your client's mom?
Mhm.
Then she could hear in the background yelling he was going to come and shoot her.
That sounds like extreme hearsay within hearsay within hearsay within. I don't know what that is, Your Honor.
I know, but this is just PC.
I know, it just seems a little.
I know.
An intriguing complaint.
I know, and she said she knew the defendant's voice from conversations she's had.
It's quite the family dynamic.
All right. Okay.
We're just requesting a bond on this one, Your Honor. It just is kind of a unique complaint.
Yeah, he didn't have a bond. All right, he's got an active case of tampering with a witness.
It is a case that's been pending out of the 180th, Your Honor. It looks like, I'm not counsel on that, but
I
it's
know.
been pending for some time, for about a year now.
Posted a $35,000 bond on that case. So that leads me to believe he's got access to funds.
Although I am court appointed, Your Honor, so.
Because he's invested.
Or maybe he depleted that all his money with that $35,000 bond.
Years old. I'm not giving him a PR bond. So I'm concerned, tampering with a witness is not a very, mild offense. Same thing, had contact with Baytown PD in reference to, I'm looking at the tampering. Okay.
Would it comfort the court at all to know that, standard bond conditions on the felony would be no access to a weapon? So for this to be proposed that he would have access to a gun to threaten the harass the complainant would be a violation of his bond conditions, and there's no BVR pending. So
Well, I agree with you there, but
access to a weapon should not be a possibility in order to give the complainant foundation for their harassment concerns.
well, I don't know what in terms of a specific condition he's got on his probation. I haven't looked that far. This is not good. I hear what you're saying. He's 18. He probably is not thinking of the words when he.
I don't disagree at all, Your Honor. I'm looking at the foundation of this, not the other case. I completely respect the concerns regarding that bond. But he is still on bond on that case, even with this going.
Well, he's on, you're right. He is on bond. Well, actually, he's on bond. And it's in the 180th. And he's running a big risk also of having that bond revoked.
Right. And
By
this
that
case is
judge.
kind of odd, to say the least. And if he has not violated his bond conditions, which speaks to the fact that he does have felony bond conditions and they have not BVR'd him, then he shouldn't have.
Not yet,
So-
because it just happened on Saturday.
Right, but I believe the date of the complaint was back in January.
No, you're right. And obviously he didn't get booked into the jail until the 11th. And usually whenever we have bond violations is whenever they get detained. That's when they usually do the bond violation reports. So he just got detained and booked in on the 11th.
What I meant, Your Honor, and I completely agree with what you're saying regarding his recent arrest, is if there had been any conclusion that he had access to weapons or was using guns or threatening or displaying any guns towards the complainant, then clearly they could have BVR'd him at that time back in January.
No, I agree with you there, but he didn't. All right. All right, I'm going to give him a bond. He made a $35,000 bond on his felony case. That's quite a bit. He paid a surety bond on that one. And that was tampering. And I looked at the PC on that one. It's also words. Same thing, just words. And whenever they gave him a bond, they gave him a $35,000 bond on words. They same thing, just words. Like on here, words. So I'm just really concerned about this. Miss Anthony.
Yes, Your Honor.
This case on Solis, do you know if anyone from the state has had any contact with the complaining witness?
Not yet, Judge. Yes, sir.
And this is on. All right, I'm gonna give a bond of $2,500, assuming he could make that. And we're also gonna issue bond conditions. He's physically here, right?
Yes, yeah.
Okay.
You just mirrored the felony bond conditions with your permission?
Let me see what the bond conditions are in felony. It'll be similar, but he's gonna have no contact with the complaining witness. Yeah, I do see no contact with that complaining witness, no possession of firearms. I'm gonna add a few more things. Just because of his age.
Yes, Your Honor.
So I'm gonna add no contact with the complaining witness, no firearms, and also because of age, no alcohol or controlled substances. Not that there
No
is.
speaking, so he doesn't get in trouble again.
Sorry?
I said no speaking. Touche. Yeah.
I know. You know if he's in school or whatever?
I don't know that far, Your Honor. I have a 15-year-old, so I can definitely, thinking without speaking comes at this age. It doesn't help the case. It just,
I know.
it is what it is.
All right, so I'm gonna have him come out here in a few minutes so they can sign those bond conditions. I'll let Ms. Garcia know what they are. And then, if you want to just set his case, does he have a court date in his felony court?
It was pushed out until July, Judge, in order to, or maybe it wasn't July. It was right after the next court setting for the felony.
Okay. All right, no worries. So then, in a few minutes, when Ms. Garcia is finished with this particular individual, we'll bring him out, have him sign the bail order. Not bail order, bond conditions, and just reset the case. Okay, you got it. You're welcome. Thank you.
Judge.
Sir, morning. How are you, Mr. Yoakum?
Big Judge.
Yes, sir.
I've got Mr. Freeze. I believe,
No.
I spoke with Kelsey, a little bit about this today. We were trying to get, he's on page 6, Judge.
Thanks.
Trying to get a PTI. We've given him the mitigation, AMC. He has a little bit of criminal history, starting back in 2002. He had there was, here, I can tell you, they tell you this is why it's complicating it. No, photo ID in 97, that was rejected. Deadly conduct in Hayes County, $10 fine in 01. Bail jumping out of Hayes County, that was rejected. Theft, misdemeanor theft, out of county dismissed. The biggest one is his PCS case from 03, 04. He did 10-year deferred on that. Has a DWI and then an old theft, which was a theft by check, that he pled no contest to. That was like a $20 check.
Okay.
Nothing
And it looks like he served 8 years TDC for the
on the
PCS.
Yeah, I think he got revoked on the probation. because-
On really? On the possession case?
Yeah.
It was
All
the
right.
manufacturer, deliver, and a PCS.
He said the ultimate plea was to a PCS, but anyway, that's not the here nor there. It's a felony conviction. We've a lot of little hiccups, but this is an AFM. We've done the AMC.
Okay.
Kelsey was making him a 12-month deferred. I think I talked her into a 9-month deferred. The issue is he does apartment management, has been doing it since 05. They are not hiring him on the AFM or assaultive type offenses right now. So what I'm trying to do.
So he's employed right now? No, not yet. Okay, got it.
So I'm trying to get him back into his field.
Got it.
And so what I told Kelsey I would do is I'm going to have him do the online DIPP class. Maybe I'll let Kelsey talk to him in the hallway. She talked to him. So I've got to bring her one more thing. I'm trying to get a PTI, even if it's supervised, because he at least can represent truthfully to the management. I'm on this PTI. It will be eventually dismissed.
If I successfully complete, yeah.
So I just need a little bit of latitude. Let him do the BIP online. It's not the 16-week in person. Just one reset will probably have enough.
But the BIP online is how long? It's several.
Yeah, you can do it at your own pace.
I know. Do you know what the BIP program online would be or entail in terms of how many sessions?
Collective, I'm sending it to a different, I don't know what they have.
Oh, I see. It's
I
different.
sent this to Kelsey, and so I said, look, when we have him do an online bill, he can do it at his own pace, and it meets court requirements.
18, is that the online one too? Okay. And that one, does it say on there how long it's for?
I don't know what she's talking about, but I've got.
That's the one from the probation office for.
Oh, okay, I've got, 12, 18, 24, 30, 36, 52.
Hours.
Range from $53 to $115. So I was gonna have to do the 24 hour.
Talk to the state. Now, if they're willing to accept that, that's fine with me. I don't have a problem with it, and I don't mind resetting it. But I just need to make sure that if that's acceptable, because we need to get it going, because it's pretty old. This case is, yeah, 600.
It's not going to trial docket.
Yeah.
The state has a decent case. I'm just trying to resolve in a manner that.
No, I understand.
Work.
I understand.
And this is, I just want to be clear, this is outside of their purview. This is for her. This
Right.
is for her to have in her file.
Right.
So if you just give me a reset, I'll get the bit to her.
Okay.
And try to get it to conclusion by the next session.
Do you remember seeing Batman, the old Batman with, who was it? Batman, I can't
The
remember.
TV show?
The TV show, the one in the 60s.
Yeah. I used to watch it.
There's a character named Mr. Freeze.
Oh, you're right.
Remember that?
There was. Yeah. The Joker,
Just-
the Penguin,
yeah.
Mr. Freeze.
Yeah, I just kind of saw it when I saw Mr.
Holy
Freeze.
moly,
I don't,
Batman.
yeah, exactly.
Same bat channel, same bat.
That's it. You got it. Hey, you got it, Monsieur. Okay, thanks. You're welcome. Yes, ma'am. Come on up. Hi, Miss Sims. Are you back from your vacation? Oh, how was it?
Yesterday,
Oh, nice.
I was gone, we went on like 30th of April. It was a long trip.
Yeah, that was a long trip, but you enjoyed it? Had fun?
It was amazing.
Really?
They call it the last frontier.
Mm-hmm.
It's kind of, it really is.
I know, I agree with you.
It's
very-
very rugged.
It is. It is very rough. Alaska doesn't have a huge population at all.
There's a reason for that.
I know, there is a reason. And it's a lot of wilderness. I know. And I don't know if you had a chance to go whale watching or anything like that.
Yeah.
Oh,
we
nice.
did. And they stayed in Seattle, so.
Oh, nice.
Stayed on Kitchen Sound.
Oh, yeah,
We
nice.
had a lot of wildlife over there. Even
Good.
saw well over there by Seattle. So
Oh,
it was
nice.
cool.
Nice.
Really.
How was the weather?
Well, we were supposed to do a helicopter ride and dog sled,
Oh,
but the weather was not permitting.
it's usually not that great right now. I know.
But most of it, we had excellent weather, except for
Okay.
the 2 days we were supposed to do outdoor,
Mhm.
activities. But other than that, it was amazing.
Well, good. I'm glad you had a good time.
Yes.
All right. All right. So you're
Okay,
here
so I have
on
Brady.
Brady?
This is the case with the
Oh, I remember this one. Yes, the harassment. Yes.
the state and I have talked about it.
Okay.
They want, we are in agreement about a time served, he's got 37 days.
think
But
we talked
we wanted to
earlier.
approach you and see what you said.
I remember we had a conversation about it.
Yeah.
And I remember how uncomfortable I was accepting the time served. And is this on one case and dismissing others or
No.
on all three? He's got,
But he's been in there for now 37 days.
all right, Nancy,
So what
this is on
that?
Brady, page 21. Can you tell me his credit? So what's the offer from the state? Because I believe if I remember correctly, last time I was saying 3 digits.
Yeah.
Yeah, 3 digit, right?
And it's still 111 at this point.
Yeah, you're right, 111 on 37 days credit.
He is going back to Mississippi, Your Honor.
Okay.
He's from there. And I don't think he's ever gonna come back here.
Yeah. This,
35, 36, and 37.
okay, so I can give him 37 on all 3 of them. So what's the state offering?
111 days. Well, we did the math on all of them, so.
No, I
when-
know. 37, that would be 111.
Yes, 111 and then 108 and 105.
Well, I can give him credit for, did you say, what's the most, 37? I can give him credit for 37 on all 3 cases since he's been in custody. Yeah, since he's been in custody all this time. However, man, 111 days. I was thinking higher than that. I'll be honest with you.
Well, Your Honor, but you know, Your Honor, the maximum he would be in there would be two, three more, no, 2 more weeks. And, you know, he's got no record whatsoever. I know these are scary things, but with this on his record, it's a permanent tattoo for him.
I hear you.
If he gets into this kind of behavior, he's not ever gonna have the benefit of the doubt. You got 3 of them that will stick.
I know. All right. I will accept 150.
You will accept what?
150
150.
on all 3 of them. He has to do 51 days.
51 days.
Okay.
Okay.
So that means he's got to do 2 more weeks,
Okay.
and then he's done.
Okay.
But on all 3 of them.
On all 3 of you gonna write it up?
Now, if you want to do it today, that's fine.
Okay. I also have another client on the docket today.
Okay.
Ms. Bailey.
Oh, Bailey, yes.
I have a motion to withdraw, Your Honor.
Is she here?
We had some confusion about that. She is here.
Okay.
But I think that, she did discuss with me the bond issue. And, I do show that you have bond violations. However,
Yes.
Your Honor, I think that those were maybe.
Skip test. She was skipping her test.
She had switched devices to companies, and so they had to upload.
No, I know. It's nothing positive. It's skip test. I do have one positive blow on May 3rd. She tested positive on her blow on Saturday.
According to my client, Your Honor, I think it was a bad blow, but I think she immediately blowed thereafter.
I don't see that. I don't see that she blew
Do you
again.
have the report
Yeah,
itself?
I don't have the report, but I just have the incident .03.
Well, could we, yeah, right, and her, you know, the classic, you know, mouthwash issue, but she did re-blow.
I don't see that on here.
So that would, eliminate if.
Well, I don't see that here. I don't see that she blew again. Do you see that?
This is on who it is, who's it on your?
Oh, I'm sorry, Bailey. It's on Bailey on page 2. It's the BVR, the DWI.
Ask the case manager if she sees, normally whenever they do retest, they include that in the DVR.
Yeah, I know. That's what I saw.
I can double check with her.
All right.
She didn't
Now,
call and reported it.
I'll agree. It's a very low amount, .03. It is very low. Very low amount, .03.
Yeah.
All right. Do you still want to withdraw on this case?
I need to withdraw, Your Honor. We have a misunderstanding about the case. She thought I was a court-appointed lawyer and I'm not.
Okay. Is she here?
She's here.
Let's bring her up. Miss Bailey? Now, I do see, that you filed a motion to withdraw on one of the cases, but not the other.
I'll file it.
On the MRP, you haven't filed it. And I'm assuming the MRP is a result of the new case. Let me see. Yep, it is. All right. All right, ma'am. Is it Antoriana Bailey?
Thanks for you.
Antoriana, Miss Bailey, you're here with your attorney, Miss Sims. I'm going to address the first part of why you're here. Your attorney, Miss Sims, has filed a motion to withdraw off your case. She wants to get off your case. Okay. And whatever issues you might have, I'm not going to force Miss Sims to stay on if there's some issues between you and her. So I'm going to grant her request to get off this case. So if you would file your motion to withdraw on the MRP, I'll sign both of them. I do see that you did on one of them, but you didn't do on the other one.
I'll file that today.
So go ahead and file that and I'll grant your request, and I'll allow you to withdraw from that case, or both cases. Now, as far as I'm concerned with Ms. Bailey, you are excused, Ms. Sims, so go ahead and take care of your other case. And then I'll speak to Ms. Bailey about another attorney, okay? Thank you. Ms. Bailey, you no longer have an attorney, so there's 2 options regarding a lawyer. I can reschedule you to have an opportunity for you to hire another lawyer, or you want me to appoint you one. I will appoint you an attorney on 2 cases. Now, before I do that, there's one other thing that I need to address. Millie. Oh, I'm sorry. Whenever you finish, I'm ready. I do see that you are charged with driving while intoxicated. You're on probation for DWI. You picked up another driving while intoxicated. You are on bond conditions on your driving while intoxicated, in which you have to blow on an interlock device. Okay. And I see that when you blew on your interlock device this last time on May the 3rd, it tested positive for alcohol on your breath. Okay. Now, don't have to say anything, but are you aware that you have to blow again? Every time that your machine. I'm sorry, was that?
I thought like if it's your big bill, just like saying this, I reached out to my.
Blow again. Now, here's the deal. That machine tests for your breath and it tests for alcohol, but it cannot distinguish alcohol from an alcoholic beverage or alcohol from something else like medicine. Okay. So it can't tell the difference. So we require you to blow 3 more times after the first time that indicates a positive test for alcohol. And the reason we do that is to make sure it's not something else. Now, what I see here is the amount that you blew is a small amount. That leads me to believe it's possibly not alcohol, but we don't know because you didn't blow again. If you would have blown again, and then the second or third time that you blew, if I noticed that it went down, we can probably say, nope, that wasn't alcohol. That was something else. Okay. So I need for you to understand, Ms. Bailey, every time you blow, if it indicates a beep, possible, you need to blow 3 more times after that. You have to wait 5 minutes each time. You blow, wait 5 minutes, blow again, wait 5 minutes, blow again. 3 times, remember, because otherwise we don't know. So I just wanted to bring that to your attention. Secondly, I see for a period of 1 month between April 4th to May 7th, there was 23 times that you did not blow on your machine. Okay, yes, ma'am.
Yes, Judge. I see that she filed for trial stating that since she's on probation for the other case, that she thought she wasn't supposed to use the other device. And so she kept blowing on the one that she got under probation, and she thought that pretrial would have access to those files, but we don't. So the case manager told her, admonished her about having to use both devices in that case.
Did she have an interlock in a car and a probation?
Portable, yeah.
So she got portable on the probation, portable on this, but the same machine, right? It's the same one?
Like at first I was in sober court, so like the device, I went back to Lifesaver, and when I got their device, they didn't add pre-trial, so I had to file for reporting.
I know. You only have one device though, right?
Yeah, I only
Okay.
have one.
All right, so here's the problem. Unfortunately, you fell in one of those cracks. That's kind of like that we can't fix. You've got probation conditions and you have bond conditions. They're separate. One doesn't have to do with the other. There's 2 separate things. Okay. So I understand that when you are on probation, they tell you one thing, but that's for that probation. So just to be on the safe side, if you blow and it takes positive, blow again. Don't worry about it. Just blow it again. Okay. And hopefully you'll be okay. Now we're gonna appoint you a lawyer on both cases. Okay. And then make sure, because I don't want to see another report. Is your machine working now? Okay, I'll just make sure it's working and you haven't had.
Lifesaver.
Okay. And have you had any problems blowing during the time periods that you're supposed to blow?
No.
Okay, because you have to blow 3 times a day.
They had like 4.
4, okay. Well, just make sure you blow every time during that period, okay?
Okay.
All right, any questions, Ms. Bailey? You don't need to see her, right, Ms.?
No, you're
Okay, all right, just have a seat. I'll appoint your lawyer. Millie?
Yes, ma'am.
Page 1 and 2, Bailey, court appoint 2 cases.
Thank you.
Okay, yes, sir, come on up.
Thanks, Judge.
How are you?
Well, that's the reason I'm here. Because you're doing great, right?
Another case, another court. This case is on your docket tomorrow is a DWI, and it's the only, and it's set just because there was a bond violation. As I understand.
I need a case number.
It's 253-9185. Unusually high below and then, as I understand it, he passed it a short time thereafter, so I checked with the lady here, said, look, I need to check with the case manager first.
I do see interlock. I do see that he had a high breath on the interlock on May the 2nd.
Exactly.
And then, let's see, May 2nd was a Friday, but I don't see that he blew again. Okay.
It's set, he has to be here.
Yeah, he's set to be
For
here.
tomorrow, I would ask, I need a week, yes, next week. I started yesterday, my heart is going like I was running 100-yard dash.
Oh, okay.
And that's never happened before. I need to, of course, I've never been 78 before. So I've got to go deal with that.
No worries. All right, let's do this. Do you have contact with your client?
Yes, I can.
Can he be here next week?
He can be here next week.
And what day?
Here alone.
No, I know. I like for you to be present also.
Oh.
What day next week are you available?
I am.
What day next week?
I'm still alone.
Well, I hope so. What day are you available next week?
The week, you name it, Judge.
I mean, I'm gonna be here every day next week. Between Monday and Thursday,
So you just got wanted to.
because we can't do Fridays.
Okay. Let's just,
That's
let's do,
it's the week of the 19th.
it's the week of the 19th.
Yes, sir. May 19th to the 22nd.
Let's do Wednesday.
21st, okay.
First.
So get with my coordinator,
Okay.
give her the case number, and tell her to off docket it till May 21st.
I'll do it, Judge. You got it. Thank you very much.
Ms. Siegler, were you able to talk to that complaining witness?
Yes, sir.
Okay. Well, let's see, you want to continue the case because it's set on the docket for today. Do you need to get with the state is it Ms. Pybus to let her know?
Yes, sir, and I spoke with her, but she was still thinking about what
All
offer.
right, let's reset it. We'll reset it. Okay, thanks. But you have her notes there where she can see, right?
Yes.
Okay, thanks. Okay. Oh, yes, ma'am.
On Swedes.
Okay.
My Swedes.
Yes.
Jail though.
Yes.
You ordered.
Oh, that's right.
No contact?
Yeah, let me see.
I'm not mistaken, no firearms, no.
Okay, yeah, no contact with the complaining witness and no weapons and firearms. Let me see, I think he's 18
But no.
and also no alcohol and controlled substances.
Okay, perfect.
Thanks.
Thank you.
Thank you. And Nancy, there is on Bailey on page 2 on her DWI second, there is also a motion to withdraw. If you can put that one on my, oh, it is, thanks. Because she filed 2 of them. She filed this one. Yeah. Let's see if I need to talk to anybody else. Joseph Franklin? Yes, ma'am, Mr. Ray, you need approach?
I do, Your Honor.
Yes, ma'am.
I got a good one this time.
Oh, okay.
A real one. Anthony Harris, I just received him.
What's the last name?
Harris.
In custody?
Last name, yes. Apparently he was bond forfeited on the 9th for not being present, and he was actually in medical at the jail.
Oh, I see. Let me look at it.
So he's got a good excuse.
That is a good excuse. Hey, you 1 for 1. That's not bad. That's not
It's a
bad.
better argument than my last one, but I'll take what I could get.
All right, so did he get detained again for some reason? I guess he got rearrested again.
My understanding was just that there was that bond forfeiture from the 9th, Your Honor. Beyond that, you're already ahead of me.
Yeah, let me look at it real quick.
All right.
Oh, this is the only case he's got.
He seems eager. He said he just got out of state jail, so he's kind of eager to resolve.
All right, so he bond forfeited in 2022 though, right? That's what I see, 2022
On the same case?
on this case. Yeah,
He was spent in state jail, Your Honor, in Paris, Texas. So that the only thing I can think of is that he was still in custody back then. We just didn't have a hold on him. He's telling me he's been in custody for some time now. And then he just got out of state jail when he got picked up on this, probably an open warrant because they didn't put a hold on him in state jail for this case.
well, I see a 2021 conviction for possession of a controlled substance where he did 2 years.
That's probably what he's referring to.
But that would have been over with by the time that he got arrested on this charge. So he was free when he got arrested on this charge, March of 2022. So he was not at TVC. He might have been on parole, but he wasn't detained. And then he got released on this charge on March 15th of 2022. And he was requested to come to court March 22nd of 2022, which he did. Then we rescheduled this case so he can get a lawyer to May the 9th of 2022. And May the 9th is when he bond forfeited.
And it doesn't show what he was in custody for prior to,
Doesn't say
okay.
he was in custody. Then he looks like he got detained again in May. Looks like possibly May 9th.
Okay, so he was in custody on May 9th then, but for something else.
Yes, I'm assuming it's either this case or something else, but I don't know. Unless he had something else pending, but I don't see anything else pending. So probably what happened is somehow or another, he got the attention of law enforcement. They found the warrant and said, let's go. He took him in.
He has what he's reporting to me, Your Honor, is that he has a heart pump and he has the device on him, that he was in medical getting that installed on the 9th. So I'm not.
Oh, he was here on the 9th, but he bond forfeited in 2022.
Okay.
So, he didn't show up.
I thought the bond forfeiture was from the.
No, that was 2 years ago, actually 3 years ago that he bond forfeited. So he's been out free for 3 years until he got the attention of law enforcement and they put him back in. So I do see that he did go before the magistrate. He does have a bond. And don't know if he can make it, but he does have a bond.
Okay, let me go check in with him and see. I guess I'll speak with the state too and see if he had a hold during any of that time.
Okay. All right. And then just let me know.
He's been in and out.
Oh, I'll be around.
So will I, Judge.
Okay, thanks. Okay.
I will just tell me like, it's like he's been in and out.
And the Siegler. Also, I sent you an email about a non-disclosure.
Yes, sir, I'm unopposed.
Okay. James Hawthorne, are you here? You know Mr. Hawthorne? Come on up. I tell you, I keep forgetting about you. I apologize. What's going on with your license?
got on the payment plan.
Okay.
And, but they just sent me like 3 days ago, they just sent me and said I had 2 more owes.
Oh, God. Really? Did they tell you how much?
I gotta figure out what that said about.
They didn't tell you what it was?
They told me because I had criminal and misdemeanor, they said it might be from another, like a substation. I think like,
Oh, God. Do you think it's tickets?
Yes, I know it's tickets.
It's just money?
Yes.
Oh, God. Okay. So, all right. So do you want me to just give you another date?
Yes, sir.
All right. I don't mind giving you another date. I know, but do you think that you can pay them? You think you can pay all? Because that's a lot.
I have to pay that.
Okay. All right. Tell you what, no worries. Have a seat. We'll reset your case. Page 7, Hawthorne, he's supposed to say, let's reset him again. Let's give him at least a month or so. He's trying to get his license.
Okay.
Yes, ma'am. Oh, yeah. Oh, yeah, let me talk to him, yeah. When we set him. Because the state, I don't know what they're gonna do in that case, but we're gonna reset that case. I gotta talk to his son and tell him we're resetting it, and they may or may not dismiss it. We'll see. So, let me see, yes. On Martinez, we're gonna reset. That's the one, that she's in ICE custody.
Okay.
It's on page 12. Yeah, and I'm gonna tell his son,
We can't transfer
we're
straight.
gonna reset it for a month. Can you give him a copy of the son?
Yes, and would you like a bond forfeiture or
No,
something?
no.
No, just.
What, SFBF, I guess, I don't know, what do you want to do? Let's just set him for a range.
Okay, we'll continue with the
Thanks,
arraignment.
man. Jonathan Martinez, just stay there. We're gonna reset your mom's case. In a minute, they're gonna call you up with the date, okay? And then, like I said, just see if you can get the hold of a lawyer and just let them know if they can come, they can zoom in. And I just need to know what's going on. Okay. Okay, I appreciate it. So just hang tight. We'll get you out of here in a minute. Yes, ma'am.
Page 17, Goldie Needle. He's not mine, but he says he needs more time to hide. Do you still want to talk to him? Or do you want me to do it?
Oh, no, you can reset him.
Okay.
Let's see. Thanks. Yes, ma'am. I'm sorry.
The plot thickens.
Oh, yeah. The plot thickens. Yes, ma'am. Miss Anthony.
Judge, so on Mr. Harris, Antheus Harris, it does look like from 2022 to 2025, it's when he was in custody
Oh, yeah?
in Anahuac.
Oh, Anahuac.
He referred to it as Paris. I don't know what that area is, so I'm
Chambers County, yes, I'm not
Chambers County.
sure where that is.
Chambers County. You been to Chambers County?
only once, Judge. I never went back.
That's a long drive.
It is long.
It is a long drive.
136 and kept going until I couldn't, there's like a stop sign, 50 miles.
It's like I-10 east and you keep going and then you take the exit, whatever exit that is, and then you go south another 100 miles or something like that. I mean, it's a long ways. I know. I hear
But
you.
the good news is he couldn't show up.
All right, so let me look at it and I can probably reinstate his bond. Let me see. All right, so Nancy, page 27, Harris, and this is Antheus Harris.
Yes.
Let's reinstate his bond.
Yay.
Now, I need to give him bond conditions though.
Oh.
No. Apparently there's a complaining witness.
They haven't been able to do the call yet, Judge.
But just I have to believe he doesn't know who they are, your client. I have to believe
I'm
they
not
don't.
based on the case.
So just tell him no contact with the complaining witness.
Okay.
Oh, this happened at the rodeo?
Yes, it looks like the complainant might have been a security officer.
At the rodeo?
What happened at the rodeo stays at the rodeo, Judge.
Just no contact with the complaining witnesses.
Just saying.
And no weapons. I know. So Ms. Garcia,
Yes, Your Honor.
Harris on page 27, Antheus Harris,
Yes,
no contact with the complaining witness, and then no weapons.
yes, Your Honor.
That's
They
it.
can't go to the rodeo.
Nah, I'm not gonna do that. Just tell him to behave. 44 years old, so.
Not everybody grows up at the same rate,
Oh,
Judge.
I hear you. All right, you got it. And then just tell Millie that he'll be released, or just say he'll be released and we'll reset him. Okay, you got it. Hey, that's a win. How about
One
that?
out of 3 is not bad, Judge.
No, not at all. Yes, sir. Morning.
Marisa Esparza.
Esparza, okay. Now I've spoken to Esparza already.
Have you spoken to her?
Yes, I spoke.
Okay.
I was just wondering if the board would be open to hearing phone calls again.
Yeah, in fact, I think this was it was kind of iffy. I don't mind hearing probable cause. So Miss Anthony,
Yes.
Esparza,
Yes.
let me hear PC. Now, let me just preface this. I don't know if you saw the report or anything. Allegedly, she was going to be detained and arrested for PI.
After she was escorted from the bar, that she voluntarily left.
Well, but they were going to arrest her for PI.
Yes,
That's what I heard.
Didn't see any facts that were kind of articulating the fact how alone she was, why that was necessary.
I mean, was this Pasadena PD? No,
It's
HPD. Okay, so let's hear PC on this one.
Yes, Judge, and I can read directly from the DIM.
Okay.
On Sunday, May 4th, 2025 at 1:38 a.m., officer was dispatched to a disturbance at a bar in Harris County, Texas. Officer arrived at the bar and located the defendant at a bar by the name of Hugh O'Connor. Manager pointed the defendant out to officer, identifying her. Officer instructed defendant that the owners of the bar needed her to leave the establishment. Officer escorted the defendant outside of the bar to further continue a public intoxication investigation. As officer was trying to gather the defendant's information, such as name, date of birth, driver's license, defendant refused multiple times to identify herself. Officer was conducting a public intoxication investigation to transport the defendant to the sobriety center. In order to book the defendant into the sobriety center, defendant must be identified with a name and date of birth. Officer tried multiple times to retrieve identifying information and was refused on every attempt.
So the one to articulate that the defendant's level of intoxication was the level of needing to arrest her and take her to the center.
Well, they weren't going to arrest her. I'm very familiar with that center. I don't know if you're familiar with that center at all. Okay, so here's what happens.
I understand things.
What's that?
You get taken there, you sober up.
Exactly. It's a center and it's located downtown. And what they usually do is they transport individuals that they believe are intoxicated so they could sober up. But it requires them to be detained. It's like they're arrested. They're handcuffed. They're physically handcuffed. They're placed in the backseat of a patrol car. They are, in essence, kind of like almost booked in, but not necessarily booked in. They check their records, et cetera, et cetera, et cetera. And then when they get to the intoxication center, they have to have all that information to be inputted. So all of that's inputted into the intoxication center. And then they have a place for males and females separated. And so the males go in one place, females go another place, and they have cots there. And they basically said, there's a cot, there's a blanket, there's a pillow, go, get sober. And then they check on them. And then when they believe that someone has sobered up, is good to go, they'll say, okay, you're released. And then they kind of do like a discharge. So all of that requires, yeah, exactly, identification and all of that, yes.
And you're kind of my feeling that, without any reason to actually arrest her.
Well, she wasn't going to be arrested, I know.
Another thing, she didn't give her name, so does she necessarily have to give the name?
Yes, she does. Yes, because they have to, it's basically they have to book her into the intox. I know you've never been there. I've been there. It's kind of actually good. It keeps people from getting arrested and charged with. Yeah. And sometimes they'll arrest someone that they might think was driving while intoxicated, but can't really prove it. And so they send them over there too. So, I mean, I'll be honest with you, it's a really good program. Yeah. And if you go there on Friday or Saturday night, it's packed.
Yeah.
Unfortunately. I don't know if you've ever been there, Ms. Anthony.
I have not.
You ought to go. It's downtown. It's just very interesting. And I mean, it's air conditioned. And so, yeah, so unfortunately, because she failed to provide that information, I want to continue with PC. Get with the state. I'm sure that we can work it out. They'll work it out easily. It's her first offense. Has never been arrested before. I'm sure that they'll probably give you some type of PTI or something. Okay. All right. Don't worry. You got it.
All right. So we need to do
Yes, sir. No, it's been established.
So maybe.
All right. Yes, sir. Thank you. Yes, sir. Good morning. What you got, sir?
Mr. Fulton, FUL. All right, let me see here, Mr. Fulton. See what's happening with Mr. Fulton.
Yes, a lot of arguments.
Got a lot going on. Is he in custody? All right, let me see here. Okay. All right, he's got 1, 2, 3 cases. Yep. Mischief, assault, terroristic threat,
Yes.
and a felony.
Fourth, I think it's 4 pending felonies also.
Oh, God. He sure does. Boy.
So BBRs came from all the cases.
All right, so it looks like he got arrested for a new charge of evading in the 232nd. Oh, God.
Yeah.
Yeah. So he's on bond for assault, on bond for criminal mischief, and on bond for terroristic threat. And then his criminal mischief is fairly new because it was a 2B warrant. And, oh yeah, you're right. But he got the attention of law enforcement because of the evading. So that he got charged with evading, and once he got charged for the evading, they found these 2B warrants.
Yep.
Oh, including another evading too. He had a 2B warrant for evading.
Exactly. I'm saying a lot going on.
Oh my God. All right, let me see, check. The BVR that he's under is, let's see, it's the, I think it's the assault one.
Yeah.
I just need to check the date that he was given these bond conditions. Okay, he was given bond conditions February 7th. And so the other cases occurred after he was given bond conditions.
I hope so.
All right, well, unfortunately, I'm gonna have to revoke Mr. Fulton's bond on the assault. And then just reset his other cases because he's got 2 $5,000 bonds on the mischief and terroristic threat, and he doesn't have any bonds on his felony yet because he hasn't gone to court. All right, just pick all 3 of them, or reset all 3. I'm gonna revoke his assault bond, assault bond, and then I'm assuming he won't be able to bond out.
All right. All
right.
Let's do what we can.
I know, just reset him. You're good to go. Thank you. You're welcome.
It's time for me. I'll make the motion to hire a thank you. Thank you. It's just And so maybe the seat already, yeah, I didn't want to somebody else. Okay, all right, thank you. Start, you can come up to me. We're gonna go say my G, should I watch this again? No.
So I should have a message from yes. With the letter and place the content.
And I'll enter them out, some of them are not. So, if we set another number two. I was just not here, that's not a great. I told you. But it's all. Right.
It's still the same.
Yes, ma'am. Yes, ma'am.
I have a complaint with
What?
that wasn't signed
By anyone? Okay.
But it's usually when that happens, I mean, from like there was a probable cause or for some reason they didn't sign it.
Okay.
Do I have to sign it or?
So what is it now? It's a 2B?
Yes, it's a complaint to be, it's in our two, but it's a hearing officer.
Yeah, that's what I say.
All right, put it on my queue. I'll look at it and then I'll decide. That's on Singleton?
Yes.
I saw that. I see that. I'll decide, whether to sign it or not.
Yes.
All right, thanks.
And then also, even if that's a more, I don't know if you remember that one, it's the motion for the child one.
Oh, is that the one that Marcus Fleming?
Yes.
Oh.
He wrote his motion for the child,
Okay.
he has an approach, so I'm not sure we want him to.
Yeah, put on my queue, but he needs support so I can give him a date.
So I just wanted to double check on this.
I'm not sure. I'm assuming he's gonna be here sometime this week or whatever.
Do you have any?
I mean, I'm gonna grant it, but he still needs to approach.
I'm gonna give you the last.
So, and then for the motion for the withdrawal, with more consistent, but one, instead of seriously or just doing regular.
Just a regular. I don't need the one on the hearing date. Just a regular one, but I do need for him to come so we can give him a date.
Yeah.
Just like the worst. Is that you know what they talk about?
You go to check. Yeah. Oh, probably dealing with the cycle of violence again. Yeah. You can self-refer. People.
I signed everything.
You can socialize everything, but it's no, you directly. They're not gonna be a few times last grade.
Yeah, and then like, you know, PTIs.
I'm being required because it is your mom.
Yeah.
And she was taking.
You can still target it away.
Yeah.
How do y'all do it? It's like an application.
Yeah.
They never get looked at. It never gets, yeah. It never gets. Yeah.
Okay.
Then he started going to.
Melly?
examine and confront any witnesses, the state will call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, we're ready for sentencing. There's no reason not to.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. As far as the gentleman that no contact with, and I told the prosecutor at the end, he is the father of her child.
Mhm.
So there has to be contact. This is a situation where they were trying to, I guess, do a business that didn't work out too well. She does have a marijuana problem, not a cocaine problem, but she does have a marijuana problem. She's been smoking since 16. No cocaine though. That was for sale. I'd like the court to take into account and ask for 4 years instead of 5 years, lower the community service and probate the fine because she's court appointed and she has she's a single mom. She has no money coming in from the father, I guess, on a permanent basis for child support. And so I asked the court's consideration in those matters.
All right, how old are you? Where's your child? All right, and how old is she? All right, so basically the grandparents are taking care of the child. No, but do you and the father take care of her?
Yes.
All right, so how are you all taking care of child when you're using marijuana and you all have all this cocaine in the vehicle and a gun? So I'm telling you right now, if your child were in that car, ended up using the gun, accidentally killing themselves or killing somebody else, you would be boo-hooing, asking for a GoFundMe page for a funeral. And then you're using cocaine, and then you can't stop using marijuana. If you're drug tested today, what are the results going to be? All right. How often are you using marijuana? All right. So here's the thing. I'm going to grant your application for probation. I'm trying to discover what conditions to place for you. So how often are you using marijuana?
It's slow down a lot. I wear some.
And what do you do for work? That's the new West telemarketing.
They do it at home, she says. I've never heard of that, but maybe that's why they get so many hangups on my phone.
All right. And how far did you go in school?
When I was
All right. What are you planning on doing with the rest of your life? What's your dream job?
I wanted to do in the office, like this, like she was saying.
All right. Well, what I can tell you is I'm not going to allow you to have contact with Stephen Palacios Cruz, it appears to the court that the grandparents are taking care of the child anyway. And on it,
She just.
when you all are riding around with drugs, marijuana, and guns in a vehicle, where was she? With his mother. So basically you have grandparents who are being parents, and I'm sure they are just devastated with worry whenever your child is along with you two, because you all are doing crazy things and you both have a drug issue and then trying to sell cocaine. Not going to happen in this court. Is Child Protective Services involved? I don't know why they are not, but that's not my call. I can't pick up the phone and call them and tell them, hey, look at these people here who need Child Protective Services in their life. All right, this is what the court is going to do. There's a $2,000 fine that will be probated. 6 years deferred adjudication. If she completes everything early, I'll consider early termination.
She's gone a little bit more than the state asked for, but you can get off early if you do everything.
There should be regular reporting by Zoom or in person. There should be regular random UAs, tests for levels, do a referral to felony drug court, and a TAP evaluation out of custody. There's to be no unsupervised contact with minors.
With who?
With minors. So you're not to have unsupervised contact with your child until you test negative.
That means your mother has to be present while you have the child.
I just.
Okay.
See, as I said, the grandparents are taking care of the child. I don't know what's happening with this generation. There's going to be field visits 1 time per month until further notice. There's going to be 200 hours of community service restitution. 100 hours will be waived upon completion of parenting classes. The other 100 hours will be waived. I'm requiring parenting classes, but the other 100 hours will be waived if you obtain some type of trade school certificate or complete some higher level of education. There should be no contact with Stephan, STEPHAN, Palacios Cruz. There should be 120 sober meetings in 120 days. Proof of employment within 30 days. There should be no employment as a home health care provider or with minors, and to follow all TAP evaluation recommendations. There's to be restitution to SAPD for drug testing. Probation, is there anything else? Yes. And then before she has the unsupervised contact, come back to the court to remove that.
Would you consider your contact order at that time also, or?
With regards to the defendant?
Stephan?
No.
That's the father of the child. I don't know.
Yeah, that relationship is not working out for you, and maybe it's working out for you, it's not working out for your child.
You understand? Do you have any questions for the judge?
And basically it appears to the court that the grandparents are raising this child anyway. You all are just fly-by-night people who happen to produce the child. Probation, is there anything else? Okay. Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. I'm going to tell you what I would always tell my clients on the family law side. Where you are today, hopefully is not where you're going to be at the end of everything. Everybody hopefully is working on improving themselves. Do you understand? So you need to work on improving yourself for you and for your child. If your goal is, you know what, I love this Stephan guy, I'm going to ride or die with him, then you need to excuse yourself from your child's life, write her a little letter explaining to her when she's 18 that you chose this man over her and that you're just going to be the fun person who comes in once in a while and gives them a gift. But don't keep breaking their heart by doing the wrong things. Do you understand? All right, good luck to you.
Thank you, Judge. May I be excused?
Yes. All right, this is the last case before we take our recess. Veronica Wicks.
Ready, Your Honor. Your Honor, I have a meeting. Do I come back at 1:30?
Yes.
Okay, I'll tell my client.
Sure.
And I'll come back at 1:30.
All right, thank you.
Thank you.
All right. Hi. Court is calling 2025 CR 003243 State versus Veronica Wicks. Am I pronouncing your name correctly?
Yes.
All right, could I have parties announced for the record? State,
Andrew Harris Edelman.
defense,
Fernando Ramos for the defendant.
and are you Ms. Wicks? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Is there an application in this case?
There is, Judge.
I don't have an application. Did y'all file an application?
We did, Your Honor.
I have it.
Okay.
All right. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand, counsel? Did you understand that if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine. Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Wicks, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state recommends deferred adjudication. They will take in consideration NIMAG number 761063. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
None.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offers exhibit 1 and attachments.
No objection, Your Honor.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We waive our right to have a PSI and ask to be sentenced today.
All right, anything you wish to say on behalf of your client?
That my client was born in Arizona, lived in Bear County for the last 9 years or more. Is employed in landscaping, that he and her husband. Has no children and hopes that you grant this application.
All right, is that true? You have no children? All right, what are the ages of your children that you do have? I'm sorry? I know you're saying you don't have any of them with you, but what are the ages? So you have a total of 2 children? Who are they with? So have they been adopted? All right. And what is the writing on your face? Okay, and who is Victor Castillo to you? All right. And does he have any children? And what are their ages? Okay. And other than this landscaping business, do you have any other employment or means of support? All right, so you're going to have to get employment. Is there a reason why you're not working? I'm sorry, what? Okay, I'm so sorry. My allergies are acting up. Would you repeat that again? All right, are you a citizen? All right, so why are you getting paid under the table? All right, so here's the thing. I know that sometimes people do this under the table thing, but that's going to catch up to you. All right, so you're going to have to get your ID and whatever else you need so that you can stop being paid under the table. Because when people are paying you under table, who knows? Maybe they're not paying you what your value is to the company, because they can do that because you don't have any ID. And their whole thing is, who you're going to tell? You're committing an offense by accepting payment under the table. You understand? And you live with this Victor Castillo? Who all lives in the household?
They live in my house, and then his boss and his wife and his kids live in New York.
The boss's wife?
Yeah, the boss family.
And their children? All right, this is what the court is going to do. The court is going to sentence you to 5 years deferred adjudication. If you're drug tested today, what are the results going to be? All right, there's going to be regular reporting by Zoom and in person, regular random UAs, a TAP evaluation out of custody, follow recs. We'll do a referral to felony drug court, proof of employment within 30 days, no employment as a home health care provider or with minors, no contact with minors, field visits 1 time per month until further notice, 200 hours of community service restitution, 140 sober meetings in 140 days. And take in consideration NIMAC number 761063. Probation, is there anything else?
You said 120 as far as the service hours.
200 hours of community service. Yes.
Nothing else there.
Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. To be successful in this courtroom, communication is key. If there's an issue, let probation know. If you feel they're not addressing it, you can always come to court. And I will tell you, I'm not a doctor, but methadone, That's not supposed to be a life. You're on it for life. You understand? So you're going to need to start doing your sober support meetings and getting with the sponsor. All right. I don't want you to be one of those persons who ends up in prison for the rest of their life, or somebody has to identify your body. You understand? All right. Good luck to you. You're welcome. Thank you.
I apologize, I misunderstood my client, Judge.
Oh, no problem.
May I be excused?
Yes.
Thank you.
All right, everyone. The court is going on recess to
county, but you're still ultimately responsible to our probation department, okay?
Yes.
I want you to maintain your mental health compliance.
Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
June 16th at 1 p.m.
June 16, 2025, 1 p.m. Pardon? I don't have a probation intake? Okay, all right. We'll make sure to get that set up. Okay? All right. Bond will continue. Thank you, Mr. Bean.
Thank
You
you.
doing okay?
I'm doing okay. Yes, sir.
All right. Good night.
Thank you.
Take care.
You too.
Court does call the case. People versus Anatoly Zubrishik.
Ally's on
Oh, I messed that up.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Zubritsky, who appears via Zoom. Sir, please unmute and state your name for the court.
Anatoly Zubritsky.
Thank you, Your Honor. Today is the date and time set for sentencing. We have had the opportunity to review the PSIR as well as the recommendation from probation. We have no changes to the PSIR and are respectfully requesting that the court adopt probation's recommendation. As to the fines and costs and probation oversight fees, we are requesting if the court would consider allowing Mr. Zubritsky to pay that and a payment plan as arranged by probation. He did serve some time in custody. He is back to work now, however, but we're asking that be allowed to be on a payment plan. Otherwise, we would ask the court to adopt this recommendation.
We did cancel the warrant.
Correct.
All right. Sir, is there anything you want to say before I impose sentence?
No, sir. And I actually start a full-time job tomorrow. So I have a part-time job, which I work like maybe 10 hours a week, and I start a full-time job tomorrow. So I can definitely pay the $100 that was used for my bond. My mom said that was okay to use as well.
Okay.
And that's it, sir.
Thank you. Sentence of the court, place you on probation for a period of 60 months. You're to pay $655 fines and court costs or court costs and state fees, $1,800 probation oversight fees. We will apply the bond and then a payment plan will be arranged by probation. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a domestic violence program as directed by probation. There's to be no contact with Molly McIntyre. You're not to go to the residence or employment of Molly McIntyre. Do not assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. Do not possess any weapons, firearms, or ammunition, or anything fashioned to be a weapon. You are to report to probation as requested by probation, including any home visits. You're to comply with all circuit court orders, if any. Your GPS tether will continue. I'll set a review hearing in this matter to be held July 14th, 2025, 1 p.m. I will order 365 days in jail, credit 39. The balance is suspended.
Thank you, sir.
Thank you.
Thank you, Your Honor. Mr. Zubritsky.
Thank you.
Court calls the case, People versus Robert Anderson.
And then on behalf of the people, Your Honor, the Public Defender Natalie Pate with and on behalf of Mr. Anderson, who should be present via Zoom. Sir, please unmute and state your name for the court.
Teresa Blair on behalf of probation. Your Honor, today, he has completed all terms. I got verification that everything has been completed with his probation. Generally, I would have waived his appearance. He did indicate that he wanted to address the court today, however, he's in an interview. Or had an interview today, so I told him to go do that. Probation is recommending, given that all the conditions are completed, that the court discharge him from probation with improvement and close out the case. I will pass a message along to the court that he's very thankful that this court gave him an opportunity and a second chance when he did screw up earlier along the way. And he did want to come and address the court and thank the court for allowing him to do that. However, he needed to do the job interviews.
Tell him, it was certainly worth it for me to be able to give him that opportunity because he made it through it.
Okay, I will pass that along.
And he's more than welcome. Do you have any objections to waiving of your client's presence? I will discharge the defendant from probation with improvement and close this case. Court does call the case of the people versus artist Valentine Lewis.
And then on behalf. Good afternoon, Assistant Public Defender Lauren Kearney. On behalf of Mr. Valentine Lewis, Your Honor, Mr. Valentine Lewis was transferred to Wayne County. He did pay, or someone paid, the $75 in restitution that was ordered last week as bond.
All right. So then, that's the only thing that was owing, was. So I went and canceled the show cause. Pay. I'll indicate, I'll cancel the show cause, pay the $75 as restitution to the victim. Wonderful. Court calls the case, people versus Darnett Blackwell.
And then on behalf of the people, Your Honor, Public Defender.
Clear on behalf of probation. Your Honor, Mr. Blackwell is scheduled before the court for review hearing. Is compliant with all terms ordered by the court. Probation is recommending that all conditions continue with the next review hearing being set August 18th, 2025. No objection.
So ordered. Court does call the case of the people versus Conjewel Burton.
And then on behalf of the people, Public Defender, on behalf of Mr. Burton,
Teresa Clare on behalf of probation. Your Honor, Mr. Burton was scheduled before the court for a review hearing. He is compliant with all terms ordered by the court. Probation is recommending that all conditions continue with the next review hearing being August 18th, 2025. No objection.
So ordered. Court does call the case of the people versus LaRue Edward. Or Edward.
and then on behalf of the people, Assistant Public Defender, on behalf of Mr. Edward, whose appearance has been waived.
Teresa Clare on behalf of probation. Your Honor, Mr. LaRue was scheduled before the court for a review hearing. He is compliant with all terms ordered by the court. Probation is recommending that all conditions continue. Set August 15, 2025 at 1 p.m.
No objection.
So ordered. Court does call the case, people versus Juan Orsorno.
And then on behalf of the people, good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Osorno, whose appearance has been.
Teresa Clare on behalf of probation. Your Honor, Mr. Osorno was scheduled before the court for a review hearing. He's compliant with all terms ordered by the court. Probation is recommending that all conditions continue with the next review hearing set August 18, 2025 at 1 p.m.
No objection.
So ordered. Court does call the case, people versus Maurice Couch.
And then on behalf of the people,
Teresa Clare on behalf of probation. Your Honor, Mr. Couchman was scheduled before the court for a review. He is compliant with the terms ordered by the court, and I did waive his appearance. review. He is compliant with the orders by the court, and I did waive his appearance.
I understand that, but.
You want another PSI?
Yeah,
Why?
that's what he would like to do. That's why we pled to the one charge.
I know, but why don't I'm not gonna get any new information from a PSI that I don't already have from an ILC assessment. We got an updated assessment while he's been in jail the last week, right?
Yeah.
Didn't they come over and assess you?
Yes. And I haven't seen that, Judge.
Well, okay, I'm not gonna follow the assessment, Mr. Hulbman, because the assessment says that they want him in residential treatment.
Right. I'd prefer to have the PSI, Judge.
I'm gonna hold him.
I want to get sentenced today. I can't control that. I can't control that. You want to see what the judge is going to do? Your Honor, when I spoke to him by pleading to the F5, it was his understanding, he does have a spouse that is sick up in Michigan, and he also has a business up in Michigan.
I understand.
And all I said to him, I said, basically, we do the F5, they're going to order a PSI. I was under the impression that you were going to order a
Usually,
PSI.
okay, and again, I understand
And that we would be back about 30 to 40 days.
I understand that, but my.
At least to get a stay to situate myself.
Let me just say this. I have a full ILC assessment that's already been completed. Just and remember, one of the discussions we had 10 days ago was is that the drug and alcohol assessment was, they recommended no treatment because you weren't entirely forthright with the assessor. True?
I told the assessor,
That you said that you hadn't used in 3 years.
I've been clean off of heroin, sir, for.
Okay, but now
3.5
we're talking
years.
about cocaine. And on top of all that, at the time you represented that to me 10 days ago, I already knew that day you had tested positive again for cocaine.
I've used once, I've had one relapse.
And
of
you got
cocaine.
caught one time. Hey, let's not go off
Year and a half ago.
Mr. Millay, I don't want to go off the rails with arguing with you again.
No.
Just listen to me. I don't know, I mean, I'm not going to get any new information. We're going to come back in 6 weeks for a sentencing hearing. I'm not going to get any new information that I don't have as I sit here today. Mr. Helbing, I'm just telling you.
Understood.
I'm not saying I'm following the recommendation. In fact, I suggest.
I understand that. If the court would indulge us to at least come back for the sentencing and let him out so he can take care of things in Michigan to come back in 6 weeks.
Just on edge of losing my property, my car, my home.
Mr. Millay, it's my intention to release you today if I sentence you. I mean, again, I don't want to.
Your Honor, he'll go along with you sentencing him today.
All right, Mr. Harris, is there anything on behalf of the state before I pronounce sentence?
Your Honor, he has 24 days of jail time credit, requesting laboratory fee reimbursement of $205, Franklin Police Department, nothing further.
Anything else from probation? Mr. Helbing.
Your Honor, I think we said it all.
All right, Mr. Millay, is there anything you want to say before I sentence you?
Just, sir, that I really am a changed person. I've told you from 2021, Thanksgiving Day, I turned myself in to Westchester I can't remember the name of it, to the rehab, but from that day, I've been clean. I had one relapse, and when this relapse happened is when my wife became missing in Florida for a month and a half. She had a stroke, and I didn't know where she was, okay? Then I find her. They find her in a homeless shelter They let her go from this hospital. They told me, I told them I was coming to pick her up, they let her go. Then they take her from the homeless shelter to a hurricane shelter. I lost her for 2.5 more months. I had a relapse. That's where my relapse of using again came. And from that day on, I haven't touched it. For me coming in here on a dirty urine, that's what it is. You take that, I can't defend that, I don't want to. But I'm a guy that needs to be talking to people and changing their lives, not go somewhere to change my life. I believe that.
Mr. Valley, I understand that the heroin addiction that you suffered from probably was very difficult to overcome. And certainly, as we sit here today, there's no indication that you've relapsed that I have seen on heroin. But you can't use any illegal drugs.
Right.
You know, when I'm talking about substance use disorders, I'm talking about whether, I don't care whether it's heroin, methamphetamines, cocaine, marijuana, I don't care. You understand that?
Yes.
All right. Is there anything else you want to say?
No, sir.
Court's considered the statements made here today. The court has reviewed the ILC assessment and will consider it as a pre-sentence investigation, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court does find that you are amenable to community control, so I'm going to place you into community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, and this includes marijuana or THC in any form. You're ordered to successfully complete substance use disorder treatment. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. You have 24 days jail time credit. You're also subject to this discretionary post-release control. Do you want me to go over that with you again?
No, sir.
You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Mr. Harris, is there anything else?
No, Your Honor.
Mr. Helbling?
My understanding is, will they be transferring the probation up to Michigan?
Yes.
So
Okay.
you'll need to report directly to court services after, because there's an application he needs to fill
Yeah,
out.
I've already got a probation up there going on.
Okay, but.
Transfer from here to there.
Okay, but there's a proper procedure, it's called ICOTS, that they have to do they have to do a petition to the state of Michigan for them to accept supervision. So
Okay.
when you get out of the jail, you come over to this building and check it back with court services.
Gotcha.
And you know what happens when you don't check in, right?
Yeah.
Okay, all right, that's all, thank you.
Thank you, Your Honor.
Yes. Is Ms. Smith here? Yes. Mr. Smith. Case number 24CR42188, the State of Ohio versus William Smith. Mr. Smith is before the court with his counsel, Mr. Helbling, Ms. Tranter. On behalf of the State of Ohio, we're here for sentencing. Ms. Tranter, anything on behalf of the state?
Your Honor, on behalf of the state, my understanding is there is a restitution amount owed, in this case, $450 to Kevin Cook. In addition to that, we are asking for an order for release of property that was recovered belonging to the victim Lamont Ellis. It's my understanding that Mr. Smith does have 1 day jail time credit at this particular point in time.
Okay. Anything from probation? Mr. Helbling?
Your Honor, I know I've spoken to Mr. Smith for a while on this issue, and he's extremely remorseful. You have a letter before you. He's sought out treatment on his own. He's tried to stay employed, from my understanding, also. His grandmother has been here in support, his other family members, to support him. He has a good support mechanism. We would just respectfully request that he be placed on community control and allowed to continue to go to his mental health and his other appointments.
Mr. Smith, is there anything you want to tell me?
I just want to say, well, I'm trying to do the best I can, and I want to be able to stay free, like, so I can keep providing for my family in, like, financial ways, and I promise I won't be in this situation again.
All right, court's considered the statements made here today, the pre-sentence investigation, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court does find that you are amenable to community control, so I'm going to place you into community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from use of any drugs, alcohol, or marijuana. There's no THC in any form. Do you understand that?
Yes, sir.
The court's going to require you to continue to with your mental health treatment and your medication management. You
Yes,
don't
sir.
stop taking your medication until your doctor tells you to stop taking it. You understand that?
Yes, sir.
There is restitution, a sum of $450 to Kevin Cook. Who's the co-defendant in this case?
Michael Matthews.
Is he related to you?
Yes, sir.
While you're on supervision, I don't want you guys hanging out with each other.
I haven't been seen him since this started.
You have
sir.
not?
No, sir.
Okay. I'm ordering you not to have contact with him, okay?
Okay.
And the restitution order is joint and several with the co-defendant. The court finds, other than that you're indigent for the purpose of any fines, costs, or other financial sanctions. You have 1 day jail time credit. Now, you're also subject, Justin, you get that back. You're also subject to the discretionary period of post-release control, which means if you're sent to prison on this, upon your release, the adult parole authority may choose to supervise you for a period of up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision if you're sentenced to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have any questions?
No, sir.
All right, I want you to go back down to court services for me, and you're going to talk to the probation officer this afternoon, okay?
Okay.
Good luck to you, sir.
Judge, additionally, we would ask for no contact with the victims.
Okay, no contact with the victims.
Yes, sir.
You don't know who the victims are, do you? Yeah, okay. We're back on the record. John, go ahead. Your cross-examination. Mr. Smith.
Afternoon, Mr. Dodds. How are you? Listening just generally to the things you've testified to here today, seems to me that it would be fair to say that you have a remembrance of some major things, but not a lot of detail. Would that be fair?
That would be fair. It's been 3 years, yes.
And, you know, Mr. Dubs, what we try to do sometimes is, if you look at a document, sometimes it'll refresh your recollection, sometimes not. But that's why we mark these exhibits on those. So if I ask you to do that, maybe I'm gonna ask you to refresh your recollection on something. I want to talk about the school project of building the Performing Arts Center.
Yes.
We'll do that first. The elementary building had just been completed a short time before the Performing Arts Center was started. Is that fair? Or are they same time?
No, much sooner, because there was an entire school year that we were in that building. And then during that school year, we were finishing Performing Arts Center and redoing the wing that we kept. It was phased to do it that way. It was all kind of phased out where there would be certain things that were done because, to be honest, the parking lot for the elementary part of it was actually the staging area for the Performing Arts
For the
Center.
construction. So there was a little overlap.
There was definitely overlap.
Okay. And wasn't there a time near the end of the Performing Arts Center, but before it was completed, that there was a discussion about this exit from the elementary school that had these concrete steps that just kind of came out and kind of went down a really steep grade?
That is correct.
And it was a problem, wasn't
It was a problem.
it? It was a problem to be solved.
It was a problem solved.
And my recollection, you can correct me if I'm wrong, but even the fire inspector said, no, these steps can't stay the way they are.
I don't remember the fire department being involved in that conversation. I think it was more, to be honest, probably Mr. James and I looking at it as kind of the project, directors looking at it and just saying like, this isn't going to work. This is a problem.
And there was no handicap ramp at that exit either, right? The way those steps were.
No, there was a ramp. There was a ramp, but there were steps. There was both. There was both to be a ramp and that. But when we looked at the steps, they were just going to be way too steep. The other problem with that part of it was there was this slope coming down from the sidewalks, and that really kind of invited kids, being kids, to climb up and down those slopes, and it just wasn't going to work. It was an idea that the architects had presented us. Sometimes when you look at a diagram or you look at mock-ups, it doesn't look the same, but once it was physically done, it was like, yeah, this is a problem.
Fair enough. And you said you and Mr. James obviously talked about it.
We did.
There were weekly construction meetings with the architect, project supervisor, contractor, you, and Mr. James. Right?
Correct.
If you would turn in the book you have there, the tab says I, but it's being remarked if you open it up to Roman numeral 9, which I did, Chase did not.
So is that IX, right?
Now, it is IX, yes.
I concur, Judge.
Did you find it, Mr.
Well,
Bell?
when it says I, that's 8, but there's 9 on the next. Is that what you're talking about here?
Yeah, IX.
Okay.
You want me to tell you what they are?
Actually, just if we had to work.
We're trying to, I gave it to them.
Underneath the wall.
You guys got so many papers, you can't find my little piece.
A lot of papers. You said I, correct?
IX.
It's behind tab G, or excuse me, tab I, and then it's IX. Progress meeting agenda, meeting number 42. Do you see that, Mr. Dubs?
I do.
Okay. First of all, this is dated June 13th of 22, correct? Up in the upper left. Meeting date.
Yes.
See that? And then you see that you were present. If you go, it's scheduled attendees, and you're second from the bottom above Ron James.
Correct.
Okay. If you turn all the way, if you look down in the bottom right of these pages, you'll see there's some numbers. You see that 000?
000, like 12?
Yeah.
Yes.
Go to 7.
Go to what? I'm
No,
sorry.
he's looking at the wrong number. He's looking at.
I'll help.
I'm
We
sorry.
use base sample when we get into multiple.
This?
Yeah, go to, at the bottom right, go to, number 7. 000, like 100 zeros.
Oh, okay.
Tell me when you're there.
I am.
I want you to ignore the handwriting on this document. Look at the bottom where it says 14-2 in the left margin, and then number 1 says districts contact for landscaping stone. See that?
Mm-hmm.
And there's no contact, is there? In other words,
I don't.
there's a subject matter, but there's no contact.
Correct.
Okay. Now, do you remember that this June of '22 is when this issue of those steps you're talking about, this slope and all that, is starting to be discussed with the architect, contractor, and project manager?
Well, it had been discussed way before that. I mean, like, there was discussion about this when the elementary opened, because that's where the fire department was involved. The fire department was involved when the elementary was being opened, because, of course, when you're occupying a building, you have to have ways for emergency purposes to get out of the building. And that particular doorway, which was in the early childhood wing, was very concerning because there was a big drop-off. And matter of fact, I want to say, if I remember correctly, we even had to put some temporary tape and some little temporary type
Band-Aids.
Yes, type of things. And but that had been going on for quite a while, because Mr. James and I both were wanting to see those two parts of the project physically connected, but OFCC, which is the state of Ohio, which is the funding for the bond issue, they would not let us do that, because they said if we did that, then we would have to do a completely new master facilities plan, and we did not want to have to go down that road. So it got Band-Aid. That's a good term.
So what happens is, now we're getting towards the end of the Performing Arts Center, which is adjacent to this area,
Correct.
and somebody's got to do something.
Plus,
Fair.
plus.
First, you got to agree with me or disagree with me.
I agree. Yes.
Somebody's got to do something.
Correct.
Okay.
Plus, the other part that we probably haven't said yet, just to make sure we're accurate, is that the wing we kept was going to have elementary students in it. So a connection between those buildings was crucial from the standpoint of not just the performing arts part of it, but the classrooms, because those kids would have to be able to go back and forth between the elementary to eat lunch and so forth. Yes.
So I want you to turn to the next exhibit, which has a J in front of it. It'll be Roman numeral 10, which is an X. Tell me when you're there. It's progress meeting agenda number 43.
40 what now?
3. Next. There you are.
Got it.
Okay. Now, that's dated June 20th. It's the following week from our prior exhibit, right? Upper left.
Correct.
And this, again, these are weekly construction meetings you guys are having. Try to get this project finished, right?
Correct.
Now, if you go to page 6, remember those numbers at the bottom, down at the bottom right? Go to page 6, and it's the bottom of page 6. Tell me when you're there. If you look at item 3 at the bottom under 14.1,
Correct.
open discussion says districts contract for landscaping stone hyphen Doug Reinhardt with a phone number.
Correct.
So you would have been present at these meetings when somehow, for this problem that existed that we've talked about, that Doug Reinhardt's name came up, right? And this is for Broomball Construction, isn't it?
It is. Here's the only thing I want to say. Can I look at something?
Say again?
Can I look at something, please?
Look at anything you want.
Okay. I'm not denying I was there. I'm not denying, but here's the only thing that makes me, when I look at these dates, like I go on vacation every year in June to Florida, and I do wonder is there a sign-in sheet or anything? That's the only thing I would say. I'm not saying I wasn't there. I'm not denying that one, because I don't remember all the details of this until I've read through it, but it just catches my attention because I've already got it scheduled. I got a vacation that I have every year in June.
Don't get nervous about it. I'm only showing you these things to see if it refreshes your recollection.
I just wanted to make sure, like, when I say I was actually there, I start to question if I
Well, it does
wasn't.
say you were there, doesn't
Okay.
it?
So,
There's a lot of other weeks in the summer you can take your vacation, right? At any rate, does any of this jog your recollection that it's in a construction meeting with all these people where the company, the contractor, and quite frankly, the school needs somebody to address the problem we've talked about. And it's in one of those meetings at Grandma's Gardens as the landscape stone comes up to perhaps address it. Is that fair?
it's fair to say, the term you're using there that does jog my memory is stone, because Mr. James had a vision of where he really wanted to have some stone that was put there that could serve as both decorative and to sit on, and I supported that.
And a barrier too.
Correct.
For the kids to get up and play on the slope and all that
Correct,
stuff.
correct.
Right. Okay, so I think we could agree that to suggest that Mr. James, all of a sudden out of the clear blue, is trying to make some orchestration to get Grandma's Gardens business for his own benefit, that would not be correct, would it?
I couldn't say yes to that, no.
No, that would be correct. All right, so this is June of 2022. By the way, you were aware that an investigation into Mr. James as a school treasurer had been instituted by the state auditor's office in the spring preceding these meetings, right?
Correct.
He's under the microscope of the state auditor's investigator when these meetings are going on, right?
Correct.
Okay. And what you know is Doug Reinhardt then had to have done some work between the time of this last date, June 20th, when his name and number goes in the construction meetings, and he comes to the meeting on August 8th before the board. He did some work.
I think that's a fair statement.
He showed up, and as I recall, he made a presentation to the board of not only what he thought would look good and look right and do what you guys wanted, but also how much he would charge. Is that fair?
That's a fair statement.
Okay. Now, let's go to our meeting minutes. By the way, I think you already told us, you had used, when I say you, the school had used Grandma's Gardens for these spruce ups in the spring or the fall or special events. It wasn't like this Grandma's Gardens came out of the clear blue. Fair?
That's correct, that's fair.
All right. And you'd met Doug Reinhardt.
Yeah, I knew who he was.
And you knew that he and Ron were friends.
I did know that.
Okay. So he comes to the board and states Exhibit 12. Do you have that up there? It's the minutes. Looks like this. Did you guys take your exhibits back?
Let's see.
Yeah, they're right here. Well, maybe. I think we can get There you go. I'm sorry. Didn't fall apart. State's Exhibit 12, that was marked, are the meeting minutes for August 8th, is that right?
That's what, yes, it appears that's what.
Now, what I want to do is call your attention to something. If you'd look at page 3 of the minutes. There's a entry that says superintendent's business items. You see that?
Yes.
And by the way, are these minutes, are they representative of at least the typical form that are used for the minutes? You know what I mean by that?
Yeah, I would.
Treasurer's section, superintendent's
Yeah,
section.
There's nothing that appears to not.
Say again?
There's nothing that doesn't appear to be typical.
Right. And so like, for example, on that particular day, superintendent's business items, B1 through B11, you see that? Right under superintendent's business items.
Personnel items, yes.
Yeah. It says it was moved by Jamie Gallagher and seconded by Jim Byers to approve superintendent's business items B1 through B11. See that? And then 11 items follow that describe what those are.
Correct.
And so it was fairly typical for non-controversial items to be loaded under one motion, so to speak, right?
Well, for mine, I tended to try to break mine up more based on the category of what those decisions or those motions would be. And so if you look at 1 through 11, which this is what I would always do, 1 through 11 are all personnel. So that's why you took
Right.
them all in one
You
swoop,
lumped them
because it was
together.
all personnel.
Right.
And then we would have then taken and broke out sports things. It appears we broke out in lieu payments for Catholic schools, private schools. Yeah, so I would always try to break them up into categories. That helped if there was any discussion by the board wanting to know more information rather than try to do it all in one swoop.
Point is, you lumped 11 things together that were passed by one motion unanimously, right?
Correct.
Okay. And if you page back, one page, under treasurer's business items. Tell me when you're there.
I'm there.
The minutes indicate it was moved by Brad Connor and seconded by Dan McLeod to approve the treasurer's business items 1 through 3. And that was unanimous and the motion carried, right?
According to the minutes, yes.
And if you just turn the page, you can see, well, at the bottom, you see what item 1 was, item 2, and item 3 if you turn the page, right?
Correct.
And item 3 was the visual presentation of the performing arts landscape proposal by Grandma's Garden owner and resident Doug Reinhardt, and then consider approval of the proposed purchase order amount, purchase order approved. So it's not just purchase order approved in the minutes. The prior page is, there was a motion by Brad Connor, seconded by Dan McLeod, and the vote was unanimous.
That's
Right.
that's what the minutes would reflect, yes.
Reflect your recollection as to what really happened?
I guess. I mean, I don't,
Well, okay, let's not.
I'm not
yeah.
disputing, I mean,
Let's reason it out, Mr. Tubbs. You were still at the school the following 30 days or so, were you not?
I was up till Labor Day, the Friday before Labor Day, yes.
25 to 30, whatever, however Labor Day fell. When you walked by the school, did you see Doug Reinhardt out there doing the work?
Yeah, I mean, I'm not disputing.
He's out
his
there
work.
doing the work,
I'm
right?
not disputing that, yeah.
I mean, there's no mystery here.
No.
Is there, he made a presentation, and it was a fairly, a detailed presentation, wasn't it?
Correct.
He had PowerPoint, which you were operating.
Correct.
He had a blow-up of one of the schematics. It looked like this, we'll mark it later, but there was something like what I'm holding up for you to see, right?
I don't remember precisely, but I just know
Yeah.
there were diagrams of some sort, yes.
And he had estimates on how much it would cost. And when he walked out of that meeting, everybody believed he's gonna start work. Right?
Correct?
Okay. So, tell me, I think you said you knew that Ron, my client, did some consulting or tax work for Grandma's Gardens?
I didn't know precisely what it was, but I believe he had told me over time he had done some things, yes.
You knew he had a relationship.
Oh, definitely.
Yeah. Now, was this your last board meeting?
Yes,
Okay. So you don't know what happened in the next board meeting?
correct.
Okay.
And to be honest, I wasn't a part of these minutes being approved, because the
I'm
minutes.
sorry, you were what?
I was not a part of these minutes being approved because minutes are approved after the fact.
They're done at the next meeting,
Correct.
and you weren't at that meeting.
I was not.
Gotcha. We're good on that. All right. Move on to the ACT issue. Yes,
I like
we
to
did.
Can I lay this here?
Yeah, it's fine.
Man. Let's get 13. You pull out state exhibits 13 and 14. Maybe I'll just keep that. I'm going to be looking at 13, 14, and you might pull 29 out as well. Tell me when you have them all and you're comfortable with them.
Yeah, I think I do.
You good?
I think so.
All right, we're gonna work in reverse. 29. 29 is an email you sent to ACT August 4th of 22.
Correct.
And that would be over 2 years after the first COVID ACT test was administered, in July of 20, is that right?
I guess. I mean, I don't know exactly.
Well, if I told
It
you
would be.
the evidence in this case is that the first COVID ACT test was on or about July 20th,
Okay.
20, we
Then
know
that,
COVID was
then that would
20.
be true, yes.
Be about 2 years.
Yes.
Now, you didn't send this email to ACT out of the blue, did you?
No,
Somebody came to you and talked to you about this case.
correct.
Who was that?
The investigator for the
Ms. Booza?
auditors, yes.
Okay. And what was the conversation that led up to you sending this email to ACT?
As I said during the
Keep your
prosecutor's
voice.
part, as I said during the prosecutor's part, I was asked by her, was I aware of some reasons why Miss James would have received some checks? And I honestly could not remember anything at that point that came to mind, because I couldn't think of her doing any supplementals during that time period, because she's coached for the school district previously before, cross-country and track. And so then, as I started thinking about it, I said, I think maybe I might know what this is, but let me check. So then I asked ACT, because I knew the one thing she had done in addition to her regular teaching duties, was ACT.
Talking about Janae now.
Correct.
And the reason because we have a female investigator and we have Janae, and she's.
Miss James, yes.
So, but there was something in your mind, what I'm trying to figure out whether, when you sent this to ACT with the inquiry, there was something in your mind, and I want to know if it was from your own recollection or from something she told you that caused you to send this.
Her asking me.
Her asking you to ask that question?
Her asking me if I could figure out what additional checks she would have been receiving.
Did she show you either exhibits 13 or 14, states exhibits 13 or 14, before you sent that question to ACT in 22?
I don't remember that happening. As a matter of fact, I don't even remember these emails until I met with the prosecutors and they showed me what my responses were. I didn't remember that.
Well, let's look at exhibit 13.
Okay.
This email says, is from Ron James to you, right?
Which one am I looking at?
Number 13.
This one doesn't have a number and this one says 14. So
Doesn't have, well, I want you to look at 13.
this doesn't have a number, but I'm
Oh,
assuming it's
13 is 2 pages. So it had
One page.
once upon a time had a paper.
I'm sorry. Let me see if this goes together.
No, there's got to be another page.
There is. Look under tab 13. We'll get this together.
almost, I'm not trying to be difficult.
Oh, no, you're fine. Let's see it. See which one this is. Well, it's the same thing as this, so this is not good. Gentlemen?
John, just flip that page.
Is there
over.
something on the
On the
back?
backside of the
Yeah,
other
when you
page.
flip it, there's a backside.
Mystery
I
solved.
need the help.
I know. I'm really more interested in helping Mr. Dubs than you.
So this is superfluous, but I don't want to mess with our stuff, so,
Okay.
okay. So we have Exhibit 13
Correct.
with a reverse side, and we have Exhibit 14. I want to look at 13.
Okay.
13 is an email from Ron James to you dated October 29th of 20, right?
Correct.
He says, Pat, due to the hours it takes to handle a much larger ACT volume and the prep work that it takes the ACT group is to pay the coordinator $350 for the extra effort. See that?
I do see that.
And you know that the coordinator is Janae, his daughter.
Correct.
I mean, you knew that. It says Wayne Local received the $350 versus going to the coordinator. So you knew, if you read this, you knew that the check came to Wayne Local Schools and not directly to the coordinator, even though it was for the coordinator, right?
That's how it appears in the email, yes.
He says, we don't get a check from the ACT, paren, until now and due to large numbers, close paren. This check is deposited in the bank and we then do a PO to the coordinator for the same amount, right? That's what it says. Did you understand that? I mean, when you read it?
I don't know, because I don't remember this particular email. The first time I really remember it was 2 weeks ago, but I don't have any reason to believe that I would not have understood that.
Well, before we finish it, it'll be on the reverse side of your exhibit. You're responding to his email of October 29th at 11:52 a.m. on the same day at 1:24 p.m., right?
Correct.
And what you're saying, the word is none, which means I have no objections to this arrangement.
Yeah, I wouldn't care if Janae got more money.
Exactly. And so the bottom line to this, and when you look at this, first of all, you were asked to do Exhibit 29 2 years basically after this email apparently came to you and you responded, right?
Correct.
And nobody's reminding you that you had received this email almost 2 years earlier. So you're asking ACT, hey, what's the deal with this, basically, right?
Correct.
But the fact is, you found out later, well, the deal was very clear. Janae's gonna do extra work. ACT sending $350 to Wayne Schools to give to her, right?
Well, what I found out was wherever the email, this email was, that was given to me from the ACT, that we pay a facilities usage and we like to keep it at $1 to $2 per examinee, and I left it at that, and I gave this information to the auditors, and at that, I just left it alone. I didn't do any more with it.
They come back and ask you anything else?
Not that I remember.
So when did you first see Exhibits 13 and 14? Did you say it's like very recently?
2 weeks ago with the prosecutors when I
2 weeks
went and
ago.
did an interview. That I remember. I'm not gonna sit here and say, I just don't remember it.
Well, it was this year.
I saw it this year?
I'm asking you.
Oh.
You say I don't remember, but I'm trying to see if we
No,
can.
I'm saying yes, 2 weeks ago I saw it,
Got
but I
it.
don't remember beyond that
Got
when
it.
I saw it.
Got it. And then you did respond, it was a habit of yours for simple things to respond with a thumbs up image, wasn't it?
Yes, or yes.
If
or
it's simple.
no, or, yeah,
Yeah.
correct.
So this next one, Exhibit 14, is on the same subject, isn't it? It's from Ron James to you, January 29th, 2021.
It appears, yes.
And when you would have read this, you would have remembered the one 3 or 4 months before, correct?
I guess I would have. I don't know if I would remember it exactly, but I obviously didn't have a concern. I wouldn't put a thumbs up.
Well, that's what I mean, is that if it was something that was totally foreign or strange to you, you wouldn't have been so flippant as to use a thumbs up. Fair enough?
That's fair.
So again, so we can summarize a little bit, doesn't this all refresh your recollection that you knew $350 was coming to the school to give to Janae at the time during COVID that it was happening?
It doesn't, because I don't remember this particular, I'm not denying I said yes to it. I honestly do not remember all of this back and forth.
Well, you certainly wouldn't be critical of Janae or Ron or anybody else for engaging in this procedure with ACT, would you?
I would not.
And, so we can be really clear, the ACT people, test coordinator and everybody else, they're not board of education approved people, are they? They're doing something outside of that.
It is, it's a private relationship between that employee, and it doesn't even have to be our employee. It could be somebody.
It could have been me.
It could have been you.
Well, they won't call me people, but it could have been somebody else, right?
That's correct.
Yeah. And so, I don't have anything else.
Mr. Hughes?
Just to dig in a little more detail, I'm Kevin Hughes, I represent.
I'm
I'm Kevin Hughes, I represent Janae.
How are you doing?
To dig in a little more detail to Mr. Smith's last set of questions there, you would agree that, well, one, the COVID world was crazy. You're the first educator to come up here today. All the kids went home March of 2020, right?
Yes.
And you were calling it, you had to come up with a reopening plan because you wanted kids back in school in August of 2020, right?
We, as an administrative team, put an incredible amount of work into making that happen. We started from day one.
And when the concept of the ACT comes up, think you coined it test of reopening. Would you agree with me?
I coined it what, I'm sorry.
When the ACT concept of opening it back up and allowing Waynesville kids and everyone else from the country to come to Waynesville and take that test, you coined the phrase test of reopening.
I don't remember saying that, but I would say this, that I wasn't against us holding the ACT because we had successfully opened school but I don't remember saying that term, but.
And you know, she put it, Mrs. Janae James put in a ton of work to make that reopening happen, this test of the ACT to happen, right?
I would say anybody that was involved with it had to put a lot of work in it too, because the entire school year, anything you did.
But she's your coordinator, and she's the number one getting that thing back up and running, right?
Sure, yes.
And you answered John's question, you didn't mind if Janae got that extra money, right?
I wouldn't care. Yeah, if the ACT wanted to pay her more money, that makes no difference to me. I mean.
Now, because that money that came in, that $350, was never the school's money in the first place, was it?
I don't know, I can't answer that.
Take your responses to these emails, combined with my question. That money, you knew, based on your responses to those emails, was never going to Waynesville.
You're asking me something I can't answer. I don't know who it belonged to. I just know it was coming from ACT.
You do understand that Waynesville never got money before COVID from the ACT for the usage of your buildings, right?
I did not know that.
When the state was asking you questions about back and forth in emails, you testified you knew Janae was sending out emails because you were involved with those emails looking for workers to work the ACT.
I saw those emails because they went out to the entire district, yes.
And that's additional work that, let me back up. Prior to the July of 2020 test, did you ever see that type of an email from Janae James? I need people to work.
I don't precisely remember that particular time, but I would say yes, she probably did, because that was a practice by a number of coordinators.
The reason I'm asking that way, do you know your ACT numbers at your school before COVID, before the July 2020 test?
No, I couldn't answer that.
You know what they were post-COVID, after the July 2020 test?
Couldn't answer that.
Do you know what happened, had to happen to the high school to get ready for the COVID testing?
Well, anything we were doing during COVID, there had to be enough distancing, spacing, certain number of desks in a room. We did that all the time anyway for school to operate. So yeah, there would have been moving around a desk and making sure that there was enough distancing.
These numbers got so big that you had to approve whether Janae could use the cafeteria for testing. You remember that?
I don't remember precisely that, but I'm sure I said okay, yes.
No further questions.
Any redirect?
A few questions, Your Honor.
Excuse me, sir. What did I do with these things?
Just let them sit there.
Just let them sit there.
Are they in your way?
No, I just didn't want to
Yeah.
start closing things.
No, that's their responsibility.
Okay.
Not yours or mine, yeah.
Mr. Dubs, Mr. Smith directed you to Exhibit I, that's of the defense exhibits. That is Exhibit, I think at the bottom corner, 00007. I don't know if you have those documents in front of you, so.
We're talking about Exhibit Roman numeral IX.
Yes.
Yes. Might be faster if I just approach.
Can you?
It's hard to
I'm
beat you
sorry.
to it.
I mean, like there's.
Oh, okay.
Don't have it last time before.
It's I, 007, okay. You're on the right page. About, I would say two 2/3 of the way down the page, there's some handwriting on that document with an asterisk.
Correct.
Indicating that Pat Dubbs suggested GG. Did you write that?
No, that's not my handwriting.
Do you know what GG stands for?
I don't recall what it means right now.
Okay. If it was Grandma's Gardens,
Well, that makes sense, yeah. Gee,
All right.
I would dispute that, correct.
did you suggest Grandma's Gardens do this job?
Me personally, like
Yeah.
to say, I went to Grandma's Gardens?
Yeah.
I would say no to that.
Okay.
I wasn't against it, but I would not say that I personally suggested it.
Okay. And Mr. Smith, I asked you, these meetings that you were having on the construction of the elementary and the Performing Arts Center, they were occurring weekly? Is that fair to say?
Yes, as much as we could. I mean, there was things sometimes that happened that you might have a meeting backed up or didn't happen, but, and the other thing that's confusing sometimes about when we start talking about construction meetings is that Mr. James and I had to be involved in sometimes meetings that overlap, because there were meetings with Broomball, who did this part of it, and there were meetings with Monarch, who did the elementary. So, I mean, it all got mixed together. There were different players.
One or both of you may not have been, well, let me rephrase that. Were you both at these meetings, or sometimes it was just you, sometimes it was just Mr. James?
We both tried to be there as much as possible. I will say this, that in the spring, Mr. James had some health issues that he wasn't, in my memory, not always there. There are also some times that I might have called in and listened to it speakerphone-wise, just because there were other things going on. But as far as one or both of us being aware of what was going on, correct, we would have been. I mean, we represented the school.
All right. So it wasn't a requirement to be at all these meetings. It was something you were involved with, but...
I wouldn't use the word requirement. I mean, a requirement. I would say that Mr. James and I were working to have a successful project, so like we insisted we be there and be a part of it.
All right. I'm going to direct your attention likewise to, this would be J0006 at the bottom.
Now you're referring to Defendant's Exhibit Roman numeral 10?
Yes.
I don't know, I'm sorry.
This will be J, and then...
Under the J. Okay. And then 10?
6.
6. At the bottom right corner.
What the asterisks are?
Correct.
Correct.
Likewise, you didn't put asterisks on that, did you?
No.
As far as having a phone number of Doug Reinhardt on there, do you recall that?
I don't recall it, but I'm sure that we had access to his number. I mean, we would have had access to it, but I don't recall.
Do you recall who would have brought Doug Reinhardt's name up at these, as far as suggesting he do a job?
Well, I would say probably Mr. James, because he had a relationship with him, and when we did things in the school district, like the mulch or the bushes and so forth, I mean, we would say, let's do this, and then Mr. James would reach out to Doug.
Do you recall anybody else being mentioned to do this job?
No, I think what I recall is Broomball just not having a solution. They did not put into their scope what was to happen with that. And so that's why it became, as the project's coming towards an end, we got to find some solutions to this. And then I believe that's how Grandma's Gardens got brought to the table, because Broomball, from what I remember, just didn't have like a sub or somebody that they were ready to bring to the table to do that.
Okay.
Yeah.
But as far as my question was, if anybody else was suggested other than Grandma's
I can't
Gardens?
remember.
All right.
But definitely Grandma's Gardens was, Doug Reinhardt was mentioned. There's no doubt about that. Does great work.
And I think that Mr. Smith asked you this. You said you knew that Mr. James and Doug Reinhardt were friends, I think, when I initially questioned you, and he mentioned something about doing his taxes. Did you have any personal knowledge of that?
I do not. When I mentioned taxes, I mentioned that there were quite a few people that had correspondence or interaction with Mr. James because he did a lot of people's taxes around the Waynesville area.
Okay.
I don't know precisely what Mr. James did for Doug Reinhardt.
All right. Did he ever do your taxes?
No.
Mr. Smith asked you as well on State's Exhibit 13, and you responded you wouldn't care if Janae got more money. Is that correct?
I would have no reason to care, yeah. If they wanted to pay her more, I'm fine with that.
And the reason why you got this email on State's Exhibit 13 that indicates due to the hours it takes to handle a much larger ACT volume and the prep work that takes ACT group is to pay the coordinator $350 for the extra effort. So in that email, you're being told the coordinator gets $350, correct?
I don't have the exhibit in front of me.
Okay.
Can you state the question again then?
In that email, I believe it's the first line, it says the coordinator should get $350.
Wayne Local received the $350 versus going to the coordinator. ACT group is to pay the coordinator $350 for the extra effort, correct?
So is it fair to say your knowledge of that $350 payment was from Ron James? That's the only knowledge you had, that it was to go to the coordinator?
Correct, it ran through the treasurer's office.
All right. And you made inquiry to ACT about that, didn't you, at a much later time?
I did.
Is it fair to say you found otherwise? It was for facilities maintenance.
Objection, on the request.
Sustained.
Did you find that otherwise in your communications with ACT as far as who was designated to have that money?
I don't think that the ACT got very specific about what it was. I mean, they basically said that typically it's for facilities, and that's what I shared with the state auditor.
All right. When you say facilities isn't specific, why is that not specific?
Why is that not specific?
Yes.
Facilities is a big term. I mean, it could be anything that's happening using that facility. It could be, I mean, like, say it's a basketball game, it could be for security. If it's for the ACT, it could be custodial, it could be electric, it could be, maybe we had to go out and purchase more supplies of some kind. It could be any of those things.
Okay. So that didn't concern you after you got the response from ACT?
No.
Okay. But as far as your information that you originally received in States Exhibit 13 and 14, those emails, all your knowledge about the earmarkings of these funds and who it's to be for came from Ron James. Is that fair to say?
Well, like I said, I've said numerous times, I don't remember the emails, but based on what you have presented me, what I'm reading, I would say yes to that answer, yes.
All right. All right, thank you. No further questions.
Any other questions?
Not
Mr.
for me,
Hughes? Mr. Hughes?
No.
Mr. Hughes?
No, I'm just.
You're thinking?
I'm thinking. I have.
All right, Mr. Dubs, you may step down. You can leave all that stuff right there.
Okay,
And you may step down. Thank you for your time this second.
thank you.
Your Honor, I just need to see who's here.
Okay. That's fine, Kevin, go ahead.
I don't care.
State's gonna call Dr. Byers.
Stay standing, raise your right hand. You swear affirm the testimony you give in these proceedings to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Can I have a seat? If you need it, let's touch it.
thank you.
Please state your name for the record,
James Kevin Byers.
and can you please spell your last name?
Yeah, B-Y-E-R-S.
How are you employed?
I'm self-employed.
In what profession?
I'm sorry, I'm a chiropractor in Waynesville.
All right. And should I call you Dr. Byers? Is that-
Jim's fine, whatever you're
Okay.
comfortable with.
All right. Where is your office located?
139 North State Route 42.
Is
Waynesville,
that
Ohio.
Waynesville?
Correct.
And Dr. Byers, you served on the Wayne Local School Board, is that correct?
Correct.
When did you serve?
2016 to 2024. 2 consecutive terms.
Okay. And what position did you hold on the board?
For the first 7 years, I'm sorry, for the first 6 years, I was just a general board member. The 7th year, I was the president, and then the last year, I was the vice president.
All right. Are you familiar with a Ron James?
Yes, I am.
And how do you know him?
He was the treasurer of the Wayne Local School District.
And are you familiar with Janae James?
I am.
How are you familiar with her?
I understand she was a teacher.
Okay.
I never
Did-
met her.
Did you have any contact with
Not
her?
really, no.
Are
No.
you aware of the relationship between Mr.
Yes.
James and Janae James?
Correct.
What
Yes.
is that?
Father-daughter relationship.
Okay. How would you characterize your relationship with Mr. James?
You know, I've served on a local boards, I've served on regional boards, I've served on a state board. And my relationship with him is he was the administrator that, you know, reported to our board.
Okay. So when he reported, was that at a formal meeting?
Correct. Once
How
a month.
often did that occur?
Once a month at our monthly board meetings.
Outside of that, did you have any type of relationship?
No.
I'm going to direct your attention to on or about August 8th of 2022. Do you recall a board meeting in which Grandma's Gardens gave a presentation for the Performing Arts Center / elementary school?
Yes, I do.
What do you recall about that meeting?
That meeting was very unusual for a few reasons. One, it was Mr. Dubb's last meeting. Number two, we typically didn't have vendors give presentations to us. I think the only other time I'd seen that before was when we were doing the elementary school bids. We had 3 vendors come in to do the services for that. And I thought it was very unusual having one person show up as a vendor, so,
Do you know why they were there?
no.
And do you get a copy of the agenda prior to the
We used to
meeting?
get the agenda the weekend before the Monday night meeting.
All right. Do you recall who presented Grandma's Gardens to the board?
It was Ron.
And do you recall what was said?
There were many things said. There was, you know, he's been a friend of the district for a number of years. He's gonna take care of us. We're gonna get a good deal. I do remember raising my hand and asking, don't we have to have 3 vendors for this? I understand he might be a viable.
Do you mind?
Keep your voice up for me, sir, please.
I'm sorry.
Keep your voice up.
I'm sorry. From the beginning?
No, just right here forward.
Okay, I'm sorry. Yes, just that, you know, I thought it was unusual having one vendor instead of
Okay.
3 vendors present.
All right. You've had 3 vendors present before?
Yes, with the elementary school, I remember.
All right. As far as whose agenda it was on, do you recall who that was?
You know, I worked really hard as a president to educate our board on it. It was the school board's meeting, and that, you know, Mr. Dubbs and Mr. James reported to us. So when you asked that question, yes, it would have fallen under his treasurer items.
So it was under the treasurer's items?
Yes.
All right. Did you know what, if any, relationship that Ron James had to Doug Reinhardt, the owner of Grandma's Gardens?
At that point, no.
Okay. Had you had Grandma's Gardens present to the board before?
No.
Are you aware of them doing work for the school before?
I'd have to say I don't recall because we didn't always know who did the work. So they may have, we just weren't aware of it.
Did you ask questions at that meeting?
Yes,
What did you ask?
I vividly remember that question. And my other second question, do we need to vote on this? Or
Yeah.
what's our limit?
And what was the response?
I don't recall.
Did Mr. James?
Hang on.
I
What's
have an
your,
objection.
what's your objection?
Well, he's asking about a conversation, nobody's being identified.
Okay.
Let's be a little more specific with the answers, the questions and answers, please.
Who did you ask the question to?
Mr. James,
And did Mr. James respond?
I don't recall.
During, did Mr. James interject at any point in this presentation?
Mr. James and my relationship is he ignored me a lot. So I didn't always get, I'd either be hushed or he wouldn't respond to something. So that was part of my frustration in our professional relationship. I don't recall, to be honest with you. And I did look back on our notes and we did vote that evening.
Okay. Can you describe the presentation?
Yeah, it was very nice. It was on a PowerPoint presentation. Lots of details, very specific. It looked very nice, done professionally.
And you do recall a vote being taken on that?
I didn't until I reread my agenda, not too recently, so.
All right.
I'm sorry. May I move up here, Your Honor? And I didn't hear until I did something.
He reviewed his notes.
Yeah, my notes.
Reviewed his notes.
I kept all my agendas from all the years I was on the board, so, in reviewing, knowing I was coming into this.
All right.
But not that day of, what do you ask?
Dr. Byers, did Mr. James ever disclose to you he was receiving $2,000 a month
No.
from Grandma's Gardens for the last 10 to 15 years?
No,
Did Mr. James ever disclose that he had an office at Grandma's Gardens?
no,
Did he ever disclose that 99% of his outside business was through Grandma's Gardens?
he would talk about his tax business, but I didn't know anything about the Grandma's Gardens business.
Were you aware that he did the taxes for Grandma's Gardens?
I was not aware of that, but I knew he did taxes for multiple people,
All right.
so.
Would that be something that you would want to know as a board member?
You know, I was always about going back to the three vendors, having a healthy discussion with the board and coming to a conclusion. I thought the fact that we voted on it that day, which is very strange,
Okay.
you know, especially that sum of money.
Why do you say that?
I think much like anything, you know, just like the elementary school, we took our time and processed that, you know, had conversations amongst ourselves, did homework on it. And it was very unusual to have a vendor come to us. That's what I'm saying. It was just unusual.
In those meetings, were they recorded?
No.
So the documentation, the history of the meeting is recorded in the minutes, is that
Correct.
correct? Were you aware of who was doing the minutes?
Mr. James.
Did Mr. James ever come to you and ask that more money be appropriated to his daughter for ACT testing?
No.
Is something like that, would that be expected to be brought before the board?
No.
And why is that?
We had line items we'd vote on, and then we do a motion, a second motion, and then we'd have a discussion. If we thought it was unusual or one of us had a question, we'd ask about it. But I don't recall us asking anything about that, so.
Okay. Well, you had indicated it was never brought to the board.
You mean her name?
Yeah, as far as receiving extra money from ACT.
Not extra money. I believe I saw her name on the agenda to be a proctor, but not the extra money you talked about.
Okay.
Is that what you're asking?
Yeah, and I was asking if you.
And I don't think we ever saw the amount of monies, like what they were paid.
I see.
So it was just a name on an agenda.
And I had asked you if you expected, would that be something that would be brought to the board's attention if money was to be distributed?
Sometimes.
I'm going to object because it was established by the superintendent that the people don't work for the board when they do the ACT.
I think he's talking about the money that went through Waynesville schools though, specifically. So I'll allow it as to that money that was paid through the school.
Correct. Anything that went through the treasurer's items that was typically listed there, so.
All right.
I understand they had a working relationship, would have a conversation, because obviously on the HR side of it, you know, Pat was, but as far as the money side, that was all Ron.
Okay. At some point, Mr. James resigned as treasurer, is that correct?
He signed a separation agreement with the board.
And was that soon thereafter, in 2022?
2022, correct.
A few months after this meeting?
Within a couple months, yes.
All right. And you did a posting about that, is that fair to say?
I didn't do a posting about that. I just put a general relief thing on Facebook, as I was happy the five of us agreed on something.
Okay.
Because our board was not congruent.
Why do you say that?
We had some serious issues there on the board, and one was his lack of professionalism, and two of the board members never wanted to pursue it, never wanted to do anything with it. And one of the board members, we had to have a discussion, and we brought in some staff that kind of switched the mind, and that's when everything kind of changed. Well, we need to do something. We need to separate from him.
Okay. And back to my original, I think on Facebook you had put some posting on there, is that right?
Yeah, yes.
And in retrospect, would you do that again?
Probably not.
Okay.
I'd done really good keeping things from the school off of Facebook,
Okay.
so.
You just have a moment. All right, no further questions.
Mr. Hughes?
Afternoon, Dr. Carr. How old is your son that took the ACT during these COVID years?
I had two boys.
And, well, let me ask you this. We know that your son took the December 2020 ACT test.
My youngest son.
What's your objection?
Relevance of whether or not his son took an AC test.
Well, I don't know. I don't know the relevance yet, but I'll give him some room. Mr. Hughes, move on. Let's
He
go.
took that test, correct?
My youngest son, yes.
And how did he like that experience?
Objection.
Overruled.
Positive.
I'm sorry?
Positive experience.
And did you drive him to the test by chance?
No, I did not.
Okay. You know how many kids were at that test?
No.
He took the June of 2021 test as well.
Okay. I don't recall that, but I know he took it.
Okay. Did he say anything negative about that experience?
No.
Did you take him to that test by chance?
No, I did not.
ACT money coming in and out of the school is not a board issue, is it?
Only if their name appears on the agenda, we have to vote for it.
Okay. And it never did it?
I don't recall, and I don't want to say either way.
In fact, you wouldn't know if ACT ever paid money to the city of Waynesville schools.
True statement.
No further questions.
far as, you said you were president of the board, but I didn't catch the years.
The 2022 year.
Say again.
2022,
2022?
correct. My 7th year.
Do board members take an oath?
Yes, they do.
Do you remember, just like ad lib, what the oath is?
Much like I probably took here, to tell the truth, all the truth, serve the community
Yeah,
to the best of my ability.
okay. So did, during your time on the board, did you ever, while Mr. James was there, did you ever make a motion that the board start recording its proceedings?
I remember talking about it. I don't remember making a motion.
So you never took formal
I-
action to try to make
No.
that happen?
We didn't have the support. I didn't have the support.
And by the way, you do know, skip to the end here, you do know that you voted to approve the August 8th minutes
Correct?
the following month.
Yes.
So when you fulfill your oath sitting on that board, you read those minutes before you vote, don't you?
Yes, I recall that meeting. I was frustrated, and I thought, there's nothing I can do. So I said, okay, let's vote. Let's do it.
Are you suggesting to the court you would violate your oath because you were frustrated?
Can you restate the question again?
Are you suggesting to the court that because you're frustrated, you would violate your oath and not do what you were supposed to do?
My recollection of voting on items was if they made sense after a healthy discussion, to vote yes or no. And my frustration that when I understood after, I think I asked during the discussion period, do we need to talk about this any further? And nobody wanted to have any discussion. So, yes, I voted yes, I did.
Well, I'm confused because we may be talking about two different things, so we'll try to straighten this out. Let me see. I'm going to show you. May I approach the witness, Your Honor?
Yes.
This will be, let me show you what's been marked Roman numeral, defense exhibit Roman numeral 15. That's an XV in case
Okay.
you wonder.
I understand.
I did take Latin.
Okay. I did too.
I want you to look at that and see if you recognize it to be the September 2022 board minutes of the organization, the Waynesville School Board.
This is the August meeting, correct?
Wait, I marked the wrong one.
Regular session of the August 8th, because we voted on this in July. Thank you.
XVI,
What's the other, the letter?
the letter is P, as in Paul. Now, take a look.
Okay.
We're going to talk about both of them anyway.
This was Dr. Ison's first meeting, by the way.
So here's the question. You can see in those minutes, did you not vote to adopt as accurate the minutes that were made of August 8th, the prior month?
I did.
So my question to you is, did you read the minutes of August 8th?
Yeah, I always read the minutes.
Right.
Yes.
And so when you voted in September to adopt those minutes, you were saying under your oath on the board that they're accurate,
Yes,
correct?
correct.
And so what we know is that Mr. James did not hire Grandma's Gardens, did he?
That was a board decision.
You guys hired Grandma's
Correct.
Gardens, right?
Correct.
Now, let me ask you something. The fact that he knows Doug Reinhardt and does his taxes and is an independent contractor and gives him advice, did that make Doug Reinhardt's bid horrible to you?
No, I already said, I didn't think it was horrible. He had a nice presentation. It could have been one of the three. I just think after attending Capitol Conference, I used to go to OSBA meetings. They preach that all the time, multiple vendors. And it was very strange having one vendor. No, he had a nice presentation. I didn't see anything wrong with it. It could have been a very viable bid.
And you also, you go by the school, being a board member, you probably
Correct.
check physically on that
Sure.
school from time to time.
He did a nice job.
You probably saw him out there doing the work.
I don't know if I saw him, but it was being done.
You
Yeah,
saw the work being done.
correct.
So, as I understand what happened here, you have a criticism that only Grandma's Gardens made a bid. That's your criticism retroactively today, right?
Yes, yes,
With 20/20 hindsight.
yes.
Except you were satisfied with the work when it was
I-
done, right?
No, I retract that last part. I had an issue with that day, the day of the August 8th meeting, when it was being presented. Because I raised my hand and I asked. Matter of fact, I asked Mr. Dubs, the superintendent, do we need to have another vendor bid? And he said, he pointed to Ron. What's,
Are you telling me, I want to understand this. You voted yes to hire Grandma's Gardens. Don't you think that obviates all of these criticisms and frustrations and all these things you wish didn't happen before you cast that vote?
I guess I'm befuddled how to answer that question because
It's a hard question, isn't it?
It's a hard question.
Can you finish his answer before he interjects something?
I just feel, and I know I haven't talked about his unprofessionalism, but when all that just builds up and you have something like this, you almost just want to throw your hands up. What am I going to do? I mean,
You could uphold your oath and say no,
Objection, argument.
right?
This is Cross, overruled.
You could uphold your oath and say, no, I'm not voting for that. But you didn't do that.
It's true.
So here we are, 3 years later, and now you're just telling the court, I wish I'd voted no, I guess, right?
I wish I would have abstained is what I wish I would have done.
Okay,
be honest
but you didn't.
I felt like I had a conversation with Mr. Dubs and with Ron and my board, and it just was going nowhere. But you know, there's multiple things we voted on. I think sometimes I wish we would have changed our vote on it, to be honest with you. So
You
wasn't-
understand this is a criminal case?
I do understand this.
Criminal charges against
I
two
do understand.
individuals,
I understand that.
and you wish you'd done something different. So do they.
Objection.
No, I'll
Sustained, thank you.
You did feel Mr. James was unprofessional, right?
I did.
And you had voiced that to other people, had you not?
Sure I had.
Were you the person that made the complaint to the state auditor's office that instituted the investigation into him?
No,
Do you know who was?
no.
There was mention of a posting. When he signed a severance agreement to leave, you said, "Great day to live in Waynesville. Time light up this Cuban. Time to light up this Cuban." You had a big stogie in your mouth,
It was a good
what
one.
you posted, right?
It was a very nice cigar.
Perseverance pays off, I tell my boys. 5 for 5 ain't bad for not playing softball last few years. Future is so bright, I gotta wear shades. This is all in reaction to the fact that Mr. James agreed to retire in the end of October of 2022, isn't it?
I think in addition to some other things going on in my life at that point.
I'm sorry?
In addition to some other things going on in my life. It wasn't solely him.
So, you had no love for Mr. James. You voted to approve a contract for Grandma's Gardens to improve the school. You agreed on the amount that was to be paid, right? That was part of it.
Sounds like I did.
The work got done and you liked the work, right? But you think there's something wrong with Mr. James for having brought this before the board. That's what we're here about, right?
I guess, Mike, I'd answer the question, why does the OSBA and all these, they always talk about 3 bids? Why do they emphasize that? If they don't want us as board members to do that? Can you answer that? I mean, why else would we?
I'll have to hear the whole thing. Repeat it back to me. I'd be
I'm
happy
really
to.
big on going to continuing
We're
education.
gonna stop here because I'm not gonna allow the witness to be asking you questions.
Sorry.
So, do you have another question, Mr. Smith?
No, I don't think I do.
Any redirect?
I'm sorry, Your Honor.
No, you're fine. He knows better.
Okay.
I take it you
apologize.
don't have a lot of
I haven't
experience.
done this that much.
No, you're fine, you're fine. I was directed more at him than you.
Let's try.
I don't mean to be disrespectful.
No, you're fine, sir, you're fine. I've sat there before, it can be stressful. Well, Mr. Harris, while you're waiting, I have a question for this witness, if nobody minds. Mr. Byers, or Dr. Byers, I apologize. Let me ask you this. I too have served on numerous boards over my career as an attorney, and even some as judge. My question is there a limit to how much, say, the superintendent or the treasurer could approve as far as a contract or something, or a threshold that the board would have to require?
Yes, I asked Mr. Dubs that, the evening of that August 8th, I called him and I said, is there an amount on this? Because once again, I was starting to have buyer's remorse.
Well, I'm not talking about that night specifically.
Okay.
I'm just talking about in general, is there an amount that
I
the
believe so.
Do you know what that amount is?
I want to say 17 or 18,000, I want to say, something like that.
17 or 18,000?
That they can do without board approval. Okay. That's the way it was explained to me. Yes.
But you don't remember an exact number?
No.
Okay.
Just something in that.
All right, Mr. Harris, I apologize. Any questions, sir?
Dr. Byers, you had indicated that Mr. James introduced Grandma's Gardens to the board, correct?
Correct, yes.
And do you recall Mr. James speaking after the presentation as well?
You mean after he had left and gone?
After the presentation
don't
was
recall
over
that.
regarding that?
Just that he was a friend of the district, you know, he would take care of us, he'd give us a good deal.
Okay.
You know.
And you know now that there was more of a connection between Mr. James and
Now I do.
Grandma's Gardens?
Yes.
All right. If you had known that at that board meeting, would that have caused you concern?
Sustained.
No further questions.
Mr. Hughes? Mr. Smith?
All right.
Doctor, you may step down. Excuse, thank you.
Thank you very much. Have a good day.
Let's take just a short recess.
Rise.
Back first. Okay.
Okay. Okay. You can,
Decide by striking somebody called a Casey of Grace with your hands, and you allegedly used a deadly weapon, namely a knife, during the commission of the assault. Doesn't mean you cut anybody, but by using it during the assault, it's a threat that disarms a victim and makes them more susceptible to harm. Now, found guilty, you're looking at no less than 2 no more than 20 years confinement in prison and a fine for $10,000. Do you understand?
Yes, sir.
If that were all it were, or if that was all it was, then we can move on. But this indictment alleges some other things that apparently on January 3rd of 1991, you were convicted in this court before I was the judge here, of illegal possession of a controlled substance, 2nd degree, illegal delivery of a controlled substance, 1st degree felony, burglary of a habitation, a first degree felony. On January 3rd, 1991. Then on November 8th, 1991, you were convicted in the 252nd District Court next door for aggravated assault on a peace officer. So if one or more of those were proven true, this second degree felony is bumped up one level to a first degree felony, a prior felony conviction. So if that were was actually appropriate under the law, which is the way it's alleged it is, then you're looking at first degree felony punishment, no less than 5, no more than 99 years confinement or life imprisonment and a fine up to $10,000. So, all right. So you know what you're charged with.
Yes, sir.
Who is this Acacia Grace?
My wife. This is his wife, Judge, and she was in the courtroom on the front row.
Where is she? All right. Okay. So what are we going to do on that?
Well, Judge,
is he asking for a trial?
Yes, sir.
Okay,
He's
that
asking
means
for a trial.
that means that they're working together again.
Well, Judge,
somehow,
basically, she took a course that was offered by the DA's office because she wanted to drop the charges. She took the course and still does not want to see Mr. Grace go to prison, which is the dilemma I find myself in. But
okay, no, I understand. It's not the first time. It's that kind of. But how long have y'all been married? Y'all been married?
Yes, sir.
Ceremonially?
Yes, sir.
For how long?
On 3 years.
How many?
On 3. 3, I believe.
Look, I've been married a lot longer than that, and I can't imagine calling my wife. I mean, you're supposed to love and cherish, and that's. I mean, you're two become one. It's a partnership, which means they're just as special to you as you are to yourself, and you wouldn't harm yourself, would you?
Yes, sir. Well, I take medication.
Okay.
All
right. Well, for what?
For depression, PSTD, hallucination.
PTSD.
PSTD, hallucination, maniac depression.
Who has prescribed that for you?
MHMR, that's Benadryl.
Okay. Are you taking it regularly?
Yes, sir.
Like you're supposed to?
I'm taking it not regularly.
Okay. When you were prescribed that, did this happen during the prescription?
Yes, sir.
Okay. Were you taking it properly?
I wasn't taking it properly. I was going to work and I was.
Whose fault is that?
It's my fault.
Well, that's not an excuse under law. I mean, that's why everybody would say, well, I didn't take my medicine, if I did or not. And then they go, okay, you can go home. But you got to take your medicine regularly. That's not a defense under the law. Yeah, I'm sure he told you that. Anyway, what state have to say of anything you want to add?
No, Your Honor, I offered him less than the habitual.
That's correct, Your Honor.
But he's just got so many priors, and there's a couple, I know there's at least one violent prior.
None of us want to get involved with your married life in your personal affairs, but it happens. Whatever happened caused the grand jury to indict, and then it becomes public. It's not private anymore. If you have problems you have to handle and deal with, that marital, it's not always great. Sometimes you have issues. You deal with them responsibly. You don't threaten people or strike people or hurt people, especially somebody you claim that you took an oath to love and cherish the rest of your life.
All right, sir.
All right.
I apologize. I'm asking you.
See if it's fixable. None of us like spending our time on something on love life issues, but still, you can't harm anybody, because if you're going to harm the person that you pledged to God and your Creator in your oath that you took, y'all were ceremonially married,
sir,
in a JP or in front of a priest or something. Well, it's essentially a prayer to God that you're going to treat them, cherish them, love them the rest of your life. Well, shame on you for not telling the truth. You've taken an oath. You got to follow the oath or else you get punished. Oaths are important, especially when they're oath to God. All right. There are easy times and hard times in everybody's. But you can't forget the oath you took and the promises you made. That you deal with your problems responsibly and peaceably, not harm anybody. If you harm somebody you love, what would you do to somebody you didn't like? You didn't know. See? You hurt them, we'd all be in harm's way with you if that was the way you dealt with things. Come on, that needs to get fixed. You need to act like the oath you took, sir. Okay. Do y'all need any additional time on this to an attempt to resolve this, or we're going to just set it for trial?
We could try it.
I'm going to review it too.
Medication.
You won't take this long. I'm going to give you 2 weeks to come back and tell me where this thing sits. Okay? Thank you.
Yes, sir.
Now that was Mr.
Gray.
With Jalen Hardin. Jalen Hardin, please. Also, man, here's something, whether you're married or not, he cannot contact you, nor anyone on his behalf is allowed to contact you. That's against the rules of law, even though y'all are still married, until this can be fixed. If you need to talk to anybody, though, in getting your input, you talk to the DA's office about it, about what your feelings are, so they know completely, okay? Because they're in control of whether we go forward on this case or not. And they're fair people. Whether you can shake your head all day long. I've known them. They're fair people. I know some that aren't, and these people are fair. You can shake your head all day long. I know better. I'll point out somebody's not fair. I don't stand for it. These people try to do the right thing. 25 CR 185 is called Jalen Hardin. You're Mr. Hardin?
Yes, sir.
All right. Mr. Grove is here, and your attorney, and you're charged here with this first-degree felony of aggravated robbery on or about November 10th, 2024 in Jefferson County, Texas. And if convicted, you're looking at no less than 5 nor more than 99 years confinement in prison or life imprisonment and a fine up to $10,000. But, here we go. We got a second case. This 2020 conviction of unlawful possession of a firearm by a felon out of Orange County. So if you were convicted of this first degree felony of robbery, and if it were proven true that you do have this conviction on this date before you allegedly committed this new offense, then if convicted, you're looking at no less than 15 years in prison, up to life imprisonment. Okay, so you can see where that takes you. And you're not eligible for probation if any of these were true. So you can get, I guess, technically you could get deferred or unadjudicated probation, but you can't get that in front of a jury. That would have to be in front of me and by an agreement. What do y'all want to do?
Judge, I've spoken to Mr. Hardin several times on this.
Okay.
It's a relatively simple case. It's got some one
twist to it.
Yes, sir. But basically, I believe Mr. Hardin says he wants to set for trial because he wants to go to trial on the case. It involves a vehicle that was allegedly owned by one of the two people and then allegedly sold to the other one and then back and forth and some things like that. But it is indicted as a robbery.
Well, I can see why, according to this probable cause affidavit.
Well, yes, sir. I just want to point that out. It's not just an unauthorized use type case, though, Judge.
All right. Okay. Anything else you want to put on the record about what the offer was? No. All right.
Mr. Hardin, is that correct? You want the case to go to trial?
Yes, yeah. All right. It's going to be set for trial. And we'll get this thing as soon as we can do this. This address shows West John. Is that where you live at the time? Okay. Mr. Grove is appointed on this case, correct?
Yes.
That means he's going to be trying this case. It probably would go to trial quicker if that's what you want, if you agree to release him, somebody on the trial docket wheel would be the next person on the trial docket wheel. These are not public defenders like Mr. Grove is, the public defenders, but we have a group of people who are handle indigent cases when the three public defenders are unable to carry the whole workload. And the next person on the trial docket wheel would be appointed. I don't know who that is. You don't get to pick. It's just the way it is.
Well, I'm not rushed, Your Honor, because I'm in the process of hiring.
Okay. How are you doing that when you got zero income?
Family members.
Okay. Okay. When would that be accomplished?
One of them is supposed to come speak with me sometime this week.
Okay. Okay. Who is it you're talking to?
Marvin Lewis.
Okay. Well, in the meantime, it'll be set for trial. Okay. He's going to be the attorney of record on that. And if y'all, anytime you want to hire somebody, it's fine with me because it saves the county money. That's what I'd like to do because Marvin Lewis is fine and David Grove is fine. These are good lawyers that in this court. So that's what we'll do. Okay. All right. It'll be set for trial. Thank you. All right. What's next, David?
I believe that's all the ones I have, Judge.
Okay, the other ones have been reset, right?
They were taken off prior to the time.
Okay.
Michael Keith.
John?
Michael Keith.
Oh, Michael Pete, yes, I'm sorry, Judge. That's one I'm trying to sign up right now.
Okay, get him, and then when we're ready. John, who do you have?
I have Whitney Carlon and Melvin Grant Plea.
Whitney Carlisle first, please. Thank you.
Whitney Carlisle, how is the other side of the law?
Whitney Carlisle. Whitney Carlisle.
Court cases.
Okay, what'd you say?
I said, how is the other side of the law?
Okay, so we fly into Lisbon.
I heard about that.
And it's dark. We come in at dawn, okay? Come in at dawn after flying overnight, 12 hours. And there's a bunch of people standing in the dark. They got some little lights on, but no AC. Or they got about 500 people lined up ahead of us. I go, what the heck? They go, we have a terrible event. Apparently the electricity is out for the whole country. And Spain and parts of France. Spain sends us we're working off the electric grid in Spain. And nothing catastrophic has happened.
3 years.
I go, okay, so you're giving us like 15, 20 minutes and it'll come back on? They don't know anything. But we stood there for about 3 or 4 hours. Then they told us nothing we can do. And come back tomorrow. We came back 3 days in a row before we got our bags. We were living out of what we had brought from the other country.
You didn't have electricity for any of those days, or did you?
Yeah. The electricity came on that day with a Is Raquel? Is it?
Sure.
This guy is the copy of he's supposed to like that, so we know what's happened. They gave it to me like a long time ago.
Right here, let me look at it.
We have file this to file.
Yeah, so they had some stuff that they could fix, but most of the country was out that didn't have, the airport had some additional electric power that they could, turn on the generators.
Yeah.
And so it took 4 days though before everybody was lined. There were people who stayed that didn't have any electricity. Well, then on the way home yesterday, a guy in front of me on the plane, he has an overdose of drug overdose. Well, we have four doctors on the plane, and everybody had hydrocodone on them. That they carry it around, and just because of that event. So,
just in case.
Yeah, that was coming back from Barcelona. We went to Lisbon, then Madrid, then Barcelona, and that was But it was a religious thing and it was very inspirational.
Good.
You know, I'm complaining about that, but I went on a religious retreat, you know, it's not like, okay, so you didn't have, so you know, suffered a little bit. Like, well, what are you there for? You're not supposed to be in, you know, a swimsuit, walking the beach and getting a suntan. You're there for a religious retreat, you know? No, it's hardly the suffering that our Creator ended up, our God went through, right? If you believe in that, yeah. So, you know, but you would think in 2025, you ought to have lights on a major city and air conditioning. And your baggage ought to come around within 4 days.
Any emails that you provided us in discovery, which should fall under that stipulation as well.
That's fine, yeah, I mean, anything
All
we
right.
provided you, we'll.
I want to
we'll
make
stipulate as
sure
well.
I just covered that so we don't have a hole in it later.
I would agree, the state would stipulate that any emails we've provided to you, we would stipulate that same stipulation.
Thank you, thank you.
Follow me, sir. Yes. Stay standing, face me and raise your right hand. Swear from the testimony you'll give in these proceedings to be the truth, the whole truth, nothing but the truth, so help you God. I do. See, there's water there if you need it, that's the green.
You'd please state your name for the record,
My name is Brad Connor.
and how are you employed?
Through the school or just privately?
Privately.
I own a couple funeral homes in Waynesville and Bellbrook.
All right. And you also serve on the Wayne Local School Board, is that correct?
That's correct.
You're currently a member of the school board?
I am.
And how long have you served?
I believe 12 years, somewhere in that ballpark. I finished the term of a person who resigned there in the last 6 months and then was elected, you know, in the following
All right.
terms there.
Have you ever served in different positions on the board?
I've served as either president or vice president for, I think, maybe a little over half of the time I've been on the board.
I see. And I'm going to direct your attention back to August 8th of 2022. What position you were serving at that time on the board?
Let's see, 2022, I believe I had just stepped down from president, and Dr. Byers had.
Dr. Byers was president at that time?
I believe so, yes.
All right. And do you know Ron James?
Of course.
How do you know?
Well, as the school treasurer and so forth, we build a relationship there through the process.
And he's been the treasurer there since you've been on the board?
Yes.
And-
Well, until here lately, of course.
All right. Do you know his daughter as well, Janae James?
I do.
How do you know her?
Well, I can't say I knew her well before getting on the board, but of course, I grew to, you know, I grew to know who she was as the time went on there.
All right. How would you characterize your relationship with Mr. James?
I always thought it was very positive.
Okay.
Professional, though.
And back on August 8th of 2022, do you recall a presentation by Grandma's Gardens that was presented to the board?
Was that the first date that Mr. Reinhardt came in representing Grandma's Gardens?
Yes. Do you
I know
recall
there was-
Doug Reinhardt?
Yeah, there were
coming
two
to
times
court?
that he came in, so that if August 8 is the first time, I just want to make
All
sure
right,
I'm clear
we'll start
on it.
with the first time.
Sure, yeah.
How was Mr. Reinhardt introduced to the board?
Well, I can't recall exactly how he was introduced or who he was introduced by, but he was on the agenda, so we knew that there was going to be a presentation.
Do you know whose agenda he was on?
Well, I know it now because I've seen that. I've seen the minutes not that long ago, but I wouldn't have. If you had asked me that prior to reviewing those minutes, I would have said no. But
Would it help refresh your recollection to look at the minutes?
Sure.
Okay. gonna show you what has been marked as State's Exhibit 12, if I can approach.
Yes.
Do you recognize that document?
Yes, I recognize it.
And what is it?
Well, it's the minutes of that particular meeting.
Okay. And if you could, I'd refer you to page 3 of that under the treasurer's agenda.
Sure.
Yeah, 3, and it would be the third item in that. You do have that turned?
Yeah,
All right.
I see it here.
Is it fair to say it was under the treasurer's agenda?
Treasurer's business items, correct.
And that was Grandma's Gardens?
That's correct.
Presentation? All right. Do you recall if Mr. James ever disclosed he had a conflict at that meeting?
Objection. Form.
Overruled.
Yeah, there was never any mention that there was any kind of business connection or even a personal connection for that matter between the two of them.
You don't recall anything said?
Correct, I don't recall anything said there.
Do you recall Mr. James interjecting at all during that meeting or that presentation?
Well, yeah, I remember there being some discussion about Grandma's Gardens specifically, and and really more about Doug Reinhardt being chosen, I guess you could say. That's probably not the right word, but to do the project, and because of the fact that he was a Waynesville graduate and so forth.
Okay. Do you know was anybody asking questions about that?
Questions about, you mean in contradiction to Doug Reinhardt doing it, or?
Questions about what Doug Reinhardt was doing there, or?
No, I don't recall there being any question, because the project was needed to be done, and I know myself, I know Grandma's Gardens well. I've purchased things there myself over the years, and so I was excited about the fact that he may be selected. I also remember there being a discussion about whether we needed to take it out to bid and so forth, but.
What do you mean by that, take it out to bid?
Well, usually in the school board setting, with taxpayer dollars being involved, you're supposed to get, I believe it's 3 bids, at least 3 bids, sometimes it's more, I believe, but anytime there's a project like that, and then there was a discussion about why that wasn't necessary in this case.
And did anybody answer that question?
Well, I remember it being answered. I couldn't say if it was answered by Mr. Dubs or Mr. James, but I remember the discussion being that it wasn't necessary to take it out to bid. I believe it was because of the fact that it was a lower value, a threshold that wasn't met, so we could choose.
So you believe it was one of those 2 individuals that said that?
I believe it was. Ordinarily, those were the 2 that would have had the knowledge to answer it.
Okay.
I could speculate on who I thought it was, but I'll wait and let you ask that if you want to ask. Yeah.
So Doug Reinhardt gave that presentation that day?
He did.
How would you describe the presentation?
I thought it was very positive. It was the amount seemed appropriate, and I guess the reason why my memory, I would argue, is not the greatest, but for whatever reason in that meeting, I have a lot of memory because, 1, I was excited that it was them, and 2, I built a house in 2008, and I got a proposal by Grandma's Gardens to do the whole outside, and ultimately, Grandma's Gardens they're well known for being one of the better landscape places in the Miami Valley, and so their prices were quite high, and you know how it is when you build a house, you exhaust some of those funds, and I remember not going that route, but I paid them for the blueprints and then kind of went a different direction. And so the fact that they were being presented and the value seemed similar to, but all those years ago my house was, so I thought it was a good deal, so I remember making that motion.
Anybody saying it was a good deal?
Well, yeah, I mean, quite frankly, I remember Ron suggesting that Mr. Reinhardt was doing the district a favor by lowering prices or or, you know, almost making it a donation to some degree, but
So you remember Mr. James at least speaking to that effect at the meeting?
something along that line, yes, because I remember backing that up. I specifically remember saying that I was also aware that that was a good deal because of having that personal connection there.
And from your recollection, it was just Grandma's Gardens presenting that day?
Correct.
And they're the only ones that ever presented to do this project, correct?
As far as I know, in that school board, that was certainly the case.
Nobody else came before the board to offer a bid?
That's correct.
All right. Did Mr. James ever disclose that he received $2,000 a month for the past 10 to 15 years from Grandma's Gardens?
Not to me. Yeah.
Okay. Did Mr. James ever indicate that he had office space at Grandma's Gardens?
No.
Did he ever indicate that 99% of his outside business involved Grandma's Gardens?
No.
Had you known that, would that have been a concern?
Well, yeah, I would have,
Hang on. I'm gonna sustain the objection.
Are you aware of any instance where Mr. James had wanted to give his daughter more money for ACT services?
No.
Were you aware of Ron James and Jenna James' involvement in the ACT?
You're talking about in the past, not so much now, correct?
Overruled.
Yeah, definitely not, you know, all the way up until recently.
Okay. So nothing was ever brought to the board's attention regarding payments of ACT?
Not that I recall.
All right. All right, I just have a minute. No further questions?
Mr. Smith?
Afternoon.
Afternoon.
Just a couple questions. You knew it was a good deal, in your own mind. You decided in your own judgment it was a good deal.
I would agree with that statement, yes.
Cool. So, if you knew that Ron James did tax work and bookkeeping work for Grandma's Gardens, that wouldn't have changed your mind as to whether it was a good deal or not, would it?
Possibly ethically, it would have changed my mind.
So this is about ethics.
Well, I mean, I think, that would I have voted against it? I can't answer that. But would there have been further discussion, and would there have been more I's and to dot and crosses, T's to cross? Certainly.
Did you see the work get done?
Sure.
You were satisfied with the work?
Sure.
You actually moved for it to be approved. You were the movant.
That's also my recollection, because I remember being excited about the fact that they were going to be involved. I knew it would be a positive project.
Cool. Thank you. Nothing further.
Yeah.
Any redirect?
No, Your Honor.
So you may step down your excuse. Thank you.
Sure.
State would call Doug Reinhardt.
Raise your right hand. Swear affirm the testimony you give in these proceedings to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Be seated. Still has a seal.
Thank you.
If you would please state your name for the record.
It's Douglas B. Reinhardt,
Would you please spell your last name?
R-H-I-N-E, I'm sorry, E-H-A-R-T.
Okay. And how are you employed?
I'm owner and president of Grandma's Gardens.
Okay, and how long have you been in that position?
Close to 47 years.
All right. Is this a family business?
It is.
Oh. Did you start it yourself, or was it somebody prior?
No, I did start it with the help of my parents, Pat and Jim Reinhardt.
Okay, and they're still living, correct?
They are.
Oh. Are they still involved in the business?
No, but
Okay.
they ask about it all the time, though.
All right. You are familiar with Ron James?
I am.
And how do you know him?
He was my next door neighbor about 40 years ago, and he's just a really good friend, and he's also our CPA.
Okay. 40 years ago, where did you live?
We lived on Main Street in Waynesville.
Okay.
Lived in the town butcher's house. We bought it from the original owner, so.
Awesome. Well, so did you, and that's when you met Mr. James, correct, as your
Correct.
neighbor?
Correct.
All right. And Ron James does the taxes for Grandma's Gardens, is
He
that
does.
correct?
That's correct.
And does he do your personal taxes?
He does.
Does he have the ability to sign off on tax returns as the preparer then?
He does, but I think I typically sign.
Okay. And how much do you pay him to do that?
It varies, depends on the complexity, but on the average about $1,500, $1,200 to $1,500 a year.
Okay. You also pay him $2,000 a month, is that correct?
That is correct.
And what is that for?
He's a watchdog. I've been abused by my last, the person that did our payroll, and I just had a huge loss, and Ron helped me get through that, so ever since then, I've just asked him to help me as an independent contractor or CPA and help me monthly to be my watchdog and just ensure that that doesn't happen again.
Mm-hmm. Does he come in regularly to Grandma's Gardens?
Typically on Saturdays when there's no one else in the bookkeeper's office, yes.
Okay. And he has an office there he uses?
Just the bookkeeper's office. We don't have any extra offices, but
And who is your bookkeeper?
that would be Lori Giannis.
All right. Does Mr. James look over those books then?
He does.
You described him as a watchdog. Is that right?
Yes, we have like a 3-part system. I approve the invoices that Lori pulls for me, and then Ron writes he prints the checks for us.
Okay.
He also does our CAT taxes, prepares those, and our sales tax, and that type of thing.
I see. Also, did he get involved in some of the consulting for you as well?
Yeah, I pay him like when my daughter and my son decided that they wanted to come on board with our company. I asked him to help me with that and how kind of create a, I don't know, structure or a shell of what their job title would be and what their expectations would be. And yes, he helped me with that.
Did he help you, give you ideas on advertising and things of ways to save money?
Well, my neighbor came to me and wanted to sell us some land that we desperately needed about 20 years ago, but we did not have the resources to do that. So I told Ron that. I said, geez, I sure would love to buy that, but I don't have the resources. And he goes, well, if I can help you figure out a way to adjust your expenses that you could afford the monthly payments, I think you should do it. So we sat down and...
Was he able to do that?
He was.
What did you do differently based on his consultation?
Well, 20 years ago, we were doing a lot of TV and television advertising, and we were spending close to $130,000 a year on advertising. And he told me about this thing called social media and me being, I don't know, I just wasn't that familiar with it at the time. He said, we need to get you a website, and he goes, I think you could cut out half or 2/3 of your advertising if you went to social media.
Mm-hmm.
So anyway, I said I was all ears, but I said, I can't cut it a half. If I cut it half, my business will, it'll go away. And he goes, trust me, I think this is going to work.
Mm-hmm.
And it did.
And that worked out for you?
It did. It came up with the extra money that I needed to make the payments on the property then.
How long has he been consulting with you and?
Well, probably at least 15 years or so,
All
15 to 20 years.
And you've been paying him regularly $2,000 to do that?
At
is
least
that right?
10 years I've been paying him
At least 10, but possibly 15?
It could be, yes.
Okay. The checks from Grandma's Gardens, does Mr. James have access to those?
He has access to the checks,
Okay.
correct, yes.
Does he cut the checks for Grandma's
He
Gardens?
does.
Including for himself?
He does. It's
And
approved by me each week, so.
All right.
And they're not actually go through Grandma's Gardens, that goes through our partnership.
What is that?
We have a partnership called Landscape Creations. My father's attorney suggested that it would be safer if we kept the business, the real estate separate from the name, just in case someone would sue us. If something catastrophic happened, we wouldn't lose the real estate because or hopefully it wouldn't be a loss.
How long has that been separated?
Ever since the beginning, my parents were partners with me. They helped my wife and I buy the first 4 acres that we had in 1979, and
I see.
so the attorney suggested we have a separate company name for that.
Okay.
So, I do have to clarify one thing. Grandma's Gardens does write the check to Ron. It isn't Landscape Creations. I apologize.
Okay. Well, I'm going to show you what is marked as State's Exhibit 25. If I can approach.
Yeah.
Do you recognize those documents? It's a group.
Sure.
And what is it?
That's Ron's monthly check for,
There's a copy of it there on one. I think there's a number of them, and
They should be all the same except for when he's doing extra projects for me, and then I would pay him.
okay. So sometimes he does extra projects for you.
Well, just like I referred to, like my children when they came on board. Just like I mentioned with that property, for instance. Ron would never ask for money, but I would pay him just because he told me I didn't know him anything for those things. He just wanted to help me, but it really made a big difference in my company. So,
So you
anyway.
gave him some extra money for extra projects that he was doing for Grandma's Garden.
That's correct.
I noticed on the checks, maybe on the left side, a little up, his name is on the checks as CPA, is that correct?
That's correct.
Is that a permanent labeling there?
As far as I know, yes, because he is a CPA.
Okay. But I mean, so he has access to the checking account?
He does. He writes the checks for us. He is the last person that touches the checks before Lori actually mails them.
Okay. And I noticed most of those checks are signed, it looks like yourself, and there may be another Reinhardt there, is that right?
Yes.
Is that a electronic signature?
I have a stamp available also. A lot of these look like the stamp.
Do you authorize Mr. James to stamp your signature?
Absolutely.
Okay. And you've gone through, and actually you provided copies of those checks at the request of the state auditor, is that correct?
That's correct.
And those are all kept in the ordinary course of business?
Absolutely.
When you had that request, did you ask Ron to recover these documents for you?
No, I did not. Lori was able to do that, I believe, our
Okay.
bookkeeper.
All right. I noticed some of the checks, and I may know the answer, and you may have already answered this, but they're not all for $2,000. You said there were special projects. I believe there's one in there for $1,000, one in there for $1,500. There's another check for $4,000, and just to be, that $4,000 check incorrect, I guess, are you aware of that?
Yes.
And what was that for?
I don't recall. Is it in this list here?
It is, and I
Let me
think-
see what date it is on that bill to help you.
And it might be 2 pays.
That could have happened too, because sometimes if our funds might have been a little light, Ron he's that kind of a guy. He'll say, hey, I'm just gonna wait and do it the next month.
I think it at least happened once then.
It might have happened more than once.
Okay.
There's times of the year where we have a tremendous amount of cash going out and very little coming in, and that's typically in the winter months, so I could see him doing that.
Okay. Do you notice that $4,000 one?
Yep, I see it.
I think it's in the memo file or something about that.
Services for April and May, yep.
Okay, all right. And I noticed there was another Reinhardt signature on there. I couldn't make out. Is it typed?
So this is one that I hand wrote to him for $4,000.
Okay.
And that,
That
instead of
is-
using a stamp that's also available to Ron
Right.
and to others, I hand wrote that.
Okay.
That's why it looks different.
Is there anybody else at the business that can sign checks?
The only other person would be our bookkeeper, Lori.
Okay. All right. Now, you've done work for Wayne Local Schools, correct?
Correct.
How often, I guess, how far back does that go?
My earliest recollection would probably be around 2000.
Okay.
I think that's approximately when Ron James became the treasurer of the school system.
Okay.
And, yeah,
How many projects would you say you've done for Wayne Local Schools?
probably only 2 major projects, and then the rest would be projects that would be under $4,000.
Okay. And under $4,000 projects, how many do you think you've done of those?
I sent those to the auditor also, probably maybe 10 or so.
Okay. And when you receive payment for your services at Wayne Local Schools, Ron being the treasurer, I'm assuming the checks that come to you are signed by Ron. Is that correct?
You know, I would assume so, but Lori would have taken the checks to the bank, so I would not have looked at that.
All right. Now, you were present at a board meeting on August 8th of 2022, giving a presentation for Grandma's Gardens, correct?
That's correct.
Is this a job you sought out?
Not really.
Why do you say that?
Well, I was super busy that year. I mean, ever since COVID, landscapers and garden centers have been really, really busy. And I just had a lot of work going on at the time. So, no, I didn't really seek it out, to be honest.
Okay. How'd you find out about the job?
I got a speaker phone call from the construction site or trailer at the, I think they call it the events center.
Mhm.
And it was Pat Dubs, at the time, the superintendent. Yeah, everybody told me who was there. It was Pat Dubs. I know Ron James was there. The project superintendent, Jason from Broomba, and Eddie, the architect, was there. So I was on, it was the weirdest thing, because it was, I don't usually get these, but it was a group of men on a voice, or a speakerphone, that called me.
Okay. Does the name Eddie Howlett ring a bell?
Yeah.
All right. Was he one of those people?
Yes, I believe so.
All right. And I'm going to show you what I marked as State's Exhibit 23.
Yep.
You recognize that?
To Doug Reinhardt, and 2 attachments. Yes, I do.
And what is it?
I believe it's the from the architect, it's the prints for the event center, and then their landscape plans, and the sidewalk layout, it says.
Well, that's a one page, correct?
Civil plans, 3 attachments. I think it was all on one sheet, but I don't really recall.
Do you see the statement in there? Give me a call.
Yes.
Doug, give me a call. Is it fair to say that email transmission was from Ron James, correct? It says from Ron James to Doug Reinhardt.
Let's see, from Ron James, yep.
All right. Is that around the time that you were contacted to do this job?
No, actually, it was, I think that's approximate. I was thinking they called me in either May or June, I can't recall.
Okay, and that email is from June, correct?
Yes, it's from the 21st.
Okay. So is it fair to say that that might be the communication?
Well, it might be, but when they called me originally, I don't know that they necessarily had the prints. So maybe Ron was the one that actually sent them to me, or Eddie sent them to Ron, and I am not sure.
All right, this may clear this up. I'm going to show you what I marked for State's Exhibit 24. You recognize that?
Sorry, guys. I do.
And what is it?
It, it looks like, I mean, I'd almost have to read it word for word to tell you what it is, but it looks like, it was just communication I had with, Jason Miller and looks like Ron copied to Jason about where we needed sleeves for underneath the sidewalk. And, I mentioned that I could get the stones for them, from the quarry. And I just want to make sure they were going to put sleeves underneath the concrete.
All right, and this is the job for the Performing Arts Center, is
That's
that
correct.
right? And that particular communication was in July?
It's July the 8th.
All right, so there were talks about doing this job before the board meeting, correct?
That's correct, and to be honest with you, even if I get a job or I don't get a job, when we're doing new construction, I always ask the concrete contractor to put pipes under, because it's impossible to do that later. So even if I didn't get awarded the job, I wanted to make sure that the contractor didn't forget to do that.
I see.
Because you have to run downspout pipes for drainage underneath those things. I just want to make sure whoever did it had access to those pipes.
I see. But your involvement in that, though, the prospect of getting this job to do the landscaping there was on the table, is that fair to say?
Correct. I had not presented a design yet to the board. I did not know, I hadn't even done the design. I didn't know if I had the project.
Had you ever presented a project to the board?
I did. It was probably in 2000. I believe I did that.
The first time you ever?
First time I ever did anything, correct.
I see. And since that time, from 2000 to 22 years?
Everything I did was pretty small, so I don't know that, basically Pat Dubs or whoever, like sometimes Tom Isaacs before that, they would contact me and say, hey, we're having a big alumni event. Can you, I know we should have called you a month ago, but can you send a crew down here and remulch and trim and make things look good? So those are the guys that typically contacted me.
But is it fair to say Ron James contacted you as well?
Sure, they were usually together. We walked the property together with superintendent and Ron. We did that on a pretty regular basis when we did some of those small projects.
Okay.
It'd be like, hey, could you put orange flowers over here? Because those are our colors. And,
I see.
And Tom Isaacs would say, hey, that really would look great there.
Just out of curiosity, did you go to Waynesville High School?
I did not.
I didn't think so.
No.
Did you know where Ron James went?
I did.
Where was that?
He went to the same high school. And he went to Wayne local schools.
He went to Wayne local schools?
I was aware of that, yeah.
Okay, all right.
Yeah, he has a passion for the school. He loved it, and
So you gave the presentation on August 8th of 2022. Do you recall how you were introduced to the board?
I believe it was the superintendent that introduced me, and he actually had my pictures accumulated of my landscape design and all the photographs of the plants I wanted to use. Because I wanted to use something more special than what they had on the original design, and so they had a monitor much like you have on the wall.
You said you believe it was the superintendent. Wasn't there a disclaimer given by Ron James at this meeting?
That's correct. That was after I was introduced. I think it's as I recall, the superintendent called out all the events of the evening, and once he called it out, then I believe that's when Ron may have done a disclaimer at that point.
Okay, what is your recollection of that disclaimer?
Basically, what I recall is Ron mentioned that much of the board knows that we are friends. We've known each other, and we're acquaintances. So he didn't want there to be any conflict of interest or whatever. He wanted to have everything on the table. He wanted to make sure the 5 board members decided if they wanted to do this project or not. He didn't care one way or the other. He told them I would be highly qualified to do it because I do a lot of high-end residential landscaping, but he just wanted them to be the ones that made that decision.
Okay. And did he interject during the meeting or any questions asked?
No, not that I recall.
All right. And this particular presentation had visual aids, I guess there's a PowerPoint presentation.
Correct.
Is that something that you designed?
No.
Who did it?
It was, typically what I've heard is it was the superintendent that put it together or someone on his staff. He asked me for the photos that I might want to put on the, he being the, Mr. Dubs, asked me what photos I might want to interject on there.
Okay.
So I sent him photographs of the plants, like the knockout or the carpet roses I was going to use, and because I used a lot of plants that had lots of color for the children. I wanted to have it be more like a sensory garden when they were waiting to see a performance instead of the row of bushes that they originally had on the original design. So I had that, and then they also, I had an email version of the design, and I believe they put that on the screen as well.
Okay.
But I also
Which
had...
you provided those pictures, did you?
Correct. I provided the pictures to the superintendent, and he put together like a PowerPoint
Okay.
or something like that, as I recall.
All right. On States Exhibit 23 and 24, just to back up just briefly, was Mr. Dubs on that email chain at all? Those were the emails?
Nope, I just see Jason Miller and Ron James,
Okay.
and then Eddie on this other one.
And at the presentation, you got the job, correct?
Yes, so they took a vote that day, and all 5 said yay, and I was surprised.
Why were you surprised?
Typically, when you're in a school board, you'd expect maybe one person to just have some reason to say no.
And you said nobody did.
No, they were all very enthusiastic about it,
Were you the only one bidding for this job?
as far as I know, but I'm not aware, so.
All right. And during the course of this job, you had to do some additional work, did you not?
I did.
And what was that?
The list is long, but the school asked me to move some trees that I planted. They were too tall. They asked me to take those back to Grandma's, bring some shorter trees, because they had just installed some cameras. And so I did that. We started laying out these intricate stone slab walls, which involve each stone. There's 120 stones. And each stone I have to cut with a gas-powered saw 4 times so they fit together real crisply. That's what I'm kind of known for when I do high-end work is they don't want big joints, they want it perfect. So I started laying those out along those curving sidewalks, and I believe it was the assistant principal came out, said I was making too much noise. And so he said, you can't cut those during the day. You can come back on the weekend and do it, or after hours, but that would be a time and a half. That would be just, anyway. So I said, can I take them out into the field and make a pattern in the field, cut each individual stone, mark them, and then can I bring them back and lay them? He goes, yes, you can do that during the day.
So that's what you did?
That's what I did.
Did you also suggest an irrigation system?
Actually, it was Superintendent Danny McLeod that suggested that. He was the last yay in the approval process. And he said, once everybody said, I can't remember who says that, okay, it's been approved, but Danny said, I would like to add that I think we should get an irrigation system, or this beautiful design will never look perfect. Danny is in charge of all the maintenance at Kettering Hospital system, and he understands, the importance of keeping irrigation and water on the plants.
I see. Does he have a relationship with Ron James?
Yeah, I think they've been friends, yeah.
Do you know for how long?
Don't know that.
Okay. And the irrigation system, did that get put in when when your design was installed?
So I could not get an answer from the architect on where we could tie in an irrigation system. I had a couple companies willing to give bids, but no one could do anything quickly. And I had to get the plants in right away because they were trying to have a grand opening for this. So what I ended up having to do is put temporary drip tubing through all the plantings, and that'll last 5 to 10 years. And then I put temporary timers on the hose bibs that I could find, and that way I was able to water majority of the planting. And then we had to put tree bags on the other trees, and there was no one to water anything for about 6 weeks, so I had to pay my guys to constantly come and water, because it was one of those falls where we were in drought.
And you had to charge for that extra service, did you not?
I did.
And it was it fair to say it was over a couple $1,000s?
It was about $3,200, as I recall.
I see. And then, when you got the job, I'm gonna show you what I marked as State's Exhibit 26. I think it's written in here, original quotation for event center with approach. Do you recognize that document?
I do, and it's dated on the 1st of August, not the 8th. After my wife and I talked about this more, I decided to make my discount greater, and I came up with a 36% discount, which instead of being, if you notice on the bottom, it was $12,000, I decided to go almost $14,000.
Okay. Was there any reason for that?
Yeah, because I figured it's going to be the last project that we do. I wanted it to be really just awesome, and God has blessed us. We've just had a lot of work from, like I mentioned, from COVID on, and we just thought, hey, this is going to be the last project we'll probably do at this school. And my wife and I love to go to the Schuster Center, and I don't know if any of you guys have seen this event center, but it looks like a miniature Schuster Center. It's just gorgeous.
Yeah.
So I wanted to make the landscape a little more special, and I just decided to discount a little bit more at the last minute.
Okay. Did you have any conversation other with your wife about discounting further?
I don't recall doing that, no.
Were you aware that there's some type of limitations of whether you had to get board approval by the dollar amount?
I'm not aware.
Okay. Did you hear Ron James tell the board that at any point during the course of that meeting?
The only thing that I heard him say was, whatever this amount was, it was underneath a threshold, but I don't know what the threshold was.
And did he say that to the board?
I remember him saying that, yes.
Okay. You did the job at the event center. I think there was a notation in some of those that you were very pleased with the work. Is that correct?
Yeah, I like the end result. I thought it looks so much nicer than what the architect's design was.
In that additional irrigation system, that's possibly, I think, in some of the pages.
Yes, it is.
After that, as the amount
Yes.
as well. Now, you came to the board again at some point, correct?
I did.
And why did you do that?
I wanted to discuss with them Christmas pots that I could do by the entrance. I thought we could put a couple pots by the front entrance of, we do this at Grandma's, we basically take a pretty pot and then we can put a plastic insert inside that has Christmas in it, like greens and things. I thought that would be really attractive to do, and I wasn't sure if they would like that or not, so I thought I would ask that, so.
Was that the only thing you discussed?
It was not.
And what else did you discuss?
Just my disappointment with a Facebook posting from one of the board members.
Okay, what was that about?
I can't remember the exact wording. I think you have a copy of it, but something about 5 for 5. It was with Dr. Byers smoking a large cigar, holding a wine glass and a bottle of wine on the table. And he was like, okay, I finally got rid of him.
And who did you think he was referring to?
Ron James.
Okay, and you were upset about that?
I thought it was pretty unprofessional, especially knowing the children that school would see that too. It really did make me angry.
Yeah, and
Disappointed.
right, and it's fair to say Ron James was a good friend of yours, a longtime friend.
Sure.
And you were upset that he resigned. Is that correct?
No, I was not upset.
Okay. then, did you believe he was being treated fairly?
I didn't, no, I don't think so. When I saw that, that was just, seemed like that was about the rudest thing that I've ever seen a board member do to someone that spent over 20 years. Ron was like the original Doge at Waynesville, and he was all about for community and kids, and to do something like that, I just thought it was disgusting, and just really, really cut to my core.
Okay. Just have a moment. Did Mr. James disclose that he was a contracted employee of Grandma's Gardens?
With who? I'm sorry.
With Grandma's Gardens?
I'm sorry, I don't understand the question.
Did he disclose that he was a contracted employee with Grandma's Gardens at that
Objection to the form, contracted employee, are ambiguous.
Pick one.
Did Ron James disclose that he was contracted by Grandma's Gardens to do work?
I don't understand the question.
He wants to know if at that board meeting,
Oh.
Mr. James disclosed to the board whether he was paid stipends or whatever you want to call it
Understand.
by Grandma's Gardens.
That I don't know. I don't remember that.
Oh, yeah. You had indicated to the board that this was the last project that you were going to do for them when you came to the board at the final time, is that right?
I don't recall actually saying that. In my mind, I figured this would be my last project.
And why is that?
Because Ron probably wouldn't be around. I knew his contract was coming to an end, and I got to landscape the original high school, and then I got to do their last project, and I really wasn't interested in doing anything else with, I guess, other folks.
So the reason why you were doing work for the school is because of Ron James?
Basically, yeah, Ron would tug on a lot of contractors' heartstrings to help the community and help kids, and so that's basically, with Ron out of the picture, I don't think there'd be anyone else there to tug on my strings, maybe.
Okay. Thank you. No further questions.
Cross.
Afternoon, Mr. Reinhardt.
Good afternoon.
You have those exhibits in front of you,
Yes.
23 and 24. You'll see that the 23 is dated from Ron James to you of 6/21/22. Is that right?
Correct.
And it had 3 attachments. Civil plans, Waynesville Sports Center sidewalk, landscape plans, Waynesville Sports Center sidewalk. And I guess the other one's not really described. It says 3 attachments, right?
Landscape plans. Yeah.
Now, that date happens to be one day after an exhibit we've already had marked and had testimony about,
Okay.
that there was a construction meeting on June 20th, the day before that 21st email to you by Ron, which listed your phone number. It said, district contact for landscaping, Stoke, Doug Reinhardt, your phone number. You remember getting a call from all these gentlemen sitting in a construction meeting, right?
I did.
And the purpose of that call was to see if you would agree to do something to help them with a problem they had, right?
That's correct.
So it wasn't just Ron, it was Superintendent Dubs, a contractor, I think Jason was his first
Yeah.
name, from Broomball.
Correct.
Eddie, who was the construction manager for the architect, right?
Correct.
And so the request was, would you be interested And so what did you tell them that day?
I'm sure I paused for a minute and said I knew how to do that kind of work, and, but I said I would look at it, so.
Okay. And so plaintiffs, or State's Exhibit 23 is Ron sending you the information, follow-up on what happened the day before when you perhaps reluctantly said, I'll take a look.
That's correct.
And then Exhibit 24 is a couple weeks later where you are going to meet with Jason, it's McMiller, Jason McMiller, and he is Broomball Construction, the contractor for the event center. Is that right?
Yes.
And you did have that meeting eventually.
Yep.
And that was it, another gathering of information so you could prepare a presentation.
Correct.
Is that right?
That's correct.
Now, Ron James, you've described your relationship, but we can agree that Ron was not your employee. In other words, he didn't get paid with taxes withheld and all that, right?
Nope.
He did not have an ownership in either Grandma's Gardens or the partnership that owns the real estate. Is that correct?
That's correct.
He had no entitlement, nor did he ever receive any profit distributions of your companies. Isn't that fair?
That's fair.
That if you wanted to terminate him, all you had to do is tell him, don't come back,
Correct.
right? So there's no written contracts of employment or of any professional relationship other than you guys basically having a verbal agreement.
That's correct.
All right. And tell the court, you had children that went to Waynesville, didn't you?
I did, yes.
How many graduated from there?
Well, my son graduated. My daughter started there, but she transferred to a Christian school early on. She was struggling, but my son just had a wonderful experience in Waynesville, and so that was another reason. He was proud of us, helping, his dad's company, his family's company, helping around the school also, and
Okay.
so yeah, we gladly gave and gave. So
Did you make a profit on this job?
no, good job. 10% would be a great profit, and like I mentioned from the beginning, I gave a 36% discount on the project.
So I don't think I'm going out on a limb when I say you didn't give Ron James one red cent for speaking up for you.
No.
Say he does a good job, he's a good, he'll do a good job. He didn't get one red cent from you from getting this job, did he?
No.
Matter of fact, you lost money.
Yeah, lost money.
But that was out of the goodness of your heart.
Exactly. My wife and I didn't care about that. We just, again, we felt blessed, and we wanted to put our look on we just wanted to make that event center look really special. So that's what we did.
That's all I have, Your Honor.
Mr. Hughes? Any redirect?
No further questions.
Mr. Reinhardt, thank you for your time. Your excuse, sir.
Thank you.
It's probably a good place to stop. We have one more witness, which is the investigator. I know she's gonna take a little while because there's interviews.
More than 10 minutes?
Okay, yeah, definitely.
All right. I wouldn't mind going later tonight, except I do have to go to the Project Search graduation ceremony in about an hour and a half or so. So let's go ahead and break for the night. I have a docket in the morning. Kevin, did you get on there?
I'm at 8:30, yes. I think I am too, Judge.
All right, you're Mr. Baker?
Maurice Baker.
Yeah. Yeah, okay, and then you have a plea?
Yes.
All right, so I have now 5 things at 8:30, so let's say 9 o'clock. Does that seem good?
Yes, sir.
All right, I'll see everybody back here then.
Thank you, Your Honor.